Good morning, everybody. The time is 9:03. My name is Christian Waugh, and I hereby bring this October Citrus County Code Compliance hearing to order. Now, at these hearings, we generally follow an agenda. It has been made available, and maybe you have a copy, maybe you don't, but the first item on the agenda is the call to order. We just did that. The second item on the agenda is the pledge to the flag, so I'd like to ask if you join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. Good morning.
If a person decides to appeal any decision made by the code compliance special master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is approving the minutes from the Wednesday, September 20th, 2023 hearing. My understanding is that the minutes have already been signed by the alternate special master, but since it's on the agenda, I'll ask if there are any objections or proposed modifications to the minutes as currently formulated. All right, hearing none, they're accepted.
Staff update, abated and continued cases are listed out front.
All right, ladies and gentlemen, I'm going to give a brief statement on this hearing and how I expect it to run and how it's going to work. Again, my name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but all it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to each of your hearings, so I'd appreciate it if you'd pay close attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case first. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case. At any time during the hearing, I may have questions of the parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is non-limited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony should remain civil, and you must not interrupt other witnesses, parties, or attorneys, hopefully including me. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate or fix the violation by that date, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage everyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all my orders as standard provisions. If you bring your property back into compliance with the code during the time that I permit, the costs will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Although it has only happened a very few times in my years as a special master, I may continue your case if I find the need for further evidence or argument. Are there any appeals of orders? All right. You do have the right to appeal any order that I make today. Thank you very much.
First case is on today's agenda. Vanawa Holding Corp. Incorporated, case number is 2023-00117, and case number 2023-00467, case number 2023-00560. Code Officer Alan Jonason, expert on the case, Land Development Director Joanna Coutu.
And what page is on the agenda?
Pages 42, 43, and 44.
Okay, thanks.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Good morning.
Good morning.
And sir?
Oh,
Good morning, Attorney Leon Boyge on behalf of the Van
How do I spell your name, sir?
Boyajan.
Thank you.
Good morning. So there are 3 separate cases on the property. I'd like to present each individually,
Okay.
if that's okay.
Yeah, okay.
Okay, absolutely. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-00117, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address of the violation is 6101 East Turkey Trail Drive, Hernando, Florida. Property owner is Vanawa Holding Corporation Incorporated. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 11 September 2023. Photos taken during a compliance inspection on 21 September 2023. Overhead photos taken from the property appraiser website showing structures on the property from 6 June 2023. And photos from my final inspection conducted on 17 October 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the signed certified mail receipt from the LLC, a copy of the SunBiz, and a copy of the property appraisal.
Okay.
Exhibit C, photos taken from my initial inspection from the previous owner. This property's had two property owners. From 30 May 2023, a copy of the SunBiz from the first property owner, a copy of the NOV, and a copy of the signed certified mail receipt from the first property owner. This is important to note to establish knowledge of the violations before the property transferred ownership.
Okay. We'll get into that. Sir, what I'd like to ask you to do is to look at these documents and let me know if you have any objection to them being evidence in this hearing.
Sure.
And sir, I assume that you're an attorney for Vanawa Holding Corp.
Right.
Inc. Okay. I would, of course, ask everyone to please silence their cell phones, iPads. That's okay. We'll survive.
Okay. What was sent? What was sent? Okay. I don't have any objections.
Okay. Without objection, what's been proposed as exhibits A, B, and C are evidence. Please continue.
On 11 September 2023, I conducted an initial inspection after finding out that the property had changed ownership and observed the property to remain in violation. On 11 September 2023, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance mentioned earlier. On 21 September 2023, a compliance inspection was conducted with no change to the property. I have had brief contact with a property owner or a representative. As of my final inspection on 17 October 2023, the property remains in violation. Land Director Joanna Coutu, Land Development Director.
All right, thank you.
Good morning.
Good morning.
This is a property, it's CLMH, Low Intensity Coastal and Lakes with Mobile Homes Allowed. It's about 2.6 acres in size, and it should be vacant. We have no applications for this site.
Okay. How did this case start? I mean, I guess I'm trying to get to
received a complaint.
the relevance of the initial investigation.
Right, we
and prior
received,
owner.
we received an initial complaint from a citizen.
Okay. And so all three of these cases basically began with an investigation back in
Absolutely.
May.
Yes, sir.
All right, let me just take a look through what we've got here. Okay. Okay, I think I understand. All right, so sir, what's going on here?
Okay, so my client is developing this property as a hemp farm. He has received all state, federal, EPA, DEA approval. He has applied for agricultural notification. That was denied. There's a value adjustment board hearing tomorrow on that issue. Assuming that's granted, everything would be in compliance. The only issue is the height of the fence. I provided the county attorney with information on the state and federal requirements for fence height. So we would ask. Secondly, we basically got, the notice was dated September 11th. We got it September 21st, the same day it was supposed to be done. So we had no time to even comply with it. So we would ask that this, be continued to the next hearing. We have our hearing tomorrow morning. Assuming that goes the way we expect, everything will be in compliance except the fence height, and I think that would be dealt with on the federal law that supersedes state law.
What federal law supersedes the county law on
Well, the
fence-
DEA requires certain fencing height in order to prevent people entering,
Okay,
animals entering.
but does the DA, is there a federal law that says you don't need to pull a permit from the local governmental authority to? Are you aware of any law that says that?
No, I'm just indicating that the fence height issue may.
Fence height. Oh, I got you. All right. Now, I haven't even heard that case yet, so I think
Oh,
we're
I'm
just
sorry. Oh, the building.
Yeah,
I was
they're-
dealing with all three of
fair
them.
enough. So
Sorry.
they're going to present that individually. We'll get to it.
Okay.
But I want to also make sure I understand what you're saying about this case. So, are you saying that there's any federal law that preempts Section 3102A, or that if you prevail at the VAB tomorrow, that this violation goes away?
Yes. I mean, not federal law. It's just that it'll be determined to be agriculture as of 2022.
Okay. But if it's determined as agriculture, well, let me just turn to the county, Ms.
I don't-
Coutu. Is it your understanding that if this is determined to be an agricultural use of some kind, that this violation goes away?
No, there is a process to go through for that. If you get an ag classification and a building is related to it and you want exempt from permitting, there's a form you fill out. It's in statutes, and you apply for that, explain that you have the ag class and it's related, and that goes through that process.
They become eligible to do that.
They are eligible to
Right.
apply for that if it's related to it, yes.
Okay. So you're saying if they do prevail, I mean, so you're would it be accurate to say that you would be half in agreement that they may become eligible after tomorrow's hearing to apply for that?
To,
Not that they'll necessarily be entitled to it.
right, or that it's already there.
Correct. Okay.
Yes, they could apply for it if they obtain an ag classification after the fact, but they still have to apply for it, et cetera.
I understand. Okay. Is that your understanding as well?
Yes.
It's an interesting ask. I'm going to defer ruling on this one then until we get to the next case. In other words, there's a motion to continue to the next hearing. it sounds conceivable that if they're eligible, they may be able to abate it if they apply. I don't know yet, but I don't want to rule on that till we hear the next case.
Okay. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-00467, Chapter 4, Development Applications, a violation of Chapter 4, Section 4002 of the Citrus County Development Code. The address of the violation is 6101 East Turkey Trail Drive, Hernando, Florida. Property owner is Vanawa Holding Corp. Incorporated. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection from the new property owner on 11 September 2023. Photos taken during a compliance inspection on 21 September 2023. Photos from my final inspection on 17 October 2023. And aerial photos taken from the property appraiser website showing the property from 25 September 2022 and 6 June 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the property appraisal, a copy of the SunBiz, and a copy of the signed certified mail receipt from the LLC. Exhibit C, photos taken from my initial inspection on 30 May 2023 of the property from the first property owner, as well as a copy of the SunBiz, a copy of the NOV, and a signed certified mail receipt of the NOV from the first property owner. Again, this is important to note to establish knowledge of the violations before the property transferred ownership.
Are these substantively the same photos, or are they different?
Different.
Okay, all right. And so again, I'd like to ask
Yeah,
you to take a
sure.
look at these. Are there members of the public who want to be heard on these cases? Okay, I see some hands. Thank you.
No objection.
Okay, thanks. Thanks. Without objection, what's been proposed as exhibits A, B, and C are admitted as evidence.
I conducted my initial inspection after an ownership change on 11 September 2023 for site modification without permit. The property was found to be in violation of the above ordinances due to not having any permits issued before the removal of trees from the lot. The aerial photos show the trees were removed sometime after 25 September 2022. I have had brief contact with the property owner, and as of my final inspection on 17 October 2023, no permits have been applied for or issued. Land Development Director Joanna Katu.
Okay.
And my comments are similar, same lot, trees removed, no applications for development.
Okay. And also, I'll put this on the record. I know you want to present them individually. Part of the reason I don't want the public to have to come up 3 times on each case. So I'll probably ask for presentation of each case before I ask for the public to speak on them.
Absolutely.
All right, so sir, what about
It's
this case?
basically the same argument I've made. The violation was dated September 11th. We received it September 21st. It was supposed to be corrected by September 21st. Again, if we prevail tomorrow, you can either apply for a late permit or it may be not needed, so.
I don't know if
again,
that's true for this one. This is an irreparable, I don't know if it's irreparable harm or not, but it's,
If found guilty, yes, you're correct. There's not after the fact tree removal permits available.
in other words, you can't undo a tree removal. Like, once they're cut down and removed, they're removed. So it's, I don't think whatever happens tomorrow will make a difference on that. And just so you know, normally what I would do on the prior case is give you an amount of time, something like 90 days or something like that. Gives you enough time to have the hearing, go through the application process. I don't know how long it takes with the county. do you think 90 days would be enough time for them to, assuming they prevail, they may not prevail tomorrow, but if they did.
Right. If they did, that particular form is a pretty quick review.
Okay, all right. And then if it doesn't come into compliance, then there's a daily fine. So that's the way I'm leaning, just so you know.
I understand.
I'd like to hear what the third case is.
Yes, sir. This is case number 2023-00560, Citrus County Land Development Code 3150B. Fences, hedges, and walls. Fences and walls may be permitted along property lines outside of required easements. No fence or wall in a residential district shall exceed 6 feet in height. Address of the violation is 6101 East Turkey Trail Drive, Hernando, Florida. Property owner is Vanawa Holding Corp. Incorporated. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection from 26 July 2023 to establish height of the fence. Photos from initial inspection after the ownership change on 11 September 2023. Photos from a compliance inspection on 21 September 2023. And photos of my final inspection conducted on 17 October 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the signed certified mail receipt from the LLC, a copy of the property appraisal, and a copy of the SunBiz. Exhibit C, photos taken from my initial inspection on 26 July 2023 from the original property owner, a copy of the SunBiz from the first property owner, a copy of the NOV sent to the original property owner, and a signed certified mail receipt of the NOV from the first property owner. Again, this is important to note to establish knowledge of the violations before the property transferred ownership.
Sir, you know the routine. I'd just like to ask you to take a look at these documents. All right.
I have no objection.
Lori, do you guys know if Osmond's going to be here? Okay.
No objection.
All right.
Yeah, it's fine.
Strap yourself in. Okay. All right.
Special Master, while they are looking at the pictures, if the value adjustment special master hearing is tomorrow, the special magistrate hearing, whatever recommendations that special magistrate makes would then need to go before the value adjustment board at their next meeting before that would ever be approved, because those are just recommendations by the magistrate. I didn't know whether
Okay.
the special master was aware of that.
I'm not aware of that. Thank you.
Do you have any questions?
If Mr. Bojan might disagree with me, but I don't think so.
In other words, it's your representation that it's just a special magistrate making recommendations tomorrow?
Yes, sir.
And the VAB isn't necessarily bound by those recommendations?
Correct.
Okay. Do we know how much time there is between tomorrow and when the VAB would take up those recommendations?
I tried to look on their schedule and I don't see where the Value Adjustment Board is scheduled to meet, but the Value Adjustment Board is made up of some members of the County Commission along with other members. So
Wow.
I don't see it on the Board of County Commissioners calendar yet, so I'm not sure when that hearing would be.
Thank you. Without objection, what's been proposed as Exhibits A, B, and C are admitted as evidence. Go ahead.
On 7 September 2023, I conducted an initial inspection and observed the property remain in violation. The fence was measured with a 6-foot-long board and the fence exceeded 6 feet in length. It's roughly 8 feet in height. On 7 September 2023, a notice of violation was issued for fence exceeding 6 feet in height, which is a violation of the ordinance mentioned earlier. As of my final inspection on 17 October 2023, the property remains in violation.
Well, so this one I am concerned about. You're saying that there's a federal law that says fences have to be a certain height for
Yeah.
this kind of an operation?
Right.
Do you know what that law that is?
So the information you provided me cites 193, but that's a state statute, and 581, that's a state statute. I don't actually see any federal statutes on this. He had provided me.
Are either of those relevant in your opinion?
No, I was looking at it while we were sitting here, and I don't see a height for a fence recommendation on any of that. And then on the documentation he provided me, it says a fence on the roadside could be 6 to 8 feet. So it gives a range. So until I get further information from him regarding a possible federal statute, I can't provide any additional information other than this says 6 to 8.
6
So
to
he
8.
could come in compliance with our 6-foot requirement.
Oh, I see what you're saying. So
Right.
under the laws, I restate things so that I understand them, by the way.
Sure, I understand.
So basically what you're saying is that the laws that have been provided to you that justify the height of 8 feet actually may allow it to be 6 feet, which would comport with the county requirements.
I would not classify this as a law because I don't know where this came from. It
Okay.
doesn't cite a law, but the information provided says 6 to 8 feet.
What have you been given?
An approved environmental containment plan, and
Who's
there's
it
no
approved
seal
by?
or anything on it, and it's not signed by anybody. And then it has attached to it a certificate of nursery registration, which doesn't, I looked at that statute as well, and it doesn't seem to require a plan either. But again, that was a quick look through this morning. So if I just have the additional information, I have no problem with that. Doing that
Yeah,
additional
basically the
research.
process is you gotta get DEA, EPA, state nursery approval. He has various nurseries throughout the state that have been approved. That's the form. Once this goes through, he gets his nursery license to do it. So that's all part of it. And all those have been conducted.
If I could jump in just a minute, also, I'm sorry, he forgot to introduce me, but it's fine. In addition to the height and the material, which of course it doesn't seem to qualify with the LDC, the location is a concern. You're on a corner lot, it is in the visibility triangle, so there is a safety issue as well. It appears to be partly in the right of way.
Well, I mean, bottom line is they never talk to you guys about the fence.
No, and
Yeah.
the safety concern on the visibility triangle is even more of a concern than the height, although the height absolutely is a problem.
Yeah, I'm not really concerned with the fact that there is a violation. I think there is. The question is, what is the scope of it? I don't want to find that height is part of it if it's superseded by something. That part concerns me.
Right.
Everything else, I wouldn't mind asking them to work with the county to bring it into compliance on. You know, I'm just I want to make height a part of it if it is a violation, but I don't know. It doesn't sound like we've been provided with anything to justify that. I haven't been. The only legal authorities I have are that it is in violation. I mean, I don't see a federal statute or rule about this. I don't deny that. I mean, you may have to go through federal authorities. Does the county have anything else to say about this? All right, then what I'm going to do is I'm going to turn to the public and ask the public if the public wants to be heard about this. I'd like to hear from them. And this is on any of the 3 cases that have come forward. So there's one about a accessory use violation, there's one about the fence, and there's one about the removal of the trees.
Excuse me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Christina Miller.
Thank you.
Thank you, Ms. Miller.
I live in this neighborhood. To give you a clear timeline, the only person that has been dealt with is Mr. Van Zant. The previous owner was only on paper. Mr. Van Zant was notified of what he was doing with that fence at the 4th fence post. To be clear, what he wants to have is a grow house, and he wants you to now ratify his bad behavior. He didn't get a permit. That fence is entirely on the property of the homeowners association. It violates it impedes the view. If you're coming on off Forest Trail or off Turkey Trail, you can't see oncoming traffic. He made it 8 feet tall. He put a black tarp over it. He removed trees that he had no business removing. His people have removed boundary markers. As we sit here, he's got a trailer parked on a neighbor's property, and he wants to tell you that federal law says that he can do that. No, he wants a grow house. He has to fill out an application. The application says it has to have a fence. That fence has to comply with local rules. He's made no effort to do that. He cannot bring it into compliance because surveys have been done, and that fence is on association property. He hasn't built that fence on his property. They cannot make this right, and I anticipate being at the board meeting, at the meeting tomorrow also. There's no way to mitigate what Mr. Van Zant has done. And our neighborhood, our homeowners association, we have tried every step of the way telling him, you can't have that on association property. You have to have the fence on your property. His response to that was, well, this is where there's no rocks and where it's flat land. You know why? Because we maintain that, because we own that. So to be clear, he has always been the person in control of this property. He's always been the person to have agency of this property. That didn't just start in September. It's always been Mr. Van Zant. Mr. Van Zant didn't want to apply for a permit. He didn't want to get a survey done. He doesn't care about any of that. And there's no way at this point for him to correct it. The fence has to come down. Like you said, he can't make coming in our neighborhood. I don't know if you're familiar with our neighborhood and how pristine and natural that we keep it. We're dirt roads for a reason. He has leveled what's in there. He has ruined our view. There's nothing else for him to do but take that fence down.
Thank you. Anyone else?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Hi,
State your name.
Jessica. I'm the president of the association. I've
Last
been
name? I'm sorry.
Ritter.
Thank you.
Sorry.
Good morning.
Good morning. I've been dealing with Milton from day one. We did try to work with him on the fence before he started putting it up. There were only 4 posts in the ground. As we went to him, we did ask him, we did measurements. We brought him the deed, which I do have the deed for you guys to put on record. We have the survey. Milton has cost our low-income residents money. We don't have that much. We depend on the residents to pay $100 a year. We have 83 residents that pay money. This man has cost us money. We had to hire an attorney, get a survey. It's money that we don't have that could be put into our roads. When it rains, our roads are destroyed. It's money that is unnecessary. We were willing to work with him. We offered to even help him.
Is it a voluntary HOA or is it?
It is,
Okay.
yes. So, and we only focus on the roads. We don't focus on what somebody does on their land or anything like that. It's solely roads. We offered to get the equipment and help him move those poles into his property as a community to work with him. His response was combative. I have an attorney. That's what my attorney handles. So here we are today. So his fence is 15 feet on our property on Turkey Trail, 14 on Forest Trail. He has moved markers, as the previous young lady said. We have witnesses watching his employees move the markers. He's blocking the roadway. So we had to literally, his employees move street signs because of the fact that somebody got hurt already. A bicyclist come out onto the road because they had to go further. The car did not see them. So he's constantly, it's been an issue nonstop. So I would like to give you the information that we have so that you can put on file. And I'm coming to you today because hopefully you have the power to stop this right now. This should not go any further. He should not have the permission to put a fence up on somebody else's property.
Okay.
It's not his to
If
do
you
so.
have documentation that you want to be put into the record, it's going to need to come through one of the parties. So the county, I think, would need to review and ask for it to be introduced. I presume respondent would not help you out on that. So has the county reviewed what you have already?
No.
What you
No.
have? Okay. I'm a little concerned about this fence case based on the public's testimony, because I don't know if there can be a violation if the fence is on someone else's property and not his. I don't know that he'd have responsibility for it. So does that conclude your comment?
Yeah, pretty
Okay.
I
much.
think the fence is on, it would be probably on both. It's
Oh, it's on both.
correct.
Yes.
Okay. All right. All right. Thank you.
Thank you.
Is there anyone else from the public who wants to be heard on these cases? I don't see any. I would like, I need to give respondent a chance to respond to the comments. Do you have any comments that you'd like to make about that?
Yeah, the location of the fence isn't before the board and may be an issue between them and him on some kind of trespass for property. We have boundary survey as well and followed it. Again, my same arguments go, we got notice of the violation on the day it was supposed to be resolved. And we have the issue going tomorrow, which I think we're pretty confident in. We just have to prove it was income producing property, which that was the only purpose for it.
Okay.
You know, there's a lot of regulations with building out of cannabis.
This is-
farm.
And have you been sworn in, sir?
No.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Martin Van Sant.
Thank you.
Yeah, I'm the owner of Van Able Holdings, also own Florida Cannabis Supply Corporation, which is what we've been building out there.
Okay.
So there's a lot of cannabis regulations, which we have to go through different regulatory agencies. And we have different rules we have to follow, which is the environmental protection plan, which was submitted in December. When we got approval prior to purchasing the property, we had already gotten all these approvals prior to even making acquisition of the lot. As far as the building height, for cannabis operations for Florida, the allowance is up to 10 feet in height. We were told that we were allowed to go up to 8 feet for that particular location, presumably because it is located within a residential area, which also there's already allowed agricultural practices out there. There's cattle farming, blueberry farms, et cetera out there. It's already happening now. So
I think
that
your
was the-
issue is that even though you've talked to other authorities, it doesn't look like you talked to the county or
I
reviewed
did talk
the.
to county, so we were in process of getting the agriculture status and put in place. But we were told that we needed to be income producing, but for the actual status to be awarded, it just needs to be, the process needs to be started, which we made this process started.
No,
in
I
December
understand, but
2022.
what I'm trying to tell you is there's at least 3 code sections here that, it requires you to look at the county code before doing certain work, like tree removal, things like that.
Yeah, so those trees were removed. We hired a licensed contractor, a licensed arborist to come out, and he removed shrubbery that was underneath, primarily palmettos. There was a lot of saplings, trees in the areas that were doing. It was a 100 by 100 area.
Right.
Which was the actual cultivation site zone, which also has an interior perimeter fence around it with 6 inches of clay. Which we had EPA come out there, check the site plans, which we were planning on doing. They approved the site plans, and because we were going through ag, the process of getting the property zone as ag, when we came to talk to the county, they said these would all be statuses that wouldn't necessarily require a permit, but that's an approval application. But because we haven't been awarded that status yet, there was no possibility for us to do that application yet, for that. To get that approval. So, come February, when we were ready to put seed in the ground and start the operation, and we were told that because we didn't monetize anything yet, that was their reasoning, which is why we had appealed for the VAB to be awarded that status from 2022 for this year. Because that's when we made the acquisition. Because prior to making that acquisition, we were told we were going to be awarded that status, and we were told for 2024, absolutely, we'll get it. Because we're monetizing it already, but the process is a very, very, very lengthy process to get everything put out, and because we have to go through, we have tri-agency forms we have to get, go through EPA, health and safety, and USDA and FDEC standards that we have to meet prior to even getting billed out. So we've had DPI inspectors come out there, walk the lot, confirm the certified boundary reports, the claims of moving stakes and everything like that. I've paid 3 times to have boundary reports out there. And I've had 3 times I've paid for stakes to be placed. And every single time, shortly after, I have somebody within this citizens association, which is not an HOA, the citizens association, come to my property and move my stakes, harass my employees who are out there, harass my family. And it's been they posted and posted online and had discredited my business. It's more of a witch hunt versus anything. We have members who have a close relationship with Mr. Allen over here, who constantly frequents the community, and I'm told he lives not too far from me as well. So these claims are baseless claims. As far as regarding the fence placement on the line, we did meet with Miss Jessica, who had introduced herself as the president of an HOA, and she claimed it was a bona fide HOA. We were like, well, we bought the property, we never signed anything, we didn't know there was anything of that sort. We identified where the lot lines were at, and we had a meeting with her saying that where the lot line runs, there's a lot of trees that are in place, and we didn't want to remove those trees. And I said that the cost would have been should have been on the burden of the association. She made the claim, we don't have enough money. And I said, well, can we do it on this side? We were approved by her. It wasn't until almost 6 months later, was it June, that it became an issue. And we were like, well, we had like $60,000, $70,000 in the project already. This fencing cost project was not cheap. So we had already started that process, and we had already gone through with the ag process to get that status.
Okay.
So these were all things that were sought. With the building, that's a nursery building. It is easily movable. It's not a permanent fixture.
Okay.
It's a greenhouse building with a propagation zone.
Okay, because that's one of the violations.
Right, correct.
Okay.
And the properties, they actually cross two lots. I own 6060 East Forest Trail and 6101 East Turkey Trail. The way we had designed it was to cover both lots, the cultivation site, primarily because both
Well,
lots.
let me focus you on the violations. Okay, so I wanted to give you a chance to respond. I feel like
Correct.
we're now away from the responding to the comments. One is a violation for having an accessory use on the property. Okay, you've addressed a little bit of that. One is for the fence. We talked about that. One is for the trees. I understand your reasons. Okay, but I want to just hear from the county on what is the county's recommendation on these three cases.
Sure. On 2023-00117, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay.
You want me to continue?
I'm curious to know what you
Sure.
want.
Case number 2023-00467. The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,500 along with the administrative costs to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation.
Okay.
Case number 2023-00560. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do you have anything else you want to say?
Don't have issue with the $200 fines. We do have an issue with the $2,500. Again, we had asked that be continued so someone can assess what value the potential removal of the trees actually was. I mean, they're just picking a number out of the air.
Well, that's what happens in these kinds of cases because it's like a liquidated damages
I understand
clause, right? So it's almost because it is incapable of being measured that it comes to me to decide and to pick something that seems reasonable out of the air, which I will do.
Yeah, but there are, and I have been involved in a lawsuit involving a similar issue, not a code violation, where there are all kinds of expert witnesses testified as to the value of the trees, replacement value, et cetera, and that is accessible. We've done it in that case.
All right. Here's what I'm going to do. In case number 2023-00117, which is the accessory use case, I'll find the property in violation and grant 60 days from today to abate the violation. Hopefully this is enough time to take the matter through the value adjustment board process. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed, and I'll otherwise incorporate standard order provisions. In case number 2023-00560, which is the fence provision, I'm going to grant also 60 days to bring the property into compliance. And if it's not brought into compliance as ordered, $100 per day fine, standard order provisions. In case number 2023-00467, the tree case, I'll call it, under LDC 4002A, I am going to assess a one-time fine of $2,500. And just so you know, this is below the amount that I've ordered in other recent cases on smaller lots. But this is based on the county's recommendation, and hopefully that's it.
Thank you.
Thank you.
Thank you.
Next case on today's agenda, John Robert and William Michael Pollock, case number 218-1908, Code Officer Alan Jonason, page 34 of your agenda.
Gentlemen, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
Michael Pollock. William Pollock.
All right, thank you all for your patience as I've gone through this case and really agonized about the issues. I think really it's been a remarkable job of briefing by both sides, probably the best since I've been the special master, for better or for worse. So first let me ask, are there any members of the public who want to be heard on this case before I announce the order? Okay, I don't see any. I'm not going to read it word for word. I'm going to sign it and make a copy available. But essentially, here is what I am finding. I've accepted the representations of fact from respondents' brief regarding the flora that are on the property. I've accepted their representations as fact that they desire the vegetation on the property without exception that remains. I'm making a finding that it's not grossly unaesthetic. I'm making a finding that there are hundreds of acres of unmaintained property across the street. I am going to find first that the property is not in violation of section 20-61 due to weeds, grass, or an accumulation of vegetative matter. I've put on the record before that there's a good case, Baton Rouge Audubon Society, Inc. v. Sandifer. I give you the site in the order that uses the definition of weeds to show that really there should be an emphasis on what's desired. And so there's no violation there. I am finding a violation based on undergrowth for several reasons. I don't believe that it's accurate. Well, first of all, by virtue of the evidence and the record, I think that actually there's a compelling argument that the property is part of a forest. And if it's not part of a forest, it's next to a forest. So for the purpose of the definition of undergrowth, plants, seedlings, saplings, shrubs, herbs probably are going to be pretty consistent. Second, I think that a literal enforcement of the code, even though I think respondents have made a good case that you may not want a literal enforcement of the code, I have to literally enforce the code. So I think that whether we like it or not, the county has intended for this code section to apply as it says. It says so in the brief, said so at a hearing. I also do not believe that the property is exempt under section 20-62B, again, for multiple reasons. I agree with the county that I don't believe when a case has already been brought and a property found in violation that there should be a get out of jail way. In other words, that you don't bring the property in compliance, you wait 5 years and suddenly it's good for the rest of our lives. I don't believe, I think that would be an absurd way to read the code. You'll see my case sites in here that support that. And of course, you'll be able to appeal it. I also believe that Code Officer Jonason's interpretation of the code is correct, that by and large, 20-62B should be applying to vacant parcels. It's not super explicit on that, but you can tell if you read subsection A, you can tell that that's what it actually means. So when we interpret statutes, we have to use all the methods of interpretation. You don't read just one section in isolation. You've proved that in some of your briefing. You have to read the other sections too. So I think that's a commanding result. And I've also previously already found that the property is not exempt under the Florida-friendly landscaping. But what I will say is I do think it is a proper defense. I think it's available to you. I think it's available to anybody under this kind of an enforcement action. I just don't think you proved it. And I think it may have even required expert testimony for the reasons that I put in here. There's a fantastic law review article by a property expert in Florida talking about the need for expert testimony. I quote that. And so, based on the foregoing findings and conclusions, I will order that the respondents abate the violation no later than 60 days from the date of this order. If the violation is not brought into compliance as ordered, a penalty of $250 per day will be imposed. I otherwise incorporate standard order provisions.
Thank you.
Okay.
Can I ask a question about?
Yeah.
If we are to appeal it?
Yeah.
I assume that process would probably take longer than 60 days. And if we were to abate it?
Well, you have a certain appeal period. I can't advise you on how to go about it. You're going to either have to figure that out for yourself, which I think you're capable of doing, or consult legal counsel. But it's before 60 days. You don't have 60 days to appeal it.
Right, but if we appeal it and then that takes longer, so we don't, because if we mow the property in order to abate
So
it
you
within 60
really do
days-
need to consult legal counsel on this. I could answer it, but you can't rely on what I tell you about it, if that makes sense.
Sure, well, I'm just asking what the county's position is are we gonna be assessed a fine if we're in the middle of an appeal?
Please take that up with the county after the hearing.
Okay.
I encourage you to talk to the county about it. All right? We'll make a copy of the order available.
And then I also had another question. In order to bring our property into compliance, is that something that we work with
Yes.
them to do?
You will work with the county on that.
Because like,
They're going to decide whether it's in compliance or not.
okay, so it will be back and forth, I presume?
I doubt it. I think you'll bring it into compliance, but we'll see. All right, thank you.
Do we take that from you? Do we take this from you, or?
I sign the order. We'll make it available right after the hearing. Thanks.
Next case on today's agenda, Margaret Schultz, James David Darmiento, Corona et al., case number 2023-00941, Code Officer Julie Wilkinson, page 36 of your agenda. 35 and 36, excuse me.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name, sir.
My name is John Darmiento.
Thank you.
Are we just doing case 941 or also 808?
Yes. Case number.
Are you doing both or one?
Are you doing both together?
I have both available to do, prepared
Are
to
you
do
okay
right
with-
now at the same
Yeah,
time.
unless
both
there's an
together.
objection to it, I'd rather they presented at the same time.
That's fine.
Okay.
Mr. Darmiento, do you object to having them both heard at the same time?
No, sir.
Okay.
Can we get some clarification? He said his name is John Darmiento, correct?
Yeah.
Are you part of the et al? Are you?
Yes.
Okay, thank you.
Go ahead.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation initially observed on September 26, 2023. The address of the violation is 3625 South Alabama Avenue, Homosassa, Florida. Case number 2023-00941, unlicensed and inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The property owner is Schultz Margaret Darmiento James David Corona, Corona Raymond James, and Darmiento Joseph M. Corona. Has been previously found guilty of the same violation at the same location on October 21st, 2021. That case number is 2131686. With $0 in imposed fines, that case was abated on November 22nd, 2021. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on September 26, 2023, and photos I took during my subsequent inspections on September 28, 2023, October 4th, 6th, and 13th, 2023, and photos from my final inspection on October 17th, 2023. Exhibit B, a copy of the notice of violation and hearing sent to Schultz Margaret Darmiento James David Corona, Corona Raymond James, and Darmiento Joseph M. Corona. A copy of the posting affidavit and a photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order. Exhibit C, findings of fact and order acknowledging compliance from previous case number 2131686. Case number 2023-00808, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owners are Schultz Margaret, Darmiento James David Corona, Corona Raymond James, and Darmiento Joseph M. Corona. Have previously been found guilty of the same violation at the same location on October 21st, 2021. That case number is 2131685 with $0 in imposed fines. That case was abated on November 22nd, 2021. I also have good service via posting the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on September 26, 2023, and photos I took during my subsequent inspections on September 28, 2023, October 4th, 13th, and 16th, 2023, and photos from my final inspection on October 17th, 2023. Exhibit B, a photo of the notice of violation and hearing sent to Schultz Margaret, Darmiento James David Corona, Corona Raymond James, and Darmiento Joseph M. Corona. A copy of the posting affidavit and a photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order. And Exhibit C, findings of facts and order acknowledging compliance from previous case number 2131685.
Okay. Can you take a look at these documents and let me know if you have any objection to them being evidence for these hearings?
Please.
You're not interested?
I'm not interested at all.
Okay. Is there anyone from the public who wants to be heard on either of these cases?
B and C for both of them?
Go ahead.
When can I speak?
So normally what I do is I let the county present its case first, and then I definitely want to hear what you have to say.
Fantastic.
We have been through this a couple times before.
Yes,
so.
we have.
Just if I could get some clarification, he said his name is John Darmiento. We have James Darmiento and Joseph Darmiento, so I'm still trying to figure out if he is actually.
I'm the father. I own everything.
Are you a father of James and Joseph Darmiento?
Yes.
Okay.
I've been here several times with
Okay.
several.
No, I
different
remember you,
properties.
sir, but I am, it appears that you may not be an owner of the property. You said you own everything, but it doesn't look like on the records you're an owner of the property.
Well, I don't know about the records then. You might have to check them,
Okay.
wherever you want to go from there.
Okay. Well, it doesn't really, I just want to know if there's any objection to these documents right now and. Okay. Without objection, what's been proposed as exhibits A through C in each case will be admitted. I do want to hear what the county's case is. Go ahead.
For case 00941, I conducted my initial inspection on September 26, 2023, and observed multiple unlicensed vehicles on the property, which is a violation of the ordinance listed above. On September 27th, 2023, while posting the property, one of the property owners became verbally aggressive with me. My director as
Who was
well.
that?
The son.
Okay.
My director, as well as several sheriff deputies, needed to come out to the property to de-escalate the situation so that I can complete my business. After that, the deputies were called to assist while conducting the next inspection so that there would be no more conflicts with the property owners. During subsequent inspections on September 28th, 2023, October 4th, 2023, the vehicles remained with expired tags. On October 6, 2023, I conducted an inspection at the request of the property owner and found that the vehicles now have current tags. On the following inspections conducted on October 13th, 2023, there were no other unlicensed vehicles on the property. As of my final inspection on October 17, 2023, the property remains in compliance.
Okay, let me just take a look. Before I get to you and you'll have an opportunity, I just want to read what's been given to me. Just 1 second. Gone through the unlicensed vehicle package. I do see that the new tags I'm looking through the junkyard conditions case. So the prior case on the property was just a junk case. It wasn't an unlicensed inoperable vehicle case.
There was also an unlicensed inoperable vehicle.
Oh, there were? Okay.
Yes.
I don't believe that's true.
Yeah, I mean, let me just look. So in Exhibit C, it appears, do you know what case number that was?
For the
Or that
unlicensed-
each of them was?
For the unlicensed vehicle, it's 2131686,
Can you repeat that?
31686.
686, okay. So I want to make sure. Okay, you're right. You're right. Okay, Mr. Darmiento, what's going on?
I don't even know where to begin, so I just want to pay the fine and go. If you don't
Okay.
have nothing nice to say, you shouldn't say anything. So that's all I'm gonna do. Thank you, sir.
What's the county's recommendation?
For the unlicensed vehicle
Both.
case? Oh, for both?
Yeah.
Okay. The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $250 per day, along with the administrative costs to begin on the date of the posting of the property, September 27th, 2023, and continue until October 6th, 2023. That would be 9 days at $250 per day, totaling $2,250. For the junk case, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $250 per day, along with the administrative costs to begin on the date of the posting on the property, which is September 27th, 2023, and continue until October 4th, 2023. That would be 10 days at $250 per day, totaling $2,500.
Oh, wait a second. So on the vehicle case, you said September 27th to October 6th, 9 days, 2,250, which I think is right. And then September 20 on the junk case.
I have an error in that. So during my inspections, they were in compliance and then they went back out of compliance and then came back into compliance. So there's additional
On the
days
junk
that.
case.
On the junk case, yes.
So can you go over that one again?
Okay, so on, the property was posted on September 27th. It was
I'm
out.
sorry, Ms. Wilkinson. I'm just curious what's going on with court reporter.
I've seen her pack it up. And that's-
Do you have to go, ma'am?
No, I was gonna leave because I thought if he's not gonna show.
Oh, no, we'll take your case next.
Okay.
That's what I was
Okay.
referring to.
Please go ahead, Ms. Wilkinson.
I need a moment.
Okay.
Sir?
Yeah.
Can I speak?
Yeah.
The vehicle is a camper, right? So it may have been out of date, like a couple of months, if that, and that was just, you know.
It was a couple months, yeah.
Okay, so that I agree upon. Well,
Okay.
these guys just don't stop. I own like 10 properties and they just keep coming from everywhere. And she's very rude, they're very power crazed, okay? And I feel, this is my personal opinion and my family's opinion, that we're being targeted, you know? My son has got a bad temper, but he don't like people coming on his property. They attempted to come on a property, even seeing signs and
Mr.
everything else,
Darmiento, you're
right?
not even an owner of this property. I mean, right? And so I've allowed you to, although you started very wise at the beginning of the hearing.
Yeah.
I mean, and
After hearing those
I know,
prices, you know,
but-
I mean, that's kind of insane.
But also the
oh,
photos that they speak for themselves. I mean, there's violations. If there weren't violations, I might have some sympathy.
There are some garbage there.
All right, go ahead, Ms. Wilkinson, on the junk case.
So on September 7th, the property was posted. On September 28th, the property was in violation. On October 4th, the property was in compliance. However, on the next inspection on October 13th, the property was again in violation until October 16th. And then from 16th until yesterday, the property was again in compliance.
So specifically give me your fine breakdown, please.
I'm sorry, I didn't hear
Give
you.
me your fine breakdown for this
Okay,
case.
$250
Uh-huh.
a day
For what days?
from September 27th
Mhm.
until October 4th,
Okay,
and from October 13th to October 16th.
okay. My math now matches yours. I saw you raise your hand.
What happened was I was changing a tire. She must have went by. She seen the tire laying on the ground. She called me up. This is a day after the tornadoes tore up Crystal River and everywhere. She's worried about one tire that I'm changing on a truck and one bag of garbage. I mean, it's really beginning to seem like, come on, you guys, take it easy. One tire that I'm changing, I mean, I didn't even have time to
So-
pick it up and put it on the truck.
So let me look. So Ms. Wilkinson, I do have a question for you. On the October 13th photos, what constitutes the violation? Is it the tire?
There's 2 tires and also a bag of loose trash on the ground.
And the bag of trash. How long do they have to be there in order to constitute a violation? I mean, if it's there for 24 hours, is that a violation? If it's there
I would
for
say
8
yes,
hours,
because the trash needs to be stored in a proper litter receptacle, which it was not. It was just on the ground, not in a can with a lid.
Okay. Mr. Darmiento?
We put the cans with the lids. It hadn't been 24 hours. There's no way in the world that bag of garbage sat between the garbage can in the house and the garbage can outside on the walkway for 24 hours along with the tire. Man, sir, this very nice lady has been to my house every day taking pictures. I mean, you can see him every day harassing us. This is insane. That's
The
all.
reason for that is actually partially to do you a favor, which is that the sooner that the property comes into compliance, the sooner the fine would stop. And because sometimes y'all don't call code compliance to show that you've come into compliance. On October 4th, did they call you to bring you out to show that it was in compliance?
It was on October 6th, and that was
6th.
regarding the unlicensed vehicles.
And they did call?
Yes.
Okay.
Sir, I've literally tried my best to do everything that they said at this property and all the other properties.
Well,
You know,
clearly.
I'm without words, honestly.
The problem is it's a repeat violation, so there's very little room for maneuvering. The photos do show violations. Sometimes they're barely violations, but they are
Barely.
violations. I know.
Barely.
But that's what it's gonna take. You've gotta comply with the county code. So I'm gonna find a violation. I'm going to find, I am going to award a fine of $250 per day from September 27th to October 6th, 9 days. It's $22.50 on the vehicle pays.
This is
and
insane.
then
That's insane.
November
insane.
27th to October 4th, and then October 13th to
You're
October
supposed to be a
16th.
fair and just person, and
Yeah.
and this is what it is.
Well, we try.
No, you don't try at all. This is all a bunch of crap.
All right. You can appeal any order made, and I encourage you to. All right. That concludes the hearing.
Thank you.
Yep.
Next case on today's agenda, Fox Run 4 LLC. Case number 218-5674. Code Officer Brandon Norman, page 14 of your agenda. Expert on the case, Joanna Coutu.
Oh, okay.
He's grabbing.
Gotcha.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names for the record?
Ingrid Vossenbelt.
Antonius Van Usen.
Good morning.
Good morning. Brandon Norman, Citrus County Code Compliance Officer. This is for case number 218-5674, Development Applications Applicability of Violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. The address in violation is 4631 East Rejoice Street, Inverness, Florida. The property owner listed is Fox Run 4 LLC. We have good service via confirmation email between Citrus County Code Compliance and the respondent's attorney's office, which I've provided. I would like to authenticate the following documents and request they be admitted into
Oh, are
evidence.
they represented by counsel?
They're supposed
Are
to.
you represented by counsel?
I was hoping
Who's your
that-
attorney?
that he would be here, but,
That would be Mr. Nick Asma.
oh, sorry.
Oh, this is Mr. Ozma.
Yeah.
Yes, sir.
This isn't the only case that Mr.
No,
Ozma
sir.
has today.
I have 8 others, I believe.
I do want to make sure, and I think, the county attorney also is here for this. Has anyone tried to reach out to Mr. Ozma?
I emailed with his paralegal last week confirming.
I have a number you can call if you'd like.
I'll gladly call.
I don't want to deprive anyone of, it was my understanding that he was supposed to be here.
I mentioned
And
Let's
the
take,
court reporter is also here at
Yeah,
his
absolutely.
request.
And thank you for your time, by the way, ma'am. All right, let's take a 5-minute recess. The time is 10:17. Are you guys ready? Time is 10:25. I need to put a couple things on the record. We're back on case number 218-5674, Fox Run 4 LLC. The first thing I need to put on the record is for the county's benefit, which is now knowing that this is one of the cases that Mr. Ozma is involved with. I have a personal connection to Mr. Ozma. He has been one of my good friends for about 25 years. We went to high school together. I've attended his wedding, et cetera, et cetera. I know his kids. I also was aware that his wife was very pregnant and likely to give birth any day recently. And I just had a phone conversation. I wasn't on the phone, but I asked Ms. Spiros to call Mr. Ozma, and apparently that baby has been born. Is that correct?
That is correct.
Okay. I had also spoken to his father-in-law a few weeks ago, who is a board-certified city, county, local government attorney named Kurt Ardeman. And he had told me about the impending birth as well a few weeks ago. If the county believes that that relationship makes me unfit to preside over the hearing, I will step away and you can have the alternate. Well, I mean, I just, it's my duty to disclose this to you. Okay. All right. I've asked Mr. Ozma if he's willing to appear by phone on the record. He agreed to do that, so I'm going to call him on my, unless we have a better phone for it. Okay, yeah.
Let me see if they can reach over.
I'm sorry, did you call him or Ms. Spiros
Ms.
called him?
Spiros did.
It's not gonna.
How about we switch places?
If you want, I'll just sit over here. As long as this mic picks me up.
Thank you.
And also, sir, for the record, is the court reporter taking all this down? Thank you.
And if I'm speaking too quickly, please let me know. Okay. I can just dial out.
Now you can start the report.
Good that you're.
Oh, right.
This is Nick.
Is this Mr. Nick Ozma?
This is, good morning.
Good morning. This is Christian Waugh. You are on speakerphone at the October Citrus County Code Compliance hearing. Can you hear me okay?
I can, Special Magistrate, good morning. Thank you for your phone call.
Yeah, of course. So it's my understanding, and I just wanted you to have an opportunity to speak on the record. We had expected you today. I had continued the hearing several times so that you would be able to attend. But is there a reason why you're not here today?
Yes, Special Magistrate, my wife recently gave birth to our second daughter a few days ago, and so I have to remain close to home to assist her with the new baby and our other children. And so, unfortunately, the new birth and family obligations preclude me from appearing this morning. And I apologize for not being there, and I appreciate the court's consideration to allow my client to appear without me for today's proceeding.
Is it your intention to move to continue, or do you want your client, and is your client okay to proceed without your representation?
Yes, Your Honor. Thank you for asking. My client is there this morning, as I understand it. We have discussed the matter. He is fully capable to handle the proceedings this morning by himself. I am fine, and I permit him to do so. There's no need for me to be present this morning to assist him, physically present in these proceedings, and he has my permission to do so, and I do not wish to continue the proceedings this morning unless the court wishes me to be present for them. But again, I think my client is fully capable to attend by himself, and I'd love for him to do so.
Let me ask your client. Is that your understanding? Are you prepared to go forward today? Okay, all right. Mr. Ozma, congratulations. I think that's really exciting. I have disclosed that I've known you for 25 years to everybody, and they haven't moved to disqualify me. So congratulations to you and Ansley.
Thank you, Mr. Magistrate.
All right. Do you have anything else?
Nothing at this time.
Thank you. All right. Thanks, everyone, for your patience on that. I think we're able to proceed. Anytime someone has a legal representation, our main function here is to provide what's called due process. And that means that you have to have an opportunity to be adequately heard and represented. Okay? Please proceed.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2185674, Development Applications, Applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. The address for the violation is 4631 East Rejoice Street in Inverness, Florida. The property owner listed is Fox Run 4 LLC. I have good service via confirmation email between the Citrus County Code Compliance Office and the respondent's attorney's office. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on March 23rd, 2023, the corrective action inspection on July 12th, 2023, another inspection on September 12th, 2023, and the final inspection conducted yesterday, October 17th, 2023, as well as images from the Citrus County Property Appraiser website for October 2022 and July of 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the email chain between Citrus County Code Compliance and the respondent's attorney's office verifying good service. Exhibit C will be a copy of the LLC amendments and Florida limited liability forms for DT Villages 11 LLC and Fox Run 4 LLC. Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Fox Run 4 LLC. And I'll explain that in just a second.
It's exhibits A through D?
A through D, yes, sir.
All right, ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you do have objections to them being evidence in this hearing. And take your time. And while we're waiting, are there any members of the public who are going to want to be heard on this case? All right, I don't see any. Do you have any objections to these documents, sir?
To these documents, no.
Okay. All right, without objection, what's been proposed as exhibits A through D are evidence. Go ahead.
On March 23rd, 2023, an initial inspection was conducted of the property for a complaint of site modification without permits, as well as tree debris. During my initial inspection of the area, I was approached by an individual who identified himself as Mr. Anton Van Oosen, who stated he was the manager of DT Villages 11 LLC, who was at the time listed as the company that owned many of the properties that I was inspecting.
I'm sorry. I think the court reporter's having a hard time. Can you slow down a little bit?
Oh, yeah, I'm sorry.
It's okay.
I apologize.
Sorry.
That's good. Thanks.
I informed the individual of my purpose for being there, and he became defensive with me. I informed him of the complaint I had received and that based off of that complaint, I observed other violations as well. We spoke of the site modifications and the junk and debris violations on the properties that I identified belonging to DT Villages 11 LLC at the time of my inspection, and about how to bring those violations back into compliance. Later, it was discovered that the sale of the property had occurred for several of the properties that I inspected that were listed as DT Villages 11 LLC. I verified new ownership of the properties that were sold and issued new notices of violations to the property owners. The properties were found to be in violation of the above ordinance due to not having permits issued before the removal of trees and the modification of the property. The aerial photos show the trees were removed between October 2022 and the day of my first inspection of March 23rd, 2023. As of my inspection yesterday, October 17th, 2022, no permits have been applied for or issued for the property.
I mean, what would be the way to abate this, if anything?
I do have an expert witness,
Okay.
Joanna Kachu. But typically with these cases, in order to abate these violations, is to apply for a permit.
An after the fact permit?
And after, or a site development permit.
Okay.
Site development permit.
I see.
In instances where people have no intentions to develop the property, this is why we present the case, and we ultimately ask for the one-time fine.
I understand. Okay.
And Joanna Coutu, Growth Management. This has an MDR designation, that's medium density residential. It's about 0.33 acres. We do have no applications.
You have no applications?
No applications at this time.
Okay.
Right.
Okay. Well, I sure would like to hear from Fox Run. Are you all the owners or managers of Fox Run?
We are the owners.
You're the owners. Okay. Well, tell me what's going on.
The problem, to answer your question, is that all of these cases are all
Intertwined.
Intertwined.
There's 9 cases altogether.
yeah, and it's all the same. So I made my arguments actually about all of them. I divided it and I separated it, but I start with a general sort of introduction, give you some background of the properties, and then I come to this one, and then probably come to the next one.
So would you be the respondent and speakers for the other cases as well?
All of them, yes.
Okay. Well,
So,
I'm gonna have to, Beth Antrim with the county attorney's office. Some of these properties are not owned by companies that he has control of.
okay.
So I would want him to address each property.
I'm going to. And so the reason why I was bringing that up is regardless of who owns what I want you to do is tell me what you think is appropriate for this case. If it involves part of a bigger story, I'll hear it, So tell me what you think is
Well,
appropriate.
I have 7 pages to read out loud. I can do that 10 times today. Then,
Well,
yeah.
I can reincorporate in any case that you think it's appropriate. We can reincorporate that record. So I invite you to present your case.
Yes, and may I comment on your remark?
You may.
I also have a limited power of attorney from Mr. and Mrs. Garcia. That's also that's the other one that is at stake. So that's the missing person.
Okay.
I can present.
Do you have a copy of that?
Yes.
Could you present it to Miss Antrim? And what I'd like to do is have that be an exhibit, frankly, if it's a copy, pending objection from the county. This is only for the purposes of standing to speak, so.
And may I add to
Actually,
that?
could you
Oh,
hold on
sorry.
a second? Yeah. I want them to be able to hear and focus on what you're saying, but so. Thank you. Are these two copies of the same?
If there's two different
Pull
It's,
your,
uh,
pull
oh,
your
sorry.
mic over,
Oh, I see.
Sandra.
There's two different properties.
Well, they
No,
look
did I-
like
did
the
I
same
give-
document to me.
I'm sorry. Is that one for Farid Garcia?
Yeah, there's one from Farid, there's one
And-
from Andrea, but I have two copies.
We have two.
Should I have two copies?
There's two properties.
All right, I'm admitting one as respondent's exhibit. Okay, respondent. We'll do numbers for you, so you'll be exhibit 1.
Okay.
Okay. Go
And the
ahead.
reason why I represent these people is that I sold them the lot just a month prior to the pictures were taken and the notice of violation
Okay.
first was. So, and it is all in one tiny area. It's all the same. And that's why I wanted to combine. But I'm more than happy to reply to, let me see, it was, I think, 21674, right? That was the one.
This is for case 2185674.
Yes, correct. Okay. Again, I'm going to read a couple of things, and we come back to the other ones.
Please. Okay.
Okay. My name is Anton Newson. You've heard that. Next to me is my wife, Ingrid, and we reside at 12050 South Pleasant Grove Road in Floral City, and we represent the entities Garden Estate of Inverness, LLC, Foxrun 4, LLC, Mimosa Hills, LLC, and Miranda Springs, LLC. I also represent Mr. Farid Garcia and his wife, Andrea Orejuela, or Joela, or whatever, and have limited power of attorney to act on their behalf in these proceedings. We're here on the county's notice of violation dated June 13, May 22nd, March 30, and April the 3rd for the cases 218-5678, 218-85676, 218-5674, CE 2023-00128, CE 2023-00129, the 130 and the 31. And also for 2185828, 2185829, and 2185830. I brought with me a written statement of my testimony today, which I will read out to you, and would like to submit this document into evidence. And I have the original, and my question is, do you want to have it up front or when I'm finished and then?
I think we need to wait for you to make it because I'm not sure it's admissible as evidence. It may be admissible. In other words, it's basically going to be a transcript, right? Because you're going to be reading it. Why don't you read it first? Let's do that.
Okay. The background on political motivations for the violations. The complainants for all notice of violation that we are here today was Citrus County Commissioner Holly Davis of the Citrus County Board of County Commissioners. I refer for this to the Citrus County BOCC service request that's part of each violation and brought into evidence by Citrus County in case 2185828. Commissioner Davis is using the code enforcement arm of Citrus County to attempt to force financial concessions from me and my companies in order to address an alleged issue with the roads in the subdivision located in Citrus County known as Inverness Village Unit 4. Her actions on behalf of Citrus County Board of County Commissioners against me are punitive, and the evidence for this is the following. She made a statement, Holly Davis, in the Citrus Chronicle on September 20, 2023. I quote her, "So there's indeed a path to a positive resolution, but it requires one or more of the entities to come forward with a checkbook. Until that happens, all agencies will continue to ratchet up the pressure. Note, one or more of the entities includes my company, DT Villages 11. 2, Commissioner Davis demanded to me that I deliver a check for $35,000 to her office before she would agree to a sit-down meeting with me to discuss the road issues.
I just want to make sure I'm understanding what you're saying. Are you saying that Citrus County Commissioner demanded that you come with a $35,000 check made payable to the county?
Correct.
Okay. Okay.
Otherwise,
I just
she
want to
wouldn't-
understand what you're saying.
Otherwise, she wouldn't talk with me.
Okay.
Correct. And there's an email thread about this, and I want to attach that here to as an exhibit A. Do I have to present it now,
Now
or can I do it?
that we can talk about. What exactly are you seeking to admit?
It's an email correspondence back and forth between my husband and
And
Commissioner Holly Davis.
Okay, I'd like to ask for the county to review this and let me know if you have any objections to it being admissible as Exhibit 2.
Yeah, that's fine.
Exhibit A. Yeah.
No, it'll be Exhibit 2 for
Oh, sorry.
respondents.
Yeah, you're
so I'm
right.
gonna
Oh.
use letters for them
Okay.
and I'm gonna use
Okay,
numbers.
sorry. Okay.
It doesn't matter. That's for me.
Ms. Antrim, what I'm assuming is that it may be relevant for a defense of arbitrary enforcement or an equal protection violation, which may be a valid defense. I don't know. So I'm just telling you what I'm thinking.
Thank you.
Sir, can I just get my water real quick?
I'm sorry?
Water?
Yeah, good water.
Okay, thanks.
First order of business, as Admiral Kirk said in Star Trek II, is survival. Mr. Norman,
Yes,
I'm
sir.
sorry.
No,
While
yes, sir.
while they're reviewing that, I had a question for you.
Yes,
These
sir.
photos look familiar to me in terms of, have you brought cases from this neighborhood before?
Yes, sir, we
Okay.
have. We presented cases from other property owners in that area.
Okay,
So,
all right, that's what I thought.
yes, sir.
I'm going to object to this because it has no relation to any of the code violations. They're not mentioned in any way in here.
Okay. Let's take a look. Thank you.
So I'm objecting on relevance.
Sure. All right, I'm going to admit it as Exhibit 2.
Thank you. Number 3, the lack of material evidence to establish a violation of Ordinance Chapter 4, Section 4002 ABC, site modification. The county's own photographs clearly show no material change development on the lots in question as defined by Florida Statute 380.04, number 1. The term development means the carrying out of any building activity or mining operation, the making of any material change in the use or appearance of any structure or land, or the dividing of land into 3 or more parcels. 4. The lack of material evidence to establish a violation of Ordinance Chapter 20, Article 3, Section 2231, A. Accumulation of junk and debris. The photographic evidence of Citrus County shows that, at best, there's a scattered collection of vegetative debris that has existed on site for many years on agricultural classified land and well past the 5-year statute of limitation. The consequence of Commissioner Davis' actions is to pressure the Citrus County Code Enforcement Office, which operates under the Citrus County Board of County Commissioners, to issue the violations against me when none are warranted. These enforcement actions were not brought by a citizen of Citrus County and not by any lot owner within the affected area. Next chapter, background of the infamous Village Unit 4. All of the lots that are subject of the violations are located in the subdivision known as Infamous Village Unit 4. Infamous Unit 4 has a history of about 20 continuous years of bona fide agricultural use as cropland that ended on January 1st, 2023. During all of those years, I grew and harvested hay, and to do so I paid for tilling, dolomite, fertilizer and herbicide on the land, which is required to create and maintain a bona fide commercial hay venture. The farm property was originally about 100 acres. Please see a map which is attached hereto and marked Exhibit B.
Okay, now tell me what the relevance of this is, this document.
That I show you that the subdivision, and this was all agricultural exempt, classified.
Everything that you've outlined in black was agriculturally exempt?
Correct.
And where is your property on that map? This property that we're...
All of these properties were mine.
Well, yeah, the 9 that we are talking about are highlighted orange.
Yes.
Okay. All right, I'd like to ask you to show that to Ms. Antrim and let me know if you have objections to it being Exhibit 3.
Well, I'd like to object to the characterization of this as being farmland, because it's not. And it hasn't been for quite some time.
Okay. Take a look. Thanks. All right, I'm going to reserve ruling on the admission of this just because I'm not sure how it's relevant yet, but so I'll reserve on that. Please proceed.
The farm property was originally about 100 acres. As late as 2020, there was new grass planted on 4-acre piece within the subdivision. The plan was to plant new grass on the southeast corner of the subdivision. That's block 13. That's what is at stake today in 2022. For various reasons, I decided to remove the agricultural classification effective January 1st this year. When the land was classified as agricultural, logs, stumps, branches and other vegetative debris over the years were gathered from the land and put in the corner of the farmland on block 13, located within the subdivision. I've owned the lots at issue for 14 years. This vegetative debris has been in place for at least 7 years. The vegetative debris was ready to be burned, which is common practice for farmers, and in compliance with any state and local law. The location in Block 13 in the subdivision where the vegetative debris was piled up during the years that it was classified as agricultural is in fact the essence of the violations today. The lots in violation are highlighted on the map. To conclude, the actions that serve as the basis for the violations occurred while the land was classified as agricultural. It is critical to note that land which is classified as agricultural is exempted from the requirements in Chapter 4, Section 4002 ABC of the Citrus County Land Development Code, and the same farmland is also exempted from the requirements in Chapter 20, Article 3, Section 2231A of the Citrus County Code of Ordinances, accumulation of junk and debris. I realize that if an agricultural classification is lifted, code enforcement may fine unpermitted improvements on the property or may ask the owner of the property to remove the improvements due to code violations. However, this relates to physical improvements that include a barn, stables, or even fences. This does not include vegetative debris. Vegetative debris can hardly be defined as an improvement. There are no illegal structures on the land. Please note Florida Statute 604.5 and Florida Statute 823.14.
Can you repeat those statute numbers?
604.5 and Florida Statute 823.14, number 4, A and B. Okay, now I come by accident. The first one is this case.
Good.
Foxrun, owner Foxrun, case number 2185674 is 4631 East Rejoice Street, lot 15, block 14. This lot had agricultural exemption through the end of 2018. While classified as agricultural, several piles of dirt and vegetative debris were placed on the lot. By the end of 2022, the tree on the lot blew down and was uprooted. At the beginning of this year, I believed that cleaning the fallen tree and vegetative debris was a good thing to do because the fallen tree and debris were a hazardous situation for local traffic that cut the corner from Crestwood Avenue to Rejoice Street. And you can even see that on the pictures, by the way. I asked a local landscaper to assist with clearing the fallen tree and debris. The landscaper also spread some piles of dirt over the lot, and when Mr. Brandon Norman, the Citrus County Compliance Officer, took his picture on March the 23rd, the cleanup of the lot was just finished. The fallen tree, together with other vegetative debris, was removed by the landscaper, and most of the piles of dirt were spread out on the lot. The vegetative work is not any form of construction activity. Additionally, there has been no material change in the land. Mr. Norman did not notice any activity that violates any law. In fact, I did what Mr. Norman required me to do in Block 13. The pictures taken by Mr. Norman in 2023 show a perfect lot. The evidence presented does not support a violation of Chapter 4, Section 4002 A, B, C of the Citrus County Land Development Code because there has been no material change or development to the land. Mr. Norman fails to make a prima facie case of a violation, and the case should be dismissed. One more remark regarding this case, 4631 Rejoice Street. Mr. Norman is of the opinion that the work the landscaper did, cleaning up the lot, is considered to be development, and thus a violation of Chapter 4, Section 4002 ABC of the Citrus County Land Development Code. And these activities on the lot were done without a building permit. So to his opinion, I need a building permit to remove vegetative debris from my lot. On the other hand, Mr. Norman requires removal of all fallen trees and other vegetative debris in Block 13 as a condition to be in compliance with Chapter 20, Article 3, Section 2231A of the Citrus County Code of Ordinance, accumulation of junk and debris. Apparently, I don't need a building permit if Citrus County considers this ordinance to be applicable. So if cleaning up a lot is defined as site development, I need a building permit. If the same cleaning is defined as clearing accumulation of debris, I don't need a permit. And Citrus County forces me to clean up the lot. Citrus County is taking a conflicting position. It is ordering me to remove vegetative debris from my land, from my lot, and it's prohibiting me from removing vegetative debris from my lot unless I have a building permit. Both cannot be true. May I continue? But that relates to the other cases.
Your other comments are related to the other lots. You're diving into more specific points on the other lots.
Yes.
After this.
Yeah.
I'd rather not, unless something about that is relevant for this case for right now.
For this case?
Yeah.
No.
I mean, take your time.
No, I don't think so.
Okay, I think I understand what you're saying. So, Mr. Norman, what is, I think with the county, let me see if I understand the county's case. The county's case is essentially that on this lot, stuff was cut down, it was cleared, that basically, without any kind of a site development plan, in violation of 4002. Is that right?
That's correct, sir.
And one of their defenses is that how can that be required if it really was just vegetative debris to be removed? Is there a difference between the type of vegetative debris that normally you can remove without a permit and what was on the lot before it was cleared?
I'd like to refer back to my expert witness, Joanna Coutu.
Joanna Coutu, Growth Management. What I did hear in his statement was the fill. I know that's not your specific question, but to go there, that he brought in fill and spread it. That's clearly development in the definition of Land Development Code. As far as tree removal, not vegetative debris, but tree removal, 4 inches is the trigger for a tree. So if it's less than 4 inches in diameter, yes. If it's more than 4 inches or debris, it's not supposed to be removed without development on the site. There's no reason, there's no active development on there approved to be cleaning up for.
Let me make sure I understand. So if a tree gets, let's say there's a 8-inch, is it diameter?
Yes.
8-inch diameter. Then in order to even cut it down, do you need a permit?
Yes.
Okay.
And you would need a development application to be able to get that permit as well.
Here's my next question. So let's say that it's 8 inches in diameter and it just falls, and it's an alive tree. Do you need a permit to remove it?
We default to statute slightly on that there's a statute that says that if there is a danger to humans or the land, that you can have an arborist certify that's a danger and we have to remove it. They provide that to us and we go, okay, check, you can take that one out.
I mean, I don't think they've really debated that it's been cleared. I'll talk to them about it. I don't know that they're saying that. They seem to be making two arguments. One is that any site clearing that was done doesn't rise to the level of development under the section of. I'm just trying to restate.
Understand, yes.
And is that one of your points?
Yeah.
Okay. Another argument they're making is that to the extent that there was debris, that the county can't have it both ways. In other words, you can't require that debris get removed from another lot and without a permit, and then say, you should have had a permit before you did it on this lot. But I think your response has been that depending on the diameter, that yes, you can.
Correct. And then the fill, of course, is a whole nother issue. But I heard him say something about material appearance. That's not the definition. It's called development, and it's a development definition.
The other, and I'll tell you right now that I don't find the statute of limitations argument persuasive. And the reason is that the way you apply a statute of limitations argument is when an action, if it's a continuing action, if it's a continuing violation, then it keeps happening. You don't get a clear, it doesn't, a continuing violation doesn't get a clear depending on the fact that it's lasted for 20 years, if that makes sense. But
Let me rephrase it.
okay.
I told you that this document, what I read out, is for all the cases.
Yeah.
This specific case, I agree with you. It's not the statute of limitations
Okay,
on
all right.
this specific case is not applicable.
Okay, gotcha. And fair enough. All right, so let me just think through everything. We'll go through each case.
I do have some additional information I'd like to present.
Yeah, by all means.
Through the code officer. I have some photographs to show him.
Are they going to be introduced as evidence?
Yes.
Okay, then before we admit them, of course, we'll have them reviewed by respondents and we'll see if they have any objection to them.
I'd also like to point out that I believe that Mr. Van Nuys was referring to the wrong section 4001, the wrong version. I think he was referring to the version prior to the last amendment.
There has been an amendment to in Chapter 4 on these statutes, so I don't know. You may not be aware. It's been substantially clarified. I might have agreed with you once upon a time.
There's also an Attorney General opinion that provides there's no statute of limitations on code cases. If you'd like me to.
Yeah, I mean, and the reason why they come to that opinion is essentially why I said.
Yeah, excellent. Nice pictures.
Okay, do you have any objection on them being
No,
evidence?
not at all.
Ma'am?
I just want to remind everybody that the court reporter's here, so we have to make sure we speak into our mics.
All right, please, Ms. Antrim, proceed.
Yes, could you tell us, when you were doing your investigation regarding this property, did you look at various years of aerial views of the property?
That's correct. I had to go back pretty
In
far.
what's been marked as, I believe, Exhibit E, there's several pages there. Have you seen all of those prior to today?
Yes, ma'am.
And can you tell us at the time of the first or the earliest dated photo?
It's listed on here, 2021 is the year.
I think there's.
Oh, I see the date at the bottom. I apologize. It says December 3rd, 2021. Oh, there was another one behind there. There was 4.
Yes.
I apologize. The date's listed as January 18th, 2019. And yes, I've seen this photo as well.
And does that photo in any way resemble what you saw in 2023?
As far as
Ms.
The-
Antrim,
the
you probably
tree
need to
being
get by a microphone.
Closer,
Just
am I closer?
resembling this.
Does that in any way resemble the condition of the property in 2023?
Oh, not at all. They look completely different.
okay.
And did you see a progression of changes in the property over the years from 2019 to 2023?
I do notice a lot more. It appears to be someone's traversing the property, so there's a lot more of what appears to be like dirt roads that have been cut into the property versus in 2019. I mean, there's essentially 2 roads.
And does it appear that the ground has been cleared somewhat?
It does appear so.
And the trees are, there's no trees on the property?
The tree is non-existent in 2023. Yes, ma'am.
Okay. We can admit that as Exhibit E. And I'll just take a look at it. I'm also going to admit the document submitted by respondents as Exhibit, I think 2, but only for the purpose of where the lots are, which I think, yeah. Oh, it should be 3? Okay, then it'll be 3. I'm now looking at Exhibit E. Okay.
And I have a couple more questions.
Yep, you have that right.
When you spoke with Mr. Van Usen, what was he doing?
The date of my inspection on March 23rd, I arrived to the area to conduct my inspection. I observed a pickup truck with a trailer, a utility-sized trailer, I would say no more than 12 feet long. I don't have an exact measurement. It's my guesstimate. It was full of tree debris. I observed an individual get out of the vehicle and make their way towards the back of the trailer. When they reached the back of the trailer, it did appear that they were going to open it up, and then that's when I was noticed. The individual approached me, and that's when he identified himself as Mr. Van Usen. I asked him if he had planned on unloading the debris, and from our conversation, he said he did intend to. He said he'd been doing it for some time. He would bring the debris from other properties onto that property, and that's where he had burn piles there, and that's where he would dispose of the tree debris.
That's not a violation
It is,
in this
it is,
case.
It's not a violation for this case
Okay.
per se. It's kind of the basis around how my interaction occurred with him.
Okay.
I did inform him that it would be illegal dumping, a violation for illegal dumping, if he did decide to remove the tree debris from the trailer and place it onto the property, because that tree debris came from a different parcel. It doesn't belong to that parcel. So technically it's an illegal dumping. Mr. Van Usen decided to, after our conversation had completed, from what I spoke about earlier, he did leave the area with the trailer still, with the tree debris still on the trailer.
Okay.
How large of an area of the village's subdivision did you traverse while you were out there doing your inspections?
I would need to refer back to a map to say so, but I essentially traversed the entire Rejoice Street, and also the entire J Street that's located out there. That's mapped on the property appraiser's website.
Did you see anything that resembled any type of farming activity?
I did not observe any type of farming activity taking place during my inspections.
And the progression of photographs that you reviewed regarding this lot in particular, did you see anything that indicated any type of farming activity on the property over the years?
For this address at 4631, I did not observe anything that would lead me to believe that any farming activity was occurring on the property.
Thank you.
Okay, well, let me ask respondents, what's the relevance of farming activity in 2023 on this lot, if any?
There are no farming activities in 2023, and that's not my statement.
Yeah, no, okay, so I just want to clarify and make sure I
So
understand.
the reason why we lifted the agricultural exemption or the classified is that more and more lots were sold, and third-party buyers wanted to construct a home on it.
I understand.
So that's the reason why. And as I told before, maybe you missed it, I said the agricultural exemption, especially in that part where he was looking at, block 13, was completely agricultural classified in 2022. And for a good reason. I can't remember if you brought that into evidence, but my letter that I wrote to you, I think, or to the code compliance in general, of the end of April, I attached the green cards from the property appraiser, which shows that it was agricultural exempted.
Okay.
So it's in the evidence.
I did hear everything you said. I was just asking to clarify what the potential relevance might be from your side of it, because you actually mentioned the agricultural exemption and part many times. Do you want to cross-examine Mr. Norman on the matters he just testified about?
Yes. Mr. Norman, I have a question to you. When you took the pictures in March and you sent out a week later the notices of violation, who did you direct that to? Can you remember that?
I do. The original notices of violations were mailed to DT Villages 11 LLC at the time of the issuance for the initial violations. With that, they were also sent to the registered agent that was on file. Prior to sending out those notice of violations, I do confirm that at the time that I issued the notice of violation, that DT Villages 11 was the property owner at the time of the issuance. Okay.
This is incorrect information. Mr. Norman sent one to DT Villages Investment.
So just hold on a second. What I want to make sure that you, so if you're going to cross-examine him, you need to ask all your questions and then you can.
Excuse me.
Yeah.
But I didn't make any copy. But can you have a look over here?
No, what are you wanting him to do?
That he directed it all, he sent them all to DT Villages Investment, while he now is saying, I send it to DT Villages 11, which is another company. So
You can ask him. Just ask him what his recollection is.
Can you remember that you sent them to DT Villages Investment?
I would need to look back at my previous notice of violation. We do have it on file. If you'd like, I can go print a copy of it.
So I'm not sure it's relevant, but go ahead.
I tell you why it's relevant.
Yeah, okay.
I tell you why it's relevant. Because they all the time they say, oh, he has 11 companies and he's trying to move on every time to prevent being here or whatever. No, in my letter to Mr. Norman, I said, hey, you have the wrong companies. DT Villages Investment is not DT Villages 11. They translated it. He's running away. He's incorporating 11 companies to run away. Well, these 11 companies, the transfer of the lots happened on March the 24th. I got the letter on March 29th. So how could I do that? How could I have known that he would send me a notice of violation?
Well, I'll tell you this, that's not an issue for this hearing.
No.
And yeah, I mean, just because the violation is alleged as afterwards as well. So the only question for me would be, who is the correct owner now? Have you received proper notice? That kind of, I'm not trying to shut you down. I'm just trying to focus the issues for the hearing. It may matter for the narrative. It may matter for the public. It doesn't matter to me for this case.
Okay.
That's all. But
Mr.
please
Norman,
continue. Yeah.
Mr. Norman,
Yes, sir.
did you ever notice any activity in this particular case? Development activity or whatever? Did you notice it yourself? Did you see someone working on the lot?
I did not see anyone doing any activity at the address of 4631 East Rejoice Street.
So, your first picture of a nice lot, how did you come to the conclusion that there are development activities?
With site modification cases, anytime that we get a report for a site modification without a development plan, we do our due diligence. We look at the previous years for aerials to determine what was actually there prior to. And based off that, that's how we determine if the violation was present.
What is the change of the land?
The removal of trees without a site development plan.
A tree was fallen down, not by me, was fallen down, the wind or whatever, took it out, was a hazard for the traffic that cut the corner. You can see that on the pictures. What's wrong with that?
I believe that Joanna also mentioned that with the removal of trees such as that, it still needs to go through the building process and it needs to be certified by an arborist stating that it is a hazard. From our records, that has not occurred.
Okay, what diameter was the tree?
I don't have that information available. I have the canopy
You
size.
don't know anything about
I have
the
the
tree.
estimated canopy size of the tree.
You have?
Based on the photos that I've submitted, I do.
Okay, so what is your guess?
I can't attest to what size the tree was. I can talk about the canopy size and how much of the parcel it occupied.
So when the wind blows it over and it uprooted, then, I mean, I violate the law.
Again, I believe that
Treated for
Joanna's already. Sorry.
hazardous situation.
I also
That's
believe
what
that
you said.
Joanna's already
Mr. Norman,
testified to
hold on,
that.
just,
so.
we got to make sure
Yes,
you
sir.
don't interrupt.
Oh, I apologize.
I know it's tempting, but we also have to create a clear record from Madam Court Reporter.
I apologize.
Go ahead.
So, you took a picture. Did you see that they cut the corner, the traffic, the local traffic? Or do you want me to show that picture for you again?
I'm not sure what relevancy it has to do with the removal of the tree. I apologize. Or trees. It is a
Well,
large
is there a
canopy.
danger for the local traffic? That's my question.
Mr.
In
Norman,
fact.
if you know the answer.
I don't know.
Okay.
I don't know.
Okay.
I don't know how many times that has to happen. All right, thanks.
For this case, I'm done. I have no questions anymore.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation.
Well, you mentioned abating the violation, but there's no abating the violation, is there?
In this sense, this is how we come to a closure for it.
Okay, I was just,
Poor choice of words, I apologize.
no, it's not. Let me just think about it for a moment. You know, part of the reason why I usually like to have the cases all brought together is because then I can consider, if there are multiple violations, what an appropriate punishment or penalty or consequence might be in light of the fact that there are others. Because we're not doing that here, listen, I am going to find a violation, and I'll explain why. Under our code, you know, even clearing is development, and part of the reason why, you know, and some people don't like it, is that when you clear something, it may affect the drainage, it may affect the stormwater runoff, it may affect this or that, and so that's why in the county's purpose in section 4001, it explains and gives some context on why the requirements in 4002 exist. And by the way, 4002 was amended a year ago because there were concerns over how clear and unclear it was. Santrum's raised the possibility that you may be functioning on the old code section, and if you are, you need to look at the new one. In any event, the evidence is sufficient to find a violation based not just on the tree, but on the clearing and the fill. So I, however, am going to deviate from the county's recommendation and assess a $2,500 fine based on the fact that that's what I assessed on another case, an individual case. And you do have the right to appeal my order. Thank you.
Thank you.
We want to continue with these, or do we want, I mean, they're going to be take time, but from the rest of.
We're going to take a break at noon.
Okay.
So based on how many people are here, how many are here just from the public? Okay. Okay. Do you have a sense of what cases they're all here for? Is it these cases?
No,
Okay.
they're different
What do you
cases.
wanna do?
That's what I was going to
You want
ask.
to be here for all these?
Do we want to get?
Okay, all right. I want to get as many people moving out of
Okay.
here as possible. So
Thank
if
you.
you know what people are here for, I'd like to ask to take these
Thank you.
cases. Yeah.
So what's,
Your other cases are going to be called, but we have a lot of people waiting. So we're going to try and take some of those cases next.
would you keep my story intact?
Oh, we're going to incorporate it.
Oh, okay.
I'm not moving you to the end. I don't know where you'll be yet. We have to take some other cases here. We are going to take a break at noon. Okay?
Yeah.
And I'm sorry, Madam Court Reporter. Okay.
She can stretch.
Yeah.
Next case on today's agenda, Pepe and Barbara Mohaka, case number 2023-00532. Cody McGuire, code officer assigned to the case, page 27 of your agenda.
Oh, well, Barbara is ex-wife now.
Oh, really?
Yes.
Okay.
So,
Sir, Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Pepe Majoka.
Thank you.
Thanks.
Cody McGuire.
Morning.
Morning. Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-00532. Accumulation of junk and debris in a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 7455 West Pixie Lane, Denellen, Florida. Property owner Majoka Pepe and Barbara. Good service via posting notice of hearing on the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on July 24th, corrective action inspection on August 23rd, 2023, and final photos of my final inspection conducted on October 17th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objections to them being evidence in this hearing.
This trash is actually mine. I was there to clear the property.
Okay.
When I've noticed, when I stopped,
Well, sir, I want to know what's going on, but the very first thing I need to
these
know.
are my trash. I'm
That's
clearing the
fine.
property. Yes.
I believe that, but
Okay.
what I want you to do is let me know if you have any legal objections. Are these fake photos?
No,
Is there
these are not fake photos.
Yeah, if you have an objection, I need to know before I can hear you talk about them.
Right.
And before I can look at them, I need to know if you have any objection to them.
There's objections. Some of these are actually not mine.
Okay.
But the property is sold. Closing is November 15th.
Oh, you're under contract to sell it.
Yes, I mean the buyer already put $1,000.
Yeah, that's not a sale, but it means you will.
Right,
Okay.
but the closing November 15th.
Are they aware that there's a code enforcement case on the property?
That's like I said, no, not yet.
Okay,
But
well.
soon there will be because you don't want to buy a property with a lien on it.
Right.
The bus seats is not mine. So, but
Mr. Mahoka, before we get to your comments,
Right.
I need to know, look through it, let me know if you have an objection to anything.
Well,
And while he's doing that, is there anyone from the public who wants to be heard on this case?
what
I thought you guys called case. I didn't see anyone from the public who wants to be heard on this case.
Oh, this is the key.
Oh, well, that's what we want to do, is we want to call the cases where there's people waiting.
Oh, okay. Oh, okay. All right.
Okay.
He had it.
All right.
Should I ask him? I'll give you 3 weeks now. Or? All right.
All right. And your ex-wife signed the contract to sell the property?
Yes.
Okay. Así es la vida.
I mean, my plan was to build a houses because Mr. McGuire he's very lenient to me, so I got respect for him.
Okay. We don't hear that every day at these hearings, so. Thank you.
I even removed the RV, so he knows that.
All right, let me take a look real quick. I think I got the gist of it. Go ahead.
All right. On July 24th, 2023, I conducted an initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions. There was a little pen construction with a tarp for siding, a long blue bench seat at the back of the property, and loose debris throughout, which is a violation of the ordinance listed above. On August 23rd, 2023, I conducted a corrective action inspection and observed the property remained in violation of junk. I have had contact with Pepe throughout and on August 3rd. And as of my final inspection on October 17th, the property remains in violation.
Okay. How much time do you need to complete the
Sir,
process?
if you give me 3 weeks, I mean, I already called Adams Roll-Off Dumpster because they are so far behind. They're behind because a tornado went by on Crystal River. So, like I said, I'm asking for 3 weeks. So
Okay. well, I can accommodate that. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $100 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when a violation has been abated in order to allow for reinspection.
Okay, I adopt the county's proposed findings of fact and recommendations. I'll grant you 30 days from today to abate the violation. If it's not brought into compliance as ordered, a fine of $100 per day will be assessed.
Okay, so if I clean up, like say in less than 2 weeks, so
Call them, and then it'll be done.
it'll be
okay.
done, so I don't have to pay anything.
Correct.
Okay.
Well, I think. I mean, yeah,
All right.
probably more than
Okay.
likely.
All right, because
All right.
I'm actually right now I'm homeless, but so.
Entiendo. Buena suerte.
All right.
All right, that's it.
Thank you.
Next case on today's agenda, Cynthia Sue Airman, case number 2023-00534, Code Officer Julie Wilkinson, page 13 of your agenda.
Well, they said Oh, okay. Go ahead.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2023-534, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 8703 West Faust Lane, Homosassa. Property owner is Ermin Cynthia Sue. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 31st, 2023. Photos from a corrective action inspection on August 17th, 2023. And photos from my final inspection conducted on October 17th, 2023. Exhibit B, a copy of the notices of violation, a copy of the notice of hearing, and a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
What page of the agenda is this again?
13.
13, thanks. Is there anyone from the public who wants to be heard on this case? Okay, thank you. Oh, really? Okay. That's what it is. That was a lot easier than I was expecting. Thank you. What's proposed as exhibits A and B are evidence. Go ahead.
On July 31st, 2023, I conducted an initial inspection and observed tents, tarps, coolers, bike parts, furniture, clothing, miscellaneous junk and debris throughout the property. On August 2nd, 2023, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On August 17th, 2023, I conducted a corrective action inspection and observed that the property remained in violation and became worse. I have had contact with a property owner who lives out of state. Ms. Erman stated that no one is supposed to be on the property, but squatters have moved in and turned the utilities on in their name. She also stated that she has started an eviction on the squatters and that case number is 182-31540. As of my final inspection on October 17th, 2023, the property remains in violation. This property is a nuisance for the whole community, and I don't even go there alone. I have to go with a coworker for my own safety.
Is it your understanding that it presents an immediate health danger or like a sanitary matter? Is there raw sewage?
Not
you
a
can tell?
sanitary nuisance, but for the safety of the people that live and work around that neighborhood, yes, absolutely.
All right, I'd like to hear from the public. Is there anyone from the public who wants to be heard? Sir, come on up.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Robert Kane. Yes, I own Kane's Ace Hardware right in front of the property. Throughout the day, there's I could probably sit out there and see 40 to 50 people traveling in and out down Foss Lane onto this property. I've had dumpster divers in my property. I've got some pictures of some trash. They leave their trash out. There's no trash pickup, which is going to bring rats, varmints, all that. As far as the sewage, I mean, I kind of disagree because there's a pop-up trailer. Where's that sewage being dumped? There's 40 to 50 people probably living back there. Where's all that? Where are these people going to the
How
bathroom?
big is this parcel, do you know? Just curious.
I don't know off the top of my head, but I believe it's less than a quarter of an
Yeah, I was
acre,
gonna
like a
say
tenth of
quarter
an
acre
acre. It's very
max.
small.
I've got additional pictures. I don't know if I guess they've got.
It does look
I mean,
like Woodstock back there.
Yeah, I mean, here's
which
the
isn't to
pop-up
compliment,
trailer.
Although my mom went to Woodstock, but that's another story.
I mean, here's this pop-up trailer that somebody's living out of back there now that's not even part of the property. That was hauled on there maybe a month ago. Piles of trash, and then all this trash, somebody picked it up maybe because of this impending meeting. All this ended up in my dumpster last Wednesday. We called the cops. The cops have been out there 15 times. They say, just keep calling. It'll make it more important for us if you keep calling, make it more of a nuisance. Yet we're just wasting public services, taxpayer dollars and everything else on getting these cops to come out there over and over and over. I've had one of the people on the property approach one of my guys and get in his face because he was looking at him. We've trespassed him. Nothing's happening. So, I mean, just as far as the sewage, I meet my trucks there on Wednesday and Friday mornings at about 5 a.m. My truck drivers from Ace Harbor have said, I go to Miami twice a week, and I don't see this kind of mess in Miami. I mean, that's kind of bad, you know.
Miami gets a bad rap, but
I've never carried a gun. I carry a gun on Wednesday and Friday mornings now. Because I don't know that when my driver leaves and I go and lock up the store, one of these guys is going to be sitting out there, you know. So.
I hear you. Okay, well, thank you. This is a question for the county. So on similar case, I'm sorry. Are there others from the public who want to be heard? I only saw one hand. Okay.
Yeah, and I actually, the dentist's office next to me, they were supposed to be here, but she sent me an email. She said, good morning, Sal, who owns the pawn shop next to me as well. This is from Nicole Ledger, who's the dentist's wife. Sal and I went to the meeting and we were told that the case was abated because the violation has been corrected. What is the next step? Can we bring a civil suit against the property owner or the county? This situation is just getting ridiculous. My girls are afraid to come to work in the mornings. There are used needles in our parking lot. They leave the hose on and hang out behind our building, and the list goes on. I mean, they've had, beer cans left outside their building, their cigarette butts all torn through. I believe it was vandalized behind the building because they have cameras, back on their property that alerts them throughout the night.
Well, I'm not giving y'all legal advice, but I will say there is a common law action for nuisance that exists. People can, if it affects, neighbors, you can bring a civil suit.
Okay.
Is that the extent of the public input? Sir? Yeah, I'd like to hear from you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Josh Wooten, and I'm here as the CEO of the Chamber of Commerce, just to back the business owners there. They've even contacted us, and I think we can all agree that this is not an appropriate activity, especially when you have a multi-million-dollar investment in the area. I know there's a societal problem, but it shouldn't be Mr. Kane's problem or his neighbor's problems. And this lot owner is being totally irresponsible. I think they're degrading the value of the surrounding properties. And yes, it is a safety issue, and it's a manpower issue of all the people that have to go out there. So I think y'all have an opportunity to send a message today that this cannot go on any longer. And we appreciate your consideration.
Thank you. Question for the county. So on similar cases, I have attempted to get creative and award the county kind of police power, injunctive power to go in and clean the properties up. Has that ever been used by the county? Okay.
No.
All right. I don't know. What does the county want on this case?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative costs, begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask that the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
You have ordered that before, Christian, but, excuse me, Special Master.
I'll
Mr.
survive
Rock.
believing.
They have abated prior to,
Really?
to that order.
On
Yes.
those cases, they
Yes.
abated?
So that, it has worked.
That's
Yes, sir.
shocking. I'm trying to remember how I phrased it. Okay, here's
I
what.
believe one time you said we could enter with law enforcement.
Yeah, yeah. I mean, I think I have the authority to do that.
Yes.
All right, so I will find the property in violation. I will grant 7 days to fix the violation. If it's not brought into compliance as ordered, a fine of $350 per day will be assessed. I'm deviating from the county's recommendation due to what I consider the seriousness and the gravity of the situation. I'm convinced and persuaded by the public. And in the photos, I think it's very likely a big problem. I will also grant that if it's not brought into compliance within 14 days, that the county has the ability to go forcibly clean the property up itself, to bring it into compliance, I should say.
Would that mean to treat it as a slum condition?
I'll write the order up.
Oh, okay.
Yep.
Okay. All right.
And would that include removal of the mobile home?
Yeah.
If it's a violation, then yeah.
Thank you.
Okay,
Thank you.
Thanks.
Next case on today's agenda, Carissa Bellinger, case number 2023-00361, Code Officer Brandon Norman, page 7 of your agenda.
Yeah, it's Irish over here. Okay. Thanks. Good seeing you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your names for the record.
Carissa Bellinger. Carissa Bellinger.
I heard you.
Okay.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is case number 2023-00361, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is 365 South Snap Avenue in Inverness, Florida. Property owner listed as Carissa Bellinger. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 7th, 2023, a corrective action inspection on August 11th, 2023, and my final inspection yesterday, October 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as photos of the posted notice of hearing at the property.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
We cleaned up everything. We got a few things left. Everything is completely cleaned up from what these pictures show.
How much time would y'all need to complete the process?
A week, but we're gonna ask for 2.
Okay.
We're busy working.
Listen,
And I know
join the
it-
club, so,
It gets accumulated from, I also scrap on the side. I do trailers of scrap,
Yep.
so I also leave it in my yard for a day or two and decipher from there.
No objections.
Okay.
No objections.
All right.
Yes.
It's a lot of pictures.
I mean, you've already conceded, but I have to satisfy myself that there's a case here, so I
sir.
wait to see the photos.
If you can ask Mr. Norman.
The Ford's
There are substantial changes from the first photo to today.
All right. Thank you. What's been proposed as exhibits A and B are evidence. It is certainly well documented. Go ahead.
On July 7th, 2023, an initial inspection was conducted at the property for a complaint of junk and debris. The property was found to be in violation of the ordinance that I mentioned above. It remained in violation of my corrective action inspection on August 11th, 2023. I have had contact with the property owners, and they have made some significant progress towards coming into compliance. And I do believe that with the time that they requested, they'll meet that requirement.
Yeah, I mean, I see substantial improvement based on your really extraordinary documentation of the case.
I didn't realize it was so many photos until I printed it off this morning.
It was a lot.
So,
All right. I'll grant you 21 days to bring the property in compliance. The
Yes, sir.
property is in violation. If the property is not brought in compliance as ordered, what's the county's recommendation?
the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day, along with administrative costs to begin after the date that you deem sufficient. This amount was selected based on the actions of the property owners. Once they were advised of the violation, this amount is appropriate given the severity of the violation as well as the respondent's actions relative to this violation. We'd also ask that the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, so based on the fact
Call
they've
them
already
when we're done.
cooperated so much, they're recommending $50, which is the lowest they've ever recommended. So if it's not brought into compliance as ordered within 21 days, a fine of $50 per day will be assessed.
Yes,
Okay?
We'll be
Thanks.
done before then.
Good luck.
Thank you.
Thank you, sir.
Thank you, Mr. Norman.
Next case is on today's agenda. Gerald C. Kroll, case number 2023-00164, and case number 2023-00850, pages 23 and 24 of your agenda. Code Officer Brandon Norman.
Did we call for both cases?
Yes.
Okay.
Yes.
Yeah, if it's okay with you, sir, we do have two cases at the property. I'd just like to
Yep.
present them both.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Gerald C. Kroll.
Thank you, sir.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00164, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. We also have case 2023-00850, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address listed is 7327 East Gospel Island Road, Inverness, Florida. The property owner listed as Kroll Gerald C. I have good service via signed certified mail return receipt for both cases. Exhibits A will be a little bit different. They have different dates for the photos, and I'll explain. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A for 2023-00164 will be photos taken during an initial inspection on June 5th, 2023, the corrective action inspection on July 14th, 2023, and the final inspection yesterday, October 17th, 2023. Exhibit A for case number 2023-00850 will be photos taken during an inspection on September 12th, 2023, the corrective action inspection on September 26th, 2023, and the final inspection yesterday, October 17th, 2023. Exhibit B for both cases will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Okay. Mr. Kroll, I'd like to ask you to look at these documents and just
Yes,
let
sir.
me know if you have any objections to
Thank
them
you
being
very much.
evidence.
This is it's oh, yes, thank you. Mm-hmm, thank you.
think what we'll do is actually break at 12:15 and come back at 1. I'm sorry?
Chevy Tahoe, it's a police officer.
Is there a Chevy Tahoe out there?
Just be careful at Wawa.
Yes.
No.
It's not one of the Ford, the usual Ford, it's a Chevy Tahoe, so
Well, I
it's
think there's
black.
enough time.
It's black.
Yes, sir. I accept.
Yeah, any objection to those documents?
No, they're actual pictures of my
Okay.
yard.
All right.
At the beginning, there's.
Right.
It's changed a lot. I've cleared up a lot on there. And, I'm still working on it every day.
No, that's fine. We'll get into that. I just want to see the photos myself before we get into things.
That's right.
All right, thank you. Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence.
On June 5th, 2023, an initial inspection was conducted of the property for a complaint of junk and debris. My inspection found the property to be in violation. I also observed a violation of the lawn ordinance at the time. I was unable to make contact with the property owner due to how overgrown the property was. I couldn't get to the front door. I was contacted by the property owner once they received the notice of violation for the junk and debris. In that conversation, I gave him a verbal warning for the lawn ordinance as a way to kind of encourage to bring everything into compliance. I observed little change at my corrective action inspection on July 14th, 2023 for the junk and debris violation. I did speak to him again. I gave him additional time to bring the property into compliance. And on September 12th, 2023, I issued a notice of violation for excessive growth and accumulation of vegetation matter due to the lack of progress that I observed at the inspection. I did observe some change at my corrective action inspection for the overgrowth on September 26th, 2023, but it was still, the majority of the property was still in violation. As of my inspection yesterday, October 17th, 2023, the property remains in violation. I've had extensive contact with the property owner, and we've gone in great detail of how to bring these violations into compliance.
Is there like an attempt to cover the junk stuff?
From my conversation that I had with Mr. Cole yesterday, his intentions for having the sheets and stuff hanging up is a way to protect himself from complaints, is the way he explained it to me.
Okay. It's hard to tell if the property's in compliance.
And I informed Mr. Cole of that yesterday. I was denied access to look and
All
see
right.
if the junk and debris was cleared yesterday, so.
What's the existing, you may think this is an obvious or a stupid question, but what still needs to be fixed on the overgrown lawn stuff?
There's a majority of the property that's still severely overgrown. I've kind of shown Mr. Kroll around and explained to him that these are the things that need to be brought in compliance.
Some of them look like bushes, some of them, so I'm just trying to figure out where, and because some of it doesn't look offensive to me, just as a maybe a layperson, like in the front, I don't know if it's the front yard or not, but the driveway, for example, in your October 17th photos, there's a lot of stuff on the side that, like the elephant ear type stuff.
And I've talked with Mr. Krull, and we've identified some of those things.
Okay.
The things that I've identified to be overgrowth, such as like vines and stuff growing up through
Okay.
things such as weeds and stuff like that.
Okay.
I've pointed out to Mr. Krull.
Okay.
I've explained to him.
So you
Those are
have
the
an
things.
understanding of
I
that
believe
not
we do.
everything over 18 inches. is a
Exactly.
violation.
He has a variety of plants and stuff on the property. And I've explained to Mr. Krull that we don't regulate the height of his
Yeah,
plants.
some of them are very nice.
Yeah,
you know.
and I would agree.
Okay.
But it's the stuff that's not being maintained currently. It is a pretty large parcel, so I understand that the maintenance of it is pretty difficult. That's why I try to be as lenient as possible with the amount of time.
How much time do you need to bring the property into compliance?
Because I'm old.
Are you?
Sorry.
Do you think that's just a fact? I mean, you
Yeah.
expect me to believe that?
It takes me, it takes me quite a while because I've had multiple problems, cancer, and I broke my ankle because I had long COVID and it's still going on. If I don't keep moving, I got another attack. So I've been doing my best, and I'd like to thank Mr. Norman of all of what he did, especially yesterday. He filled me in of all the things in detail, which I was missing in a sense, because there are beautiful plants. It breaks my heart to have to, clean them up, and I'll show you a comparison here with some exhibits I have.
Sure.
On the thing, and I would appreciate any help I can get from y'all, but I love that garden. It's like a botanical garden of some of my friends. I've been a master gardener for many years. I got over 5,000 hours in charity work with the Cooperative Extension Service, IFAS. And I'm a veteran from the Army for 6 years, 65 to 71. I'm just not in good health anymore, so it takes me time and it's hard for me to judge. Plus, it's difficult to get help. I have excellent neighbors that offer to help me out with certain things, but they're old too, in a way, and they loan me tools, things like this, to help me out. And my leg broke, and a little over a year ago, when I was working in the garden, it took me at least 6 months before I could even walk, and that's how things got ahead of me. Plus, at the same time, we had a hard freeze, so there was nothing left, hardly. All of a sudden, they start coming back, and I just couldn't do it on there. So I have a vegetable garden. The main reason I've had it, because this garden is actually left over from my parents. It's my parents' house. I took care of them for many years. Mother died at 99. In 2014, then I volunteered at the hospital, and that's what I do yet today. I go 1 11-hour day a week in same-day surgery to volunteer for these wonderful nurses, help them out. And they keep me, it's my therapy in a sense, because they keep me real moving, because otherwise I got arthritis problems like I'm getting now, having to sit, But the weakness, the fatigue, the bleeding and dizziness from all that, dizziness. I had pneumonia in the left lung from the COVID. Let's see. I got over 6,000 hours now at the Citrus Memorial Hospital in volunteer time, and I trade plants and give plants away.
Well, Mr. Kroll, just so you know, I'm not having you arrested. You're not going to prison here.
Okay, I've never had this happen in
Yeah,
my
I
life,
know,
sir.
and I wanna put you at ease.
I traveled the world, and I never ran into anything like this.
I want to put you at ease. I mean, I don't. I value hearing about this, and I
Okay.
thank you for your
I didn't
service.
mean
I
to
know
bore
that
you.
being in the
I don't mean to-
Army from 1965 to 1971 wasn't the easiest time to be a member of the U.S. Army.
Yeah, Vietnam was not nice.
And my dad was there too. But I think as much as I value that, the real central issue here, the two things I'm interested in,
Yes, sir.
is number one, I want to know if we have an agreement on what is subject to this code section and what is not. In other
Yeah,
words,
that's the most difficult thing for me.
So Mr. Norman said he's had some conversations
And he
with you.
has. He's been very good.
Are you in agreement with what he says?
I believe most of it.
Okay,
I
where is the
think,
disagreement?
The undergrowth. See, what I have is, let me just explain it. I got the brochure here. What I do with it? When I worked with Cooperative Extension, we were taught this program, the Florida Friendly Landscaping, which I get a lot of help in. And that's what my goal is. I conserve, I do all these things. So
Yeah,
that's
listen,
what
we're
my
big fans of
case.
Florida-friendly landscaping.
Yeah, that's just sort of my case. These are all named plants. And let me see, I don't know if you want to see these. The reason the
Anything you want me to see, I need to see.
You need to see?
Okay,
Yeah.
but
Can you
show it to
please?
the county first and let's see if they have any objections to it.
Just let me get it together. Here. I think I got it all. Yeah, I got it all.
Now, I issued an order earlier today on Florida-friendly landscaping, and what I found is that in order to make a case that something is protected as Florida-friendly landscaping, I really need to have a comprehensive understanding of how it fits the statute. In other words, there's an article from the guy who probably wrote that brochure, Michael Alexa, that says, it takes a real specialist to understand what a Florida-friendly landscape is, because it has to do with water efficiency, it has to do with all these things that frankly are difficult for a layperson like myself to understand.
Yes, I agree.
I see a lot of beautiful plants in these photos, and I'm loath to say that they're subject to the code section, but the vines and things, I mean, some of that could be considered brush / undergrowth.
The vines are actually part of my vegetable garden.
Okay. What are
they're
they a part of?
yams. Yams.
Yams?
Underground, there's yams,
Interesting.
and they tend to grow sort of where they want to because the neighbor's lot has them, and I get them, and I eat them. I found out they were the edible ones. They weren't the one that was invasive on there. So you'll see the vine grow up the tree, and then all of a sudden, when it's mature underground, you get a big
That's
root.
interesting.
And then you cook it. And
I am curious, are there any members of the public who want to be heard on this case? Okay, 1, 2. All right.
I just wanted to state that, sir.
Actually, hold on. In order for me to hear from you, I have to get you sworn in, and we're not quite there yet. We'll get there before we leave. All right,
Yes.
so is there any objection from the county on this being Exhibit 1?
No.
Okay, so I'm just going to take a look real quick.
There's before and after, sir.
Okay.
On a few of those pictures where
All right, let me just take a look.
I can ID all those plants if you'd like too.
Oh, I believe you. Let's see.
Because you're absolutely correct in the complicatedness of this, because I spent many hours taking courses from the county and the university, and it is a lot to learn.
You consider yourself an expert in this?
Not an expert, but I can grow a beautiful
How many
garden.
hours of training and or research or classes have you taken in this?
Oh, a couple thousand hours.
Oh, I think that might qualify you as an expert.
on there.
That might be
But,
sufficient.
Because I volunteered for a Navy SEAL, which was also highly qualified as a training as a Navy SEAL. And he had he's a real horticulturist. And then the other one was the director. He was the director of research for Libby's and citrus. And I have a lot of citrus trees there.
Mr. Norman,
too.
have you seen these photos?
I have seen these photos, sir.
How do they relate from your perspective to your case?
I can confirm that all these plants that you're looking at, the first photo I believe is the bush with the pink flowers, and then the second photos go to the third. It's of bare ground. That's kind of referencing those shrubbery. I asked Mr. Kroll if he could just trim it back because those plants were starting to obstruct the county's right of way and the roadway. I didn't ask him to remove them all. He took it upon himself to completely remove the shrubbery.
I misunderstood. I'm
Yeah,
sorry
yeah.
about
No,
that.
no, it's okay. I just wanted you to trim them because they were bleeding into the road,
Yeah.
I
and,
see.
causing a potential hazard.
Normally, the county did that.
Yeah, yeah.
For years.
That's what
Once
he's
a year, they
explained.
run the bush hog through when they do their grass cutting.
Well,
on the edge. This year they
The
didn't.
things that are in the photos though we've discussed in great detail, and I can confirm that those are not things that I'm asking him to
Okay. All right.
to maintain or 18 inches.
Oh, we were talking about the vines, and I don't know if you heard. He said those are part of yams. So, I mean, if that's true, and he's got a vegetable garden and he's growing fruit and stuff, I mean, is that a violation of the code section?
I haven't seen any.
Have you seen yams before?
I've seen the one that he showed me. It was just that he had already uprooted. We didn't identify any of the vines or anything like that being any sort of crop yielding plant or vegetable yielding plant.
But if they are,
Oh, yeah, there's a picture there I thought of.
I mean,
In the
if
back.
there's a corn stalk and it goes above 18 inches, does that violate the code section?
That's not what we're asking to We're just asking that because I can't even traverse his property, sir. I can't even get to the front door. It's so overgrown. So we're not asking that we regulate the aesthetics of it so much. We just want it to be maintained again. I have seen from other angles of the properties. I apologize I didn't include the photo. But essentially his property is bleeding through a fence that's been erected on a neighboring property that is maintained. And I tried to explain to Mr. Cool that's probably more than likely where the complaint originated from is for the fact that it's now pushing through their fence and it could possibly cause damage and stuff. We talked about trees and things of that matter, and I've explained to them.
Neighbors have the right to trim back to the property line.
I've informed them of that as well. But I was just trying, because he was trying to understand where the complaint originated from. And I said, to be honest,
I'm sure. I mean, everyone wants to know that.
And we talked about, because I know there was an argument of trees too while I was out there, and we talked about the diameter of trees and, how anything over 4 inches, I'm not going to ask him to regulate, but a lot of that stuff is it's well under the 4 inches in diameter, and so he needs to maintain it and regulate it. The fact that I can't even traverse the property, it not only poses a hazard for emergency responders in case they need to respond to the property, but just for the property owner himself. I mean, he's even admitted to me that he can't exit the front door of the property. He has to use a side door in the garage.
Yeah, before this happened, I was cleaning kitchen, doing things, and then I had to stop on doing that. So I had a lot of stuff from the kitchen and the bathroom out there, clothes and
Well, but
some
if you have
things.
stuff that's growing into your walkway and that is not a violation of the code.
No.
Oh, it's not? Okay.
So, I mean, I've seen the photos.
But the things that I'm talking about that are blocking certain, like being able to traverse the property, are things that he could regulate. They are like stuff like vines that have grown up and started to attach themselves to other parts of plants.
Okay.
I
mean, Mr. Kroll, it does. I do think that there are some. It does appear that there are some plants.
Yes, and I continue to work on it too.
yeah.
I was doing it even before Mr. Norman down there, but it just was so slow because I couldn't walk much.
What
I
I
could
would
get to
like-
my garden. And
Go ahead.
the reason, I want to explain one thing, please. The reason I put the sheets up in that because the neighbor was spraying with pesticides on both the herb line and she had a fence there, and she's killing back into my good trees, persimmons, some citrus, this type of thing, just wild. And the same thing with it. I had my transplant nursery part by the house there where Mr. Norman saw the sheets up there. It is close. I use it as a clothesline, but when she was spraying, I had to sort of avoid it for my health, and that was one way of doing it.
Okay.
on the
I mean, the thing
And,
about this code section is it's very strict, and it's very broad, and it really depends on their enforcement, their willingness to enforce it, and discretion
Yes,
on that.
and I
All right,
agree.
I want to hear from members of the public at this point. Who from the public would like to come forward and be heard? I saw two hands, sir. You're closer. I'll hear you first, and then we'll go to number two.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
My name is John Clay, and that last name is spelled with a K, K-L-A-Y.
Thank you very much.
As of about 3 days ago, my wife and I have lived on Gospel Island for 8 years, and I've known Jerry here for probably 5 years or better. And I've been on his property a number of times and walked through him with it. And I know you mentioned something a little while ago about him being an expert. Well, I would think, and I'm not an expert myself, but I've gone through his property and numerous times I've stopped and said, what is that plant right there? You know, he's got ornamentals, he's got all kinds of bushes. And the thing of it is, it's, you know, they call it overgrowth or undergrowth, whatever your term is for that. But there's no weeds, there's no high grass. They're all plants and bushes. And I went through there and he could tell me the name of every single one that I asked him. And driving numerous times up and down Gospel Island Road, there are a number of areas that are overgrown right up to the ditch on the side of the road. And it's very common. You can drive the whole length of Gospel Island Road, and that's the way it is. I know that he depends on his garden for about half of his groceries that he gets. So he's using the property to help himself. And I think he's got a neighbor who lives behind him who doesn't like the way he lives. He doesn't, she doesn't like the way that he keeps his garden. And I think that's where a lot of this is coming from. A lot of this is being driven by a neighbor that's not real happy with the way it looks. Anyway, I can't think of much else to say, but.
All right, thank you, sir. I'd like to invite you to come up and speak if you would.
Sorry. My cap fell on the floor. I didn't want to
okay.
put it back. My name's Becky Knox. Oh, can you go to the microphone, please?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And you said your name was?
Becky Knox.
Thank you.
I just wanted to state that I'm an honest person. I'm not a judgmental person. But if you need some help, I will volunteer my time, my services. With your permission, maybe we can exchange phone numbers. If anything need to be trimmed. I have.
Ma'am, I definitely invite you guys to get together, but do you have anything you want me to consider for this case as a member of the public?
Be generous with your decisions, and with permission, I'll help this gentleman take care of whatever it is
That's up
he
to him.
needs. And
Yeah. All right.
I'm decent with ladder work, and I bring tools.
All right. Thank you, ma'am. I appreciate it.
Okay.
Is there anyone else from the public who wants to be heard on this case? All right. I don't see anybody. Mr. Kroll, I think I'm willing or able to issue some rulings, but I want you to be able to tell me anything else that you want me to know.
Yeah, I got a couple items, because Mr. Norman is very concerned about, and rightly so, about the laundry line. And it's for my protection and on there because of the spraying with these pesticides. It got so bad it kills that big paper mulberry even now. It's very badly damaged. I don't think it's going to make it. And the persimmon trees, citrus trees, the blackberry bed, all that I think is in the records there.
Well,
And the
people aren't
garden-
allowed to destroy your stuff. I mean, that's a nuisance as well, I mean.
Yeah, it's hard to clean up. I even have a couple of other pictures showing that case, but my garden should be in that file there in the last. It shows the small plants in the pots.
Yeah, I saw
And then
that.
they grow up and get into the big pots, and that's what my garden produces. Tomatoes, peppers, onions.
I am not going to hold that those
mango.
violate the code section.
Oh, it doesn't? Okay, thank you. Thank you, too. Yeah, I appreciate that. The other thing was, that fence line was always heavily sprayed, so there was nothing really growing there. See, and it killed a lot of the trees and the ground cover that's back there. There's a ground cover, I don't know, about so high, on it. And that protects the area in a lot of ways because it doesn't even freeze. The other thing is it's got a barbed wire fence, so when I try to clear along there, I get stabbed. Well, sorry. Jeez. And I could show you that too if you want to see it.
If you want to introduce it as evidence, then please show it to the county and we'll see if there's any
You can.
objection.
And, I don't, this is the other section, it may not pertain, but, yeah, please, because the gentleman's so kind to review this.
You have the right to.
But you, sir, you saw the garden plot?
I did.
You did, thank you. Because that's the most important part to me. I'm gradually gonna cut way back, and I'm only gonna have garden and fruit.
I'm pretty sure under the code definition, that vegetables are not prohibited under this section.
No,
There may be another section that prohibits it, but not this one.
The co-op did give me the code.
Mr. Kroll, just to clarify, the photo you provided that has the barbed wire on the top, where is this fence? Is it on the back side, the front, left, right? Where is this fence?
It's on the west side.
Okay, and it,
Of it, and it's on her property for the most part, except a few of the posts are on my property.
so your neighbor's property is on the left side of the photo?
You see the other sheet there? You see the one that shows you there.
This one?
That's the neighbor's property.
Okay, so this
And
is
you
looking
see her-
into your neighbor's
her fluent
property?
comes out of here and kills the grass
Okay,
and stuff, and it runs into mine, but I don't mind it that much because I don't think it's toxic, it's probably great water.
okay. All right, thank you for the clarification.
Thank you. Any objection?
No objection.
This is Exhibit 2.
You can tell too on the last photo, sir. That's another one of our concerns. It's just you can kind of really see the overgrowth from his photo. That's what a majority of the property looks like on the backside.
Yeah, that's this last two or three things, that's the neighbor's driveways and stuff, and that's been like that for 20, 30 years or more.
So, I see what Mr. Norman is saying. There's a little work that needs to be done.
Yeah, those sheets in there is my neighbors, the ones in the back. with the
Oh, I
show
hear
the
you.
Driveway, that's a neighbor.
Right.
Just to show the example, that's all it is.
We're past 12:15.
I'm sorry.
I am going to issue rulings on these cases. First, in case number 2023-00164, which is the junk case. Well, first of all, Mr. Kroll, how much time do you need? I know I asked this before.
Yes.
How much time do you need to kind of clean the junk stuff up?
Oh, less than a week on there. I was going very strong, but then when I talked to Mr. Norman, he wanted, this other things done, and I sort of put the balance on. And then I decided to remove the nursery, the plant nursery, from that area, what's in dispute there, down to the garden in the back there. And I got a greenhouse in there.
And how much time to clean up what remains of the brush and undergrowth that's in excess of 18 inches in height?
That could be a long time because that undergrowth is.
I need you to give me an estimate.
Yes, it's a Asiatic jasmine I got from the co-op, and it became my ground cover. Plus, it goes up the trees, and then in late summer, it blooms, which is very unusual for it. It's Asiatic jasmine, and all these pinwheels come raining down like snow, and that's sort of the reason I kept it, because some of the gardeners that come by like it,
People love it, yeah.
And the same true with that flowers in the front door,
Is the Asiatic jasmine a part of this? Is that?
Well,
I haven't identified any plant out there to be what he's talking about.
Okay.
So
Is the Asiatic
can't
jasmine
speak on
the
that.
stuff that is commonly used in landscaping, like on people's front yards, and it blooms white?
yeah, it doesn't, if you keep it on the ground, it doesn't bloom.
Right, and if it's on the ground, it won't
When it goes
bloom.
up is when you get this beautiful effect.
And
'Cause
the
even the
smell.
co-op told me, well, it never blooms, but all of a sudden.
No, it does.
Yeah, it does when it climbed the tree. And
Right.
the other ground cover.
How much? I don't.
Oh, okay.
I really don't know that's. Man,
It's hard to clean it because it's like wire.
it
grows
is.
slowly.
It's really well. It gets unruly very quickly as well. It can explode, and it can look.
No, it doesn't grow very fast. That was there 30 years.
I've seen it grow like.
Yeah, and in the fertilized area, I don't fertilize. I use rainwater, don't fertilize, I only use compost. I follow
All
the
components
7
of
rules.
Florida-friendly landscaping.
That's right. I followed all those rules because that was pounded into me, for years.
No, you know the rules and you are an expert.
On
So
the
I
thing.
actually.
So the mulch,
Uh-oh.
the whole 9 yards. The only one I don't get involved with is the last one, number 9.
Mr. Kroll, I gotta be honest, we're at
Waterfront.
12:21. I need to
Yes.
know how much time you need
Can you give me
to,
a couple months? Because
How much- give me-
I'll do it quicker and call Mr. Norman.
can you be
right
more
away,
specific?
But
How many months? 2?
2 or 3.
You want 3 months?
Yeah, I don't know how much I can get in help. 'Cause-
Okay.
And me doing it.
What's the county, I'm sorry, go ahead.
For the junk and debris, from my history dealing with Mr. Kroll, can you give him an additional week as well? Just,
Okay.
just,
I wasn't gonna give him just a week.
okay, just,
I-
because
I-
just judging on our history and
I've
our
been through this
interactions.
before.
Okay.
All right, what's the county's recommendation on each case?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs for each case to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the special master to additionally find its respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
What was the amount?
$50.
Okay,
And What did it start? When does the $50 start?
hold on a second. So in case number 2023-00164, which is the junk case,
Yes.
okay? I'm gonna find that the property is in violation and I'll give you 1 month to bring it into
Okay,
compliance.
thank you.
If it's not brought into compliance as ordered, a fine of $50 per day will be assessed, okay? So that one's gotta be done in 1 month. Case number 2023-00850, the overgrown brush and undergrowth case. I will give 3 months to bring it into compliance. I do find the property in violation. I hope you use your time wisely, as well. It's not just a matter of clearing, it's a matter of, I think, making sure everyone's on the same page about what violates and what doesn't.
Yes, that's where I need to learn more. He's
Just
helped
stay
me
in
a
touch
lot.
with the county.
He's helped me a lot, and
Well, I've given some guidance in the
and
hearing. I think the county understands where
and
I'm
I made
coming
up
from.
some areas, which I cleared.
Yeah.
And just as a sample, like the size of this room.
Right.
And there, and he's looked at those, and
And
I think I'd let him speak on that, but.
well, I think y'all are in good
that's what I
shape.
tried
And
to
if the
do.
property is not brought into compliance by the end of the 3 months, a fine of $50 per day will be assessed on that
Okay.
case as well.
Thank you.
Okay?
Thank you very
That's
much. You're very professional here. I'm really impressed.
We don't hear that every day either, but good luck.
Thank you, sir.
So thank you very
Now,
much.
to everyone else who's here, I really do apologize. We try to get through these, but everyone has a right to be heard. So I am going to put us in recess. I have to there really aren't, people have to be able to go to lunch. There's not that many places. I'm going to do 45 minutes. So we'll come back at, let's say we'll do 1:15. All right. Okay. Good afternoon. The time is a little after 1:15. I hereby call this hearing back to order.
Next case on today's agenda, Daniel and Sherdell Tiggs, case number 2023-00499, Code Officer Amy Becker. Page 41 of your agenda.
Oh, I've just seen her come in. She's right there.
Oh. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes. Can you please state your name?
Chardell Tiggs Cook.
Thank you, ma'am.
Good afternoon.
I'm sorry?
I need my glasses. May I get them?
Oh, yeah, of course. Let's just wait a moment.
That's what I need to.
We all need glasses.
Go ahead.
Good afternoon.
Good afternoon.
Amy Becker, Citrus County Co-Compliance Officer. This is case number 23-499, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 10891 North Mataro Avenue, Citrus Springs, Florida. The property owner is Daniel Tiggs and Chardell Tiggs. I have good service via posting of the property in the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on July 19th, 2023. Photos taken on August 24th, 2023 at my corrective action inspection. Photos taken on October 5th showing the posting of the property. And photos taken on my final inspection, October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and the pre-hearing order, and a copy of the posting affidavit.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
I do not, however, I haven't seen the actual property since it was purchased several years ago.
Okay.
Is it my time to speak?
Not yet per se. I definitely will want to hear from you. I just wanted to know if you had any objection to these first. Before I turn to you, I don't even know for sure what the county's case is until they tell me. So it's useful for me to hear from them first, and then I can turn to you.
Thank you.
Okay. Okay.
On July 19th, 2023, I conducted my initial inspection for accumulation of junk and debris and observed closed debris, which is a clear violation of the ordinance listed above. As of my final inspection on October 17th, 2023, the property remains in violation. I have made contact with the owner on October 12th, and she's aware of the violation.
Okay. Now, I definitely would want to hear from you. I understand what they're saying. I've seen the photos, so.
Okay, this property was purchased between me and my ex-husband several years ago. We've divorced. I moved away. In the divorce decree, the property was awarded to him. He is now deceased. The attorney that represented me during the divorce never submitted the quitclaim deed. So everything has been falling back on me. And my name is the current name that's on the warranty deed at this time. I have maintained the property taxes since he passed away in 2012. And the intention was for him to keep the property for our two children. Well, they're adults now, but he died. So it was my intention to keep it and maintain it until, they decide what they wanted to do with it. My son has expressed an interest in it. And there are other parties that are interested in purchasing the property. Personally, I don't really want it or have any need for it, but he does. And there are some investors that are interested in purchasing, but I'm not able to sell it because we learned that there was a couple of things. This is a long backstory, but there was an estranged wife after me, and the quitclaim deed, it never got filed. So
The quitclaim deed from you to your ex-husband.
for me to give it to him.
Yeah, giving your interest
Right.
to him. Yeah.
So it never got filed.
Right.
So my name still remains on
Do you know
there.
if it exists anywhere?
I tried to reach the attorney that handled my divorce. It was several years ago. I
Okay.
cannot.
Okay.
And the other thing is that I live in Georgia now. I live in Atlanta, and the property is here. I've not seen that property since we bought it several years ago. I really can't control people dumping on it, and I'm not negating my responsibility for it. It is mine, I guess. I'm also.
I don't know whose it is, to be
I was
honest
just
with
getting
you.
ready to say, I'm
Yeah.
also in the process to trying to determine who it belongs to.
Right.
I'm the one that they were able to find, locate, because my name is still
It's
attached
on the property
to it.
appraiser website.
Right.
Yeah.
So I'm in the process now of determining what I need to do to remove the deceased owners from the deed
Well, let me just
itself.
ask you this. I mean, I understand there's an issue with all that, but according to the photos, there's really not that much.
No,
I mean,
it doesn't.
Becker, what do you? I mean, is this all there is from the photos? Basically, is that all there is?
Yes.
I mean, you could clean it up in 10 minutes.
Oh no, I intend to do exactly that.
Yeah.
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 I intend to do that exactly that. But my issue is, whose is it? I mean,
Yeah. Well, this happens a lot. I mean, honestly, it's not the first time that something has come before me and someone has basically dumped stuff onto someone else's property and then it becomes their problem. It happens fairly often. Sometimes it becomes the owner's problem. Sometimes it doesn't. There's all kinds of nuance with that. But don't know. All I can say is that there is a violation on the property. It's just like it would take minutes, literally minutes to clean. And the thing about that is that it gets it off of at least my radar. And I wish it would get off my radar because, in terms of the ownership issue, I really can't help you. I have no idea what you're going to have to do to sort that out because
I'm trying to do some research about how I can actually make it mine.
I mean, I know what you have to do, but I'm not your lawyer. So I would encourage you to consult one and figure that out. Yeah. No, there's ways. I mean, and I hope you do.
That's not costly.
Yeah,
I'm sure it will be. But
if that I can't tell you.
I've been told that I have to do a quiet title.
I would. I mean,
that was my
that's
next
not
step.
I'm not your lawyer. I'm not giving legal advice, but I mean that's the usual method for doing
quiet
that.
title. So I have that. I'm looking into having that done, because if I do that, then I can sell it, because I really have no interest in it. I don't want it. I mean,
Well, it sounds to me that either the quitclaim deed wasn't properly delivered,
Right.
and therefore you are the sole owner of the property because that deed was ineffective, or possibly the deed was conveyed. It doesn't sound like it was ever recorded. Maybe it was conveyed somehow, and now it's perhaps owned by the children. I don't know, but there's all kinds of scenarios. I'm not going to get it for my purposes. I'm allowed to rely on the property appraiser, like I believe the county is. So I mean, it's my intention to find a violation on the property, to give enough time to just clean up. I'll give more than 10 minutes, but that's what I'm planning on doing.
well, I live out of state. I don't know. Now, Amy has given me some people that I can talk to about cleaning it up, but I do live out of state, and I don't know, I'm not familiar with the area. I'm not familiar, I don't even know where that place is, that property is. I just pay the taxes.
Well, how much time do you think you need if you want to fix it?
Well,
30 days? 30 days?
That works. I can probably get it done in 30.
Okay.
Unless
I
you
mean,
want to give me more.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs beginning after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I mean, I don't think this would take 7 days, but I don't know how long it takes to recruit people, so I'll give 40 days, and if it's not brought into compliance within 40 days, a fine of $50 a day will be imposed on the property.
Will I get something in writing to
Oh, yeah.
reflect that
Yes, ma'am.
today?
No. No. I'm not that quick, unfortunately.
Okay.
Yeah. No, you're very quick. But that's it. Thank you.
Thank you.
Good luck.
Next case is on today's agenda, Kenneth Stewart, case numbers 2023-00816 and 2023-00817. Code Officer Amy Becker, pages 39 and 40 of your agenda.
Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Your name, please?
John O'Donnell.
Thank you, sir.
Are you, and in what capacity are you?
I'm the tenant.
You're the tenant, okay.
Of the home, yeah.
Go ahead.
Okay, these are repeats. You want them both together?
I do.
Okay. Case number 2023-816, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. It's a repeat violation. The property owner was previously adjudicated guilty of the same violation at the same location on June 16th, 2021, case number 2140512. The violation abated on July 28th, 2021. No fines were imposed. Also, case number 2023-817, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner previously adjudicated guilty of the same violation at the same location, June 16th, 2021. Case number 2140378. The violation abated on July 28th, 2021. No fines were imposed. The address for both is 2 Utah Street, Beverly Hills, Florida. The property owner on both is Kenneth Stewart. I have good service via posting of the property and certified mail return receipt for both cases. I would like to authenticate the following documents and request that they be admitted to evidence. For both cases, case number 816 and 817. Exhibit A, photos taken during my initial inspection and posting of the property on September 8th, 2023, and subsequent inspections on September 15th, September 19th, September 25th, October 10th, October 13th. Sorry,
I missed after the 19th.
I apologize. September 19th, 2023, September 25th, 2023, October 10th, October 13th, and my final inspection on October 17th, 2023. Exhibit B, a copy of the administrative complaint and notice of hearing for both the repeat violations, a copy of the pre-hearing orders, a copy of the posting affidavits, and a copy of the return mail return receipt signed for both cases on September 18th, 2023. Exhibit C, a copy of the findings of fact and order acknowledging compliance for the previous violation for both.
And so is this the same Exhibit A for each case?
I tried to lessen the photos for the vehicles.
Okay, so they're different.
There'll be less photos. They're different.
Okay. Sir, I'd like to ask you to take a look at what she's going to give you and let me know if you have objections to them being evidence.
This is the junkyard.
Yeah, we're good.
Okay. Have you given both of them?
Other one's coming. Vehicle.
Yeah, it's the place. It's all good.
Okay.
Yes.
Okay. me just take a look at them real quick.
Yes, sir.
Well, I mean, what's, are you guys running like a world simulation or something? I've never heard that before.
Oh, I thought that was your fan. I'm like, that thing is going.
That fan is blowing out some air.
Are you considering the like the logs junk?
No.
Okay. Okay, well, I mean, go ahead.
Thank you. On September 8th of 2023, I conducted my initial inspection for unlicensed vehicles and accumulation of junk and debris. As far as the unlicensed vehicles, there was 2 vehicles, a pickup and a blue car. The blue car had no plate on it. And then as far as the junkyard conditions, I had discarded furniture, vegetated matter, tires. And I spoke with the tenant, who is here today, and advised him of the violation. I also contacted the owner, Kenneth, left him a voice message, let him know it was a repeat violation. To make a long story short, it came into compliance on September 25th. The property came into compliance. There was a fence resurrected in the back. So on September 25th, the junkyard condition case 817 was in compliance. And on September 25th, case 23-816, the unserviceable vehicles, they were both removed and it was in compliance. I checked back because I have to check twice a week or a certain amount of time. So the unlicensed abandoned vehicles stayed in compliance. So October 10th, 13th, 17th, it stayed in compliance and it's in compliance as of yesterday. The junkyard conditions, when I went out yesterday for my last inspection, the 17th, if you look at the photos, the fence is up. The only thing that I saw was there was some scrap metal that was not contained on the left side of the house.
So are you saying that as of yesterday, it's not in compliance again?
Yes.
Solely because of the scrap metal?
Yeah, it's just a few pieces of aluminum that's going to the scrapyard. I was actually gonna go today, but I don't see that happening now.
I just want to, is that the only
Yes.
non-compliance? Okay.
Yes. And he had the vegetative matter too, but I realize you have a lawn, he mows lawns.
Yeah, I do
So
landscaping,
I'd like to give some leniency there.
Yeah, that'll be going to the
I was assuming that
today.
it would be gone within a couple of days.
All right, well, Mr. O'Donnell, anything to say?
I've got rid of the cars. Like she said, I had put up a fence, because I had to remove partial piece of the fence because I was in an easement.
Mhm.
I just ran it to the neighbor's fence, which you can't do apparently. So I had to take section of the fence down temporarily, and now I, finally got some money together to put up the rest of the fence, so it's completely fenced in the back now. And that little bit of aluminum that's on the side of the house, that's going to the scrapyard this week. So
What is the county asking for?
So as far as case number 2023-816, the abandoned unserviceable and unlicensed vehicles, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with administrative costs to begin on September 8th, 2023, and continue until September 24th, 2023, which would be 17 days for a total of $2,550. That's the lowest. And then as far as the junkyard conditions, case number 2023-817, accumulation of junk and debris, I would ask the Citrus County Code Compliance Division respectfully request that the special master assess a fine of $150 per day along with administrative costs to begin on September 8th, 2023, and continue until September 24th, 2023, 17 days, totaling $2,550, and a fine of $150 per day from this day forward until the violation is abated. Today is the 18th.
So you're not asking for a fine for yesterday?
No, I mean, I'll give him that. I mean, I believe him when he says.
Okay. Unfortunately, legally, there's not a lot of gray here. It is what the code says. That is the lowest repeat violation fine.
I've complied with everything. I think that's absolutely ridiculous. $4,000 because I had a couple of cars.
It's
and some
required
junk
under
in
the
my
law.
yard. It's
required under the law.
ridiculous.
And that's the deterrent to make sure that a repeat property doesn't violate again. All right, in case number 202300816, I'll assess a fine of $150 per day for the days that the property was not in compliance from September 8th to September 24th. And in case number 2023-00817, that fine will be very similar, same amount from September 8th to September 24th. No fine is being requested for October 17th. But from today's date forward, there will be a fine of $150 per day to the extent it's not brought into compliance. So when it is,
It will be later today.
then please just call the county.
And then
Yep,
how long is that
I'll
gonna
try to
take?
make it out this afternoon or tomorrow.
Okay, that's it.
Next case on today's agenda, Rolando Carrillo and Malte Ventura. Case number 2023-00086, Code Officer Brandon Norman, page 10 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Rolando Carrillo.
Thank you, sir.
Welcome.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00086, Development Applications Applicability, violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Code, or Citrus County Land Development Code. The address is 3687 South Chicory Terrace in Inverness, Florida. Property owner listed as Carrillo Rolando and Ventura Malte. I have good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 7th, 2023, and the corrective action inspection on August 11th, 2023, as well as photos from my final inspection conducted yesterday, October 17th, 2023. I also have aerial images from the Citrus County Property Appraiser website for December 2021, November 2022, and July 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as photos of the posted notice of hearing at the property.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them. Okay, thank you. I guess without objection, these will be exhibits A and B. Go ahead.
On July 7th, 2023, an initial inspection was conducted of the property for a report of site modification without permits. The property was found to be in violation of the above ordinance due to not having any permits issued before the removal of trees from the vacant lot. The aerial photos show that the trees were removed between November 2022 and the day of my first inspection, which would be July 7th, 2023. I have had contact with the property owner, and we have discussed the violation and the options to bring it into compliance. As of yesterday, October 17th, 2023. No permits have been applied for this property.
All right. What's going on?
Good afternoon, Your Honor.
Good afternoon.
What do you call it? I've been in the process of getting my permits, and I just did. I've been waiting on my blueprints and stuff, and I've got the application and the permit number. I
Okay.
just did that while we were at
You already
lunch.
pulled the permit?
Yeah.
Okay, is the county aware of this?
I just did that just this afternoon.
Okay, gotcha. All right.
Okay, so I just did that, and I did
Wait,
what I
you,
did.
you applied and got a permit at lunch?
Well, I got it right here.
Okay. I was gonna say that's the fastest I've ever heard. That's
Quick
you
turnaround.
guys are
That was a quick
good.
turnaround. I'm good. I know
all
I'm
right.
good.
Okay, so I mean, but you understand what the county's saying.
Yeah, I removed trees and before getting permits. But I tell you what, that area there, and he knows it because he's been out there before. Even just getting access to the property, the roads and stuff, you have to clear to get to the property. And you know what do you call? I didn't even realize that clearing the road, I wasn't even allowed to do that to get to my place. So
You know, I don't think I could count on both hands how many times, we've had cases like this. So this is a well established thing that I've had to deal with over the years. And it's one reason why the code section has changed over the years. It's become clearer to make it more obvious. But it is what it is. I understand that, I'm not going to punitively punish. It's not like you intended to ruin the world or something. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,500 along with the administrative cost to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. And the reason why we did $2,500 is due to the fact that when I had contact with them, they did express that they did intend to develop the property. They weren't aware at the time. They explained to me that they weren't aware at the time they couldn't clear the property prior to pulling a permit. So we had a bit of an educational kind of discussion as to what was
It's
actually
a shock to a
allowed.
lot of property owners that you can't
It
take
is.
trees down on your own property. You own it with a warranty deed, and it's
It is. They've expressed remorse for not following the proper procedures, and it seems like
How
they
big
are
is this
taking the
parcel?
steps.
So 1.2 acres. It's over a little bit.
Looks like a good size.
But it's a large amount of trees that were removed as well from the parcel. So
All right. Well, you've seen how these things have gone already. Is there anything else you want to say?
No, I just asking for lenience in the court. I'm going to be spending a lot of money there, and if you could help me out with anything, I would appreciate it.
I would, but I want to stay consistent. I want to try and treat people equally on the same violation at the hearing if I can. So what I'm going to do is I am going to assess a $2,500 one-time fine, and that's it. That's it. Okay?
No problem.
All right,
Thank you.
Thanks.
Next
Have a good
case
day.
on
You too.
next case on today's agenda, Becky L., Brandy S., and Ron A. Knox, case number 2023-00307. Code Officer Brandon Norman. Page 22 of your agenda, expert on the case, Joanna Katu, Land Development Director.
I've already sworn you
Yep,
in.
already
Okay.
sworn in.
okay.
Go ahead.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 2023-00307. Special requirements for all accessory structures, a violation of the Citrus County Land Development Code, Section 3102, Section A. The address listed is 11521 East Head Court in Floral City, Florida. Property owner is listed as Knox Becky L., Knox Brandy S., Knox Ron A. I have good service via posting at the property in the Lake Canto government building, and I would like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during the initial inspection of June 28th, 2023, my corrective action inspection on August 3rd, 2023, and photos of my final inspection done yesterday, October 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, and photos of the posted notice of hearing at the property.
Ma'am, I would like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Yes, I am not denying any of it. He was very professional, very explanatory, just, like I said, I'm not denying any of it. I'd rather I have something to say, and I have more of an explanation, kind of, so to speak, and I can
You
kinda-
have a right to be heard. So I mean, if you have something to say, tell me.
Okay, yeah, speak freely.
I don't know if I'm joking.
Well, kinda.
Could you? All right. Let me first. Let's walk through this, and I'm not hearing.
Because really, all I have there is it was a fifth wheel, and I have a legal registered vehicle that's in the back right, and then I had another vehicle that I've been working
Oh,
on.
Miss Knox. I mean, I don't even know what their case is yet.
Okay.
You're telling me some, I'm sure, important information, but I don't have the context because I don't really know what their case is yet. So let me take a look at this, and
Okay, I was just trying to explain as a whole where
I want
it's
you to
where-
explain if you can. I'm not prepared to understand it until I know what they're
Okay,
saying first.
yes, sir.
Thank you. Okay, so what is the county saying, first of all?
The violation is for storage on a vacant parcel.
Okay, meaning that there is stuff being put on a vacant piece of land. I assume it's zoned residential, and there's no principal use, no house, that's been built and permitted, and
We did have a prior case on this address. The principal use that was there was demolished in 2016.
oh, okay. So was it demolished pursuant to the prior case? It was blight or, okay. Same owners?
Same owners.
Okay, all right. So Ms. Knox, I would like to hear what you have to say. I get it now.
Okay. First off, I am the only one that's responsible for this. The other two owners, they live. It was grandfathered in, and it was there for us if one of us kids needed a place to pitch a tent. So I just happened to be that one this year or last year. Anywho, it does look a little messy at this time, and it's usually been well maintained and cleaned throughout. It's on a dead end street, and I only have two neighbors, and we all get along, and so we're not. Anyways, like I said, the one vehicle is registered, insured, which the camper had burnt down. So right now, it's the remains is still standing. Up under the white tent carport, it is a vehicle that has been there and is a good decade or so. I've off and on worked on it. It's kind of special, something to me. I'm not quite sure what to do with that right now.
So it makes sense to you though what the county's saying, which is that
Yes,
it's a
I
vacant
understand.
parcel, so without the principal use, you really
And-
can't have anything on the property. Does that make sense?
Yes, sir.
Okay.
Okay, the RV, it is still connected to a septic. It wasn't just sitting there. I did lie to you. I was staying it. I apologize. I was scared. I didn't know what to say. I've not cleaned up the burnt mess of it yet, which honestly, I really could get it done in less than a week, 3 days. Besides the frame of the trailer, it's big, it's a gooseneck. You need an extra plasma cutter, big ass generator, cut it up. And I'm still paying $1,100. I still need $1,100 before I get the title to that RV. I do have $300 or $400 at the bank to get caught up on my property taxes. I was saving it for my driver's license, actually.
Property taxes aren't your issue in this
I'm
hearing.
aware of that.
Yeah.
But,
So at the end of the day, the most important thing that I need to know is how much time do you need to get everything off the property?
Could you spare me a month? I did recently find out that the trailer itself is actually rare, and I'd like to see if I can get an estimator out for it. I'm still trying to figure out how I can, anywho, will you grant me 30 days?
Okay. Let me just ask the county, based on the representations that have been made, does the county have health, safety, sanitary concerns?
Due to the recent information that was just explained to me, the county would have a reason for
What are
concern. For the septic being hooked up to the RV, especially if the RV is derelict and burned down in a manner that it is. There's no telling if that septic that it's hooked up to is now safe. I mean, we're going to have to talk with other agencies
I
to
mean,
see if
I
we can
can
inspect
spend
it.
$20 and buy some 4-inch caps for it and just cap it off. It's
Ms. Knox, what they're saying is that it's a danger to you.
Yeah.
So
I just don't know the extent of it until we work with environmental health to determine what sort of issues it poses. I mean, I spoke to her several times, and she did tell me that she wasn't staying there, so that's why we didn't pursue it earlier. And I didn't see any signs that a septic had been hooked up, so I wasn't able to get those other agencies involved at that time. But with the information that we have now, I think it's very pertinent that we at least notify them and have them inspect the septic that it is hooked up to determine if it is a safety or health concern. But as of right now, with the information we have, it is.
what does the county want me to do? And do you need time to talk about it?
I mean, we don't know if it's a safety concern yet until the environmental inspection is conducted to see where the waste may be going. So.
I mean, I personally have dug it up and looked at it, and was really hardly ever. It's probably even dry.
Is there anyone from the public who wants to be heard on this case?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you go to the microphone, please?
Hi, hello, my name is Frank Ryman. Her septic is a cement system, and there is one pipe that leads to where the camper burned down. It would take one cap to cap it. I am a 40-year retired union carpenter, not a plumber, not environmental protection, but I know the system that's there. I just bring Becky here today to try and help.
Okay.
Becky's basically homeless. She's been staying with me here and there.
Okay.
So thank you for your time.
All right, I appreciate it. It's easier, for me when there's not a health safety concern. But based on what I'm being told, it sounds like it's more the purview of some other department and not mine. So I'm going to leave that to you guys to figure out. And in the meantime, what's the county's recommendation on this case alone?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find that it's the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Normally, Ms. Knox, I would give you more than 30 days in a situation like this because I'm not convinced that this can be fixed in 30 days, especially given your situation.
Really, all it is, that pile of trash, it's really only like a 6 by 10 or 11. That's one trip to the landfill.
Okay, well, that's good because I'm only going to give you 30 days.
Burnt debris.
I am going to give you 30 days as you requested. I am concerned about the health safety situation, and if it's not brought into compliance within 30 days, there will be a fine of $100 a day.
I mean, I can't afford $75 permit this week, but I can have it done and left open for the inspector to inspect it.
Okay.
And the county will work with the other agency to
Okay.
really determine what the extent of it is. That way we can.
Okay.
We can come up with a plan of action.
I'm in the
to bring
dark,
it to
so
compliance.
good luck.
I have what would you suggest for me to do with my one vehicle?
All I know is you can't store it on a vacant parcel without a principal
I mean,
use.
I do have city water. I just.
Ma'am, that's all I can tell you. I would work with the county to figure out where you can put a car.
Wow.
Yep.
Okay.
All right.
Thank you.
Good luck.
Next case on the day's agenda, Luke Thomas Lloyd, case number 2023-00706, Code Officer Julie Wilkinson, page 26 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
Alex Graves.
Luke Lloyd.
Thank you.
Good afternoon.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2023-00706, Animals as Pets, a violation of Section 3730B of the Citrus County Land Development Code. The address is 4840 West Peters.
I swear to God, if you guys are trying to keep people from having adorable animals as pets. Okay, go ahead.
4840, the address is 4840 West Peters Lane in Homosassa. The property owner is Lloyd Luke Thomas. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection, August 24th, 2023. Photos from a corrective action inspection on September 7th and 25th, 2023. And photos of my final inspection on October 17th, 2023. A copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Okay, sir and ma'am, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them being evidence in this hearing.
Our objection is that we were never noticed, or we were never notified of a notice. We just got the court appearance.
Okay.
And had we gotten the notice of violation, we would have corrected it immediately. Because we
Okay.
have done that for every code
So
violation we've had.
You didn't get the notice of violation, but you got the notice of hearing.
Yes, and that's how we
Is,
knew.
how did you get the notice of hearing?
It was mailed to our
It was
address in Orlando. And we,
Okay.
yeah. So as soon as we got that, we came up here because we were confused that we had a court hearing about something we didn't know.
Okay.
Yeah.
Okay.
But other than that, no, these photos are fine. You want to look at them? Are some of these from when you came for the corrective action of the chickens that are in the actual coop? Okay.
So what I'll do is I will construe that not as an objection to those documents as evidence, but as a comment on the evidence that, improper notice.
Okay.
Is that, I mean,
Yeah,
you
that's-
are alleging improper notice?
Yes.
Okay.
So this is proof that they got this?
No, this is proof for the NOA. Yes.
We've had multiple code violations called on us. We immediately taken care of it. We would have done your job.
I'm assuming that there are people from the public who want to be heard, and if so, I would just ask that you wait patiently.
I can hear them behind me.
Was it sent return receipt? Yeah, because it was at the bottom. Okay, so it never came back as receipt. So instead of sending it up again, they said it was right. So this is a repeat violation.
All right. Let me just take a look at these real quick. No more than 4 poultry hens may be on the property,
Yes, sir.
and no roosters
Hens.
allowed on the property?
No roosters, that's correct.
So the issue with notice, with a quasi judicial hearing like this, is that if you end up getting one of the notices, or if you show up, then the issue of prior notice is waived because you're able to make a presence for yourself. You're able to make your position heard, and that's what enables you to have due process in a hearing like this. So my function is to make sure you have due process. Now, if I assessed an automatic fine from the day you should have had that probably would not be illegal, okay? But I'm not doing that.
Okay.
So I'm gonna overrule the notice objection because you're here and you have due process.
Okay.
But I am interested to hear what the county has to say on this. Those animals look great.
On August 24th, 2023, I conducted an initial inspection and observed multiple chickens, more than 4 hens, and a rooster on the property, as well as I heard multiple roosters crowing while I was standing at the property line. The chickens seemed to be congregating near the fence on the property line with the neighbor. On August 24th, 2023, a notice of violation was issued for animals as pets, which is a violation of the ordinance listed above. On September 7th, 2023, I conducted a corrective action inspection and found the excess chickens and roosters remain on the property. On September 25th, I conducted another inspection at the request of the property owner and found that the roosters and excess chickens have been removed from the property. I have had contact with the property owner. In March of 2023, I had another case number 2185703, for the same violation. This case was abated when the PO had the chickens and roosters removed from the property. This has been an ongoing issue and nuisance for the neighborhood over the past year, with the property owners removing the roosters and then bringing them back after the case is abated and closed. For this reason, this case is being brought to the special master even though it has been abated.
What do you want me to do?
I would like to have for you to assess a fine for the administrative costs. And so that this can get on a record, so that way if roosters do come back on the property, it can be treated as a repeat.
So you want me to find that a violation did occur,
Yes.
that's abated, but
Yes.
that it did occur, and because it occurred, they should be liable for the administrative costs?
Yes.
I mean, is that the county's position? Okay.
Yes.
And the reason why the county's requesting this is because there've been prior issues?
Yes.
Okay. Let me first understand, what are they allowed to have on the property? I mean, clearly not roosters. Is that an acreage or a zoning, or both? It's both?
They've loaded into residential a little over an acre, so they don't qualify under the animal schedule for animals such as hens, roosters, etc. The animals as pets that she's talking about is 4 hens only, no roosters. That's when you don't have the acreage to be under the animal schedule, so the roosters can't happen at all. 4 is the max on hens as personal pets.
Does that make sense?
That does. The chickens that were in our yard that she noticed the second time she came back, we had given them to the neighbor next door because he has 2 acres. So he was allowed to have them. But we have agricultural fencing, so they would come back and forth between our houses. And we did not mind them being in our yard. But now, to not deal with any of this, we have now rehomed every chicken except 4. Because I knew this was going to be an ongoing issue with our neighbors constantly calling code on us.
Okay. All right, well, there are members of the public who want to be heard, so you have that right. I'd like to call, if you could come over here to this podium.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your names, please. Roxanne Santos.
And Jimmy Santos.
Please, let me know
I
what
do
you
have a flash drive.
Oh.
Okay. And this has been going on for quite a long time.
Okay.
Okay. He's nothing but tormented me with these animals, and then my wife is very sick. Okay. These animals never left that yard. I'm very next door to him. I've been there for 7 years before he moved in 3 years ago. okay? My wife's a very sick woman, and they put us through hell. Read these letters.
Wait, hold on one second.
I want to
I
turn
wanted
these
to say
over to
something.
him.
Your Honor, I wrote them a letter prior to going to, code enforcement to try to make things better. I have it here, sir, and I'd like for you to read it. This is even before I've been called any code enforcement.
So when members of the public have evidence, it needs to come from one of the parties. So if you want to introduce it into the record, I don't mind you reading it. You can testify to it.
Yes, sir.
Okay? But I can't admit it unless the county wants to introduce it as evidence for some reason. I doubt they're going to do it. Okay?
May I read it?
Yeah.
Mr. Lloyd and Mrs. Graves, as you are aware of, the chickens on our property have gotten out of your yard many times and entered into our property. Due to their conditional presence on our property, Roxanne has to keep looking out our windows to check the yard for the chickens, as we have to leash our dog on our property to take him out. One such presence of your chickens on our property caused a pretty serious injury, as our dog took off to chase them. We have tried to civically communicate with you to keep your chickens off our property to no avail. It seems instead of trying to work together for a situation, we have continued to allow the chickens to trespass onto our property. Furthermore, it has come to our attention that you have been gossiping to our neighbors about our personal information, for which we do not actually know the history. On April 11th, 2023, Mr. Lloyd presently he stopped Kevin, which Kevin was a tree service in the middle of the road, and told him that Jimmy was peeping Tom. Mr. Lloyd has also told neighbors that Jimmy had been staring out the window of Mrs. Graves. I assure you that no one is peeping at Mrs. Graves. It is Roxanne, myself, looking out the window to check to make sure that the chickens are not out of our property again before letting the dog out. We do not want our dog chasing them or probably hurt them. In addition, we do not need anyone's permission to look out the window of our home. To take things even further, the FJS that you put on your van facing the property and shooting guns off in the middle of the night is just outright harassment.
I want to get this evidence.
Well, here's the thing. That doesn't sound like it's related to this case.
Yes, it is. Everything's related to this.
Shooting?
Shooting the gun because she was out that day.
Sir,
Okay,
just
let
hold
me
on.
explain.
You will have a chance. I will definitely give you a
Let me
chance to
explain to
respond.
you. The day that she told him that he was in violation with the roosters and the chickens, he came out on that day on the 18th, did he not? Did he not?
Now, sir, this is your chance to
Okay.
not
on the
examine
18th
witnesses.
Okay.
You tell me what's.
September 18th, he came out, he went to her office, okay, and talked with her. He left there mad, okay? All day long, he blasted his radio, which was being a nuisance. To 1:14, which I got a police report, I called the police officer. He slammed his van door, closed the radio off, because he seen the police officer coming down the road on Breen. And the cop got there and I said, he done turned it off. He left that blasting right behind my window with his van. And this is all due to his chickens in my yard. I even got a scar on the back of my leg, what happened because of them. And she's been out to my house way before August, okay? Now, you have not been to my house before August?
Sir, you gotta focus your comments to me. You don't have the right to ask questions
Okay,
of witnesses.
well, the thing is, they shouldn't be walking away with nothing happening to them. Everything has happened to me and my wife since we lived there, okay? And we've been there way before them, and we never bothered nobody.
We were good friends with them, Your Honor. That when we first moved in, I cooked for them, I took them cookies. We were friends. We tried to be friends.
And we tried to work with them, and all we got was, Your dog can get it. F you and these chickens. When my wife tried to talk about it, and they say we're trespassing when we're on the easement. There's no such thing as a trespassing on easement.
And I have to walk my dog on a leash because of chickens. I live in a quarter an acre block.
Do you agree that the chickens are gone right now?
No, sir, she has 7.
We seen them the other day.
She has 7.
And when she came out before, and they put them in that house, because let me tell you something, when she first came out.
So you're saying that when Ms. Wilkinson came out to verify that they were gone,
Yes.
that they were not in fact gone, they were hidden?
They hide them, okay? Just like when they said before, when she first came out, that's before August, okay? And they said they were gone onto Mr. Herman Fowler's property. That all they would do is throw feed on there like they were on that property. They never left the property, okay?
They couldn't have it on Mr. Herman's property's barn. The barn has no windows.
No windows at all.
It's completely closed. You cannot put 15 chickens in a closed barn. It's a little barn. It's no big house barn. And that's impossible that you could do that. And they did.
And they don't have no windows. There's no way to survive in the heat.
Into the barn. That
That was all out lie.
Do you have anything else you want to say about the case?
Here's the thing, and he said he never put no JS, which is my name is Jimmy Santos, on his van. It's all on here,
Well,
the proof. I give you
again,
this up, and
that's an example of something that if you want to admit it as evidence, and the county would have to do it, but I'll be honest, I don't know if it's relevant, even if it was
And
retaliation.
he's threatened me too, okay?
Well, that's not for this.
Sir, this is with all the chickens in our yards.
Okay.
Okay, this is their cat that's in our yard.
So you're saying there's recent photos after they said that it abated of the chickens in the yard?
Absolutely, sir.
Well, again, this is for the county to present to
This young lady
me.
has been out here to my home at least 4 to 5 times.
Okay.
And it's all here.
Okay. Has the county seen it? Has the county
No,
reviewed it?
no.
No,
Okay.
sir.
All right.
She, the officer told me what to do, and I went and I did it.
Okay.
No one had seen it
Okay.
until today. She told me the next day.
I'm not going to allow it into evidence unless the county moves it into evidence.
Who would do that, sir?
The county would.
Would that be-
Well, let them
So
talk.
it's totally up to the
Let them
county.
talk.
I can't play it on my computer to see.
You've
what it
tried?
is. I'm not allowed to.
Yeah, we can't have unauthorized items plugged into our computers to look at them.
So I have pictures on my camera.
Well, unless you want me
You
to
have to
confiscate
take
your,
No, no.
That's why we
Yeah.
did it.
See, let me say something. Ever since the code enforcement and everybody comes out to this place to check on them, it seems like they get away with everything, okay? And I am fed up with it. I'm a taxpayer. I've paid a lot of money in taxes in the past 10 years, okay? I don't think they should be walking away with scot-free. Look at my leg, and my leg's scarred because of their animals being in my yard.
all right, thank you.
We can ask IT.
It-
I mean,
it's-
we'd have to get with IT to have that.
IT has some tool they can check it to see.
Is it going to change the result? I mean, is it going to add something for proof of the case?
We'd still have to go out and do an inspection and verify,
We could do that today.
the violation.
She was at our house
you know?
yesterday. Ms. Wilkinson was at our house
Well,
yesterday.
while they're figuring that out, I want to give you a chance to respond. You have that right too. Okay, so, tell me. I mean,
Okay.
if you have something to respond to what you just heard, you have that right.
This is an ongoing issue with them.
I'm sorry. Hold on a second.
We can view it on this one, I'm sorry.
Well, let's take that up. I want to hear what they have to say, and if you don't mind, go ahead.
Ms. Wilkinson was at our house yesterday because they called and said we had 7 chickens and a rooster, which was all fabricated. I let her on the property.
We never
I
said
walked
rooster.
her
Guys,
around.
no. You guys are done. Thank you. Thank you very
I
much.
walked her around the property. I opened up the coop and
I'm sorry, ma'am.
Oh, you're fine.
Your public comment session has concluded, so I'd like to ask you to. We'll have the county come back to the
We'll just leave
microphone.
this
Yeah,
there.
please sit. Please sit. Yeah.
Can I stay?
Yeah, of course you can stay. Yeah.
Sit down.
Oh, yeah. I mean, if you want to stand, that's up to the county. All right, go ahead.
So Miss Wilkinson was on the property yesterday, so she can attest that she saw only 4 chickens and no roosters. And like I said previously, the excess chickens were coming from our neighbor's yard that's on the side of us. And I don't know what they're commenting on, that they lived in a barn with no windows. That's completely fabricated as well. I have pictures
I think
of
what
our
they were
fencing.
trying to say, I mean, I don't know, but I think what they were trying to say was that it's not plausible that they would be on the neighbor's property because the only place they would be the barn.
There was a coop there. It's not
Okay.
there anymore because we just rehomed all the chickens because we don't want to do this
When did you
anymore.
rehome them?
A week ago,
Okay.
a week, 2 weeks ago.
Okay.
But they were legally allowed to have 20 chickens because they have 2
The
acres.
neighbor?
Yes,
Okay.
yes. And we can only have 4 because we have 1.18 acres.
Okay.
I have pictures of the fence we put up. It's a 6-foot wooden fence. So I don't know how these chickens would be getting into their yard. This is a really big ongoing issue with them. So we erected a fence just to set a boundary. I felt like I was being held hostage dealing with creepy behavior because I didn't want all the blowback, because I saw how they were towards the neighbors across the street. I saw how malicious they were with calling code, calling the health department, calling the cops, and I just thought, oh my God, this is going to happen to us unless, I keep up this relationship of just trying to be friendly. But it came to the point where I didn't want to be in my backyard because we had no fence up. And every time I was in my backyard, I'd look over and they were at the fence calling me over, or in passing, they were commenting on things I was doing in the backyard where I was just thinking, like, how did they even see me? Are they just watching what I'm doing? So we put up a fence. They called code on us because we put up a fence that was higher than 6 feet. We did not know. We took it down to 6 feet. They called code again because they measured it themselves, and it was 6 feet 2 inches in one spot. So we asked code, what can we do to legally block them out? And they said car canopies. So now we have car canopies going along our fence line, as well
Car
as
canopies?
Yes.
7 car canopies, and they still find ways to stick their hand through the.
What is a car canopy?
A carport.
Oh, I see. I
Yes.
see.
A car
I got
canopy.
you.
Way we could get them from
So we-
videoed over our fence.
Okay.
I was in my backyard one day. I just got into town, and I look over, and Roxanne had stuck her hand through my fence. The only part that wasn't wood yet. She pulled down the privacy screen and stuck her hand through my fence, recording me. We put up a fence in the front of our house because they were driving up and down the road, recording me, just trying to intimidate us. They've done this to other neighbors. This is what they do.
It's been going on for 3 years now.
The night we put up the fence, I have pictures. They took out a spotlight and shone it directly at our house. I have a picture of the spotlight, and I have a picture of the view from a bedroom window with how bright it was. And these are all just intimidation factors. Oh, I also have a video and a picture of Roxanne taking a bag of trash and putting it over my gate. This was last week, and after we caught her doing that, she called the cops on us, saying that we threw this trash in our yard and she wanted us arrested for being nuisances. This is probably the 3rd time she's called the cops on us, making things up. So this is an ongoing issue. It's at the point where, honestly, we're not going to live in this neighborhood anymore because it's going on. And I was hesitant to say that because I don't want them to try to figure out, where we're moving to and to harass us there.
Okay.
I feel like that is the next move for them. I've seen their behavior towards other people.
Well, so the way the code works is that, first of all, are there any other members of the public who want to be heard on this case? Okay.
Yeah, sure you can.
Yeah, and if you want to admit the photos into evidence, you absolutely can try to. We'll see if the county.
It was just showing how much we try to block them out.
Right.
We don't provoke them. I don't even look up at them when they drive by.
We moved our
We've had
mailbox.
issues.
We
We've
moved
had
our mailbox to the other
battles.
side of
We've moved
the
our
street.
mailbox.
We moved a gate.
We've done everything we can to block them out of our lives, and they continue to harass us daily.
The-
Daily. The radio that he's talking about, that was played because we didn't want to hear them cussing at us, harassing us, calling her multiple names I don't even want to say right now.
Well, the problem for y'all is that it does sound like there was a violation.
Yes.
And it's been abated.
It's been abated. It's been abated.
According to the evidence I have,
Yes.
it's been abated. And the county is requesting an unusual remedy, but it is one I'm allowed to give under the law. And the reason is to deter further violations, okay?
We don't have an objection, Tom.
Okay, there's no objection. I will look at them. I'm not sure the relevance for the hens and the rooster.
There's nothing that can get through those fences right now.
And like I said, the code was out there yesterday.
How did you have the timing to catch the photo of the garbage bag?
Oh, it was a video, and I took a
I watched
screenshot.
her walking
I
down
see.
our whole fence
Okay.
line with it, and I knew it was coming.
Okay.
So I got a video.
Well, initially she tied this garbage
And
bag
that
to
was-
one gate,
That was a
and then
week
she,
or two after she called us on junky conditions in our yard, because we had a hurricane right before that. We had everything in our yard piled up in an area. That was all cleaned up, and then 2 weeks later, she's throwing garbage into our yard.
And I understand code is here for safety and for regulations, but they have totally weaponized code enforcement.
If there wasn't a violation, it wouldn't be weaponized.
Well, I understand with the roosters, but
Yeah, yeah.
the code came out yesterday, again, and like I said, I showed them
We have nothing
the
to hide
property.
anymore.
No,
nothing.
there's.
We are not hiding anything. It's just getting ridiculous.
All right.
They continue to spy on us for the last 2 years. I have palm fronds sticking out of a tire in one area where there's trees and we couldn't put a car canopy because we've been harassed at that one spot. When I hadn't finished the fence, I had 20 feet to go on a 200-foot fence. The last 20 feet, they provoked our dog to try to bite them over the fence. She's out there with her phone trying to get our dog to bite her. And I had 20 feet of fence left to go. You know, so
They
every
walked all the
little
way to the back
spot,
of the yard
Every
to do
spot that
this.
we had open, they would come harass us at. So we shut that off. We shut off our one gate. The only gate we didn't have shut off was the gate last week that she threw the trash over the fence, and I immediately put a cloth across that.
I mean, honestly, I
And
feel
then-
like we live in a
We
prison
do.
because.
I have to look at just whether the violation
I
exists.
I understand. This
And,
was just this was just a response to the letter that she read, because that was.
So you have the right to do that, and I encourage the public to make its comments and for you to make your responses. So is the county standing by its recommendation?
I'm just concerned about the roosters not returning back to the property. So yes, I'm standing by my recommendation.
May I say something?
Yeah.
There are multiple properties surrounding our property that have roosters.
Well, that's where this is a complaint-based.
There will be-
Yes.
This is a complaint-based system.
I'm just saying, they will hear crowing. It won't be coming from
It won't be
our property.
coming.
Well, I mean, if code enforcement comes and there's no roosters, I mean, I know that's a small consolation, but that's the remedy. Okay, then I will find that the property was in violation and assess, what is the administrative cost?
We won't know yet.
What is it based on?
Inspection fees, recording fees, and postage.
Okay, well, the recording and postage fees are
Minimal.
de minimis.
I would say, because of the amount of inspections though, we're probably looking between $300 and $400.
All right, so I am going to assess the administrative fees, and that's, there was a violation. The code enables me to assess those costs. It's not fair when there is a violation that the taxpayer should pay for the investigation, but often they do. This is just a situation where they want to deter future violations. So it doesn't sound like there will be any, and that concludes the hearing.
Thank you.
Yep.
Next case is on today's agenda, Barbara Jean Mason, case numbers 2023-00767 and 2023-00794. Code Officer Alan Jonathan, page 28 and 29 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you?
Yes, ma'am.
Can you please state your name?
Jennifer Spradlin,
Can you spell the last name?
S-P-R-A-D-L-I-N.
Thank you.
Good afternoon.
Alan Jonathan, Citrus County Code Compliance Officer. This is case number 2023-00767, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 2023-00794, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. Address of the violation is 3949 East Sanders Street, Inverness, Florida, 34453. Property owner is Mason Barbara Jean. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 6 September 2023, photos from my compliance inspection on 21 September 2023, and photos of my final inspection conducted on 17 October 2023. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the posting affidavits, photos of the notice of hearings posted on the property, and a copy of the pre-hearing order.
So it's exhibits A and B in each case?
Yes, sir.
And the photos are different?
Yes, sir.
All right.
Absolutely.
Ma'am, could you take a look at these documents?
Yeah, that's all. That's why I'm there to help, so.
Are,
You're good with that?
Okay, yeah.
Okay.
are you Ms. Mason?
No, sir.
Oh, okay. Are
No.
you,
I do live with her now. I moved in, September 10th.
you live in this property?
Yes.
Okay, all right. Thank you. All right, thank you. Wow, an old Thunderbird. I haven't seen one of those in a while.
Did you used to have one?
No.
Oh, okay.
I opened a lot of them at car pickup when I was a patrol.
Gotcha.
Go ahead.
On 6 September 2023, I conducted my initial inspection and observed the property to be in violation. On 6 September 2023, a notice of violation was issued for junkyard conditions and unlicensed vehicles, which is a violation of the ordinances mentioned earlier. On 21 September 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with Barbara Jean Mason. I just had contact with the lady here. As of my final inspection on 17 October 2023, the property remains in violation.
And ma'am, I'm sorry, I missed your name.
It's Jennifer.
Okay. What's going on?
So I moved in September 10th and all those pictures are, yeah, that's what's going on and we're there to help.
Okay.
So we did get trash pickup, but you can only put so much at the end of
That's
the road.
right.
So we do have a trailer, we just don't have someone to pull it. I did talk to Miss Mason on break and I did let her know that she's gonna have to get a tag or we'll have to get rid of the car.
Okay.
Because it's been a long time. So
Okay.
she surrendered her license, she's 82.
Gotcha.
So we're there to help and we'll try to get it done in like 30 days maybe.
Isn't the president 82? Doesn't he still have a license?
He does,
84?
but yeah, you don't want, you don't want her to
Yeah.
have a license.
I know a
promise
100-year-old who
you.
had a license and they finally had to forcibly take
I
it
mean, I
from her
think
after
it's a
she
good-
hit her 10th mailbox, but
Is that
Yeah,
wrong?
she would probably
yeah.
like, hit 10
Nothing she did
mailboxes.
was wrong, I'll tell you that. She was amazing. Okay, well, how much time do you think is needed to address both of these things?
30 days.
On both,
Yeah,
you think?
for
Okay.
sure. I have somebody there to help too.
Okay.
As well.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with the administrative cost to begin after the date you deem sufficient to abate the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to the violations. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
All right, in each case, I will find that the property is in violation. I'll grant 30 days from the date of the order to abate the violation. And if the violation is not brought into compliance as ordered in each case, a fine of $50 per day will be assessed.
Yes, sir.
Thank
That's it.
you.
Thanks.
Thank you. Thank you, guys.
Next case, Cynthia Jean Borden, case number 2023-00803, Code Officer Amy Becker, page 9 of your agenda.
Ma'am? Here. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Can you please state your name?
Cynthia Jean Borden.
Thank you.
Thank you.
You're welcome.
Amy Becker, Citrus County Code Compliance Officer. This is case number 2023-803, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 2 South DeSoto Street, Beverly Hills, Florida. The property owner is Cynthia Jean Borden. I have good service via certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on September 7th, 2023. Photos taken on September 14th at my corrective action inspection. Photos taken on October 12th, and my photos taken on my final inspection October 17th, 2023. And Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on September 21st, 2023.
Okay. Ms. Borden, could you take a look at these documents and let me know if you have any objection to them being evidence in this hearing?
Yeah, this has all been taken care of.
Okay.
It was all taken care of yesterday.
Okay.
At 11:30.
It was?
Yeah.
Okay.
Okay, well, why weren't you out there? It was not there.
She came earlier than I did it.
I gotcha.
I was here before 12.
Yep, I didn't get there till 12.
Oh, the fence blew over. Was that from the storm? Yeah. Possibly. They're putting it back up, slow but surely. It's up now.
Okay. Then without objection, exhibits A and B are evidence. Let me just look real quick.
Okay.
Okay. Okay, please go ahead.
On September 7th, I conducted my initial inspection for accumulation of junk and debris and observed an accumulation of vegetative matter. As of my final inspection on October 17th, the property remained in violation. She says that it's taken care of. The fence is back up. It fell down on the 12th. It's back up, so I'll check it tomorrow.
Okay. So you don't really need extra time. You just need code to go out there and check. Okay. If it's not perfect, if it's not in compliance, how much time would you need? 7 days? 7 days? Okay.
Yes, that'll work.
Okay. I just want to, I don't want to set you up to fail if for some reason there's something that's missed.
3 different jobs, so.
Okay.
I volunteer 2 and 1. I'm only in Citrus 3 days a week. And I'm at Beverly Hills Surveillance and Habitat for Humanity those 3 days.
And you've hung out here with me all day.
And I had fun. It was the best day
Oh,
off
I'm
I've had
sure.
in a week.
Yeah, strap yourself in.
Oh, it was better than TV.
Yeah.
Watching it, I was like, this
Yeah,
is awesome.
you'll get your YouTube video out of it, that's for sure. Okay, then what is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection, which she has just done. So
Yeah.
she's notified me.
I mean, just based on the photos, I'm just gonna, in caution, find a violation, grant you 7 days to complete it. Sounds like you won't need it. If it's not brought into compliance within those 7 days, $50 a day. Good luck.
Thank you.
Okay.
Thank you.
Next case on the agenda, Kevin Smith and Catherine M. Smith, case number 2023-00105.
Code Officer Brandon Norman, page 38 of your agenda.
Okay.
So, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
Kenneth S. Smith.
Thank you.
Welcome.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00105, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5641 South Eaton Terrace, Inverness, Florida. Property owner listed as Smith Kenneth S. and Smith Catherine M. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection of May 16th, 2023, an inspection done on June 26, 2023, a corrective action inspection on August 3rd, 2023, and a final inspection on October 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit I completed, and photos of the posted notice of hearing on the property.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
I have no objection.
Okay. All right, without objection, what's been proposed as exhibits A and B are evidence.
On May 16th, an initial inspection was conducted of the property for a complaint of junk and debris. I met with the occupants and they asked for 2 weeks to come into compliance. Due to the history that we've had with the property, they've come into compliance before, so I didn't think it'd be unreasonable to grant them that. So I gave them a 2-week verbal to bring it into compliance. I re-inspected the property on June 26, 2023, and it remained in violation. It continued to remain in violation at my corrective action inspection on August 3rd, 2023. And then as of yesterday, October 17th, it does show some positive change. It's still in violation. I did have the opportunity to speak with the property owner today. It's my first time actually talking with him. I've only spoken to the occupants. And he's expressed to me that he has every intention to rectify the situation on the property.
Okay. Is that accurate?
Yes, it is, sir.
Anything else you want to let me know, or how long you think it might take to?
Well,
I mean, it doesn't look. I mean, it looks fixable.
I could plead on hot strings or whatever, but there's no excuse for the way the property is. It's horrendous. I wouldn't want to be a neighbor. It's 75 to 85% done. It will be done in 30 days.
All right, so 30 days is enough to fix this?
Yes, it is.
Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with the administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master find it the respondent's responsibility to contact the Code Compliance Division once the violation has been abated to allow for reinspection.
Do you think I just don't have heartstrings to pull on? Or is it? I adopt the county's proposed findings of fact. The property is in violation. I'll grant you 30 days from today to abate the violation. And if it's not brought into compliance as ordered, a fine of $50 per day.
Thank you very much. I have one other thing. I haven't had much contact with code enforcement, but the things that I've had, they are extremely professional. I haven't found one that I disliked even, so I mean, they're doing a great job. If that's
this is the
going
first
on
I've heard of
record,
this, so.
you can put it there.
Thank you.
Thank you
Yeah,
very
try
much.
We appreciate it.
Try appearing in Orange County.
Trust me, I was a prosecutor in Boston.
Okay. All right.
All right.
Yeah, I'd like to get everyone out of here.
Yeah. We're ready. We can start with them.
Yeah.
Oh, okay. I didn't know if next case on today's agenda, Ferrith Garcia and Andrea Orjuela. Case numbers 218-5828 and case number 218-5830. Code Officer Brandon Norman. Expert on the case, Joanna Coutu, Land Development Director, pages 15 and 16 of your agenda.
So the first thing I'm going to do on this case is I'm going to reincorporate the evidentiary record that was made from the Fox Run hearing. And do you have any objection to that?
No, I have no objections to that, but
I thought you wanted it, so I'm
Yeah, but I would like to combine all these cases. We can make a split between the accumulation of debris and what was it? Site development.
Well,
but this is all the same.
It's actually up to the county on how it wants to present, and I think they're doing at least me a favor by doing these two together. I do prefer that they be brought together, but sometimes there's individualized issues. So we'll definitely take these Garcia Orejuela cases together. So I'm going to incorporate the relevant parts of the Fox Run hearing into this evidentiary record. Everything from the written speech I'll incorporate. And there was one other thing I wanted to do.
Are you incorporating the evidence 1, 2, and 3 as well?
I'm gonna do that.
I do have to say, these are two different addresses too. I want to make
They
sure
are,
that's,
yeah,
okay,
two
okay.
different addresses. Just there was one other thing I was thinking about. All right, well, maybe it'll come to me, so go ahead.
My interaction prior to as well, it wasn't in regard, I didn't ever speak with Mr. Van Oozen on these two properties specifically, simply because of the fact they
Oh,
weren't
that
listed
reminds
as.
me, that's what I wanted to do. I
Yeah.
wanted to say I'm accepting the power of attorney as giving them
Got
standing
it.
to speak on behalf of them.
Understood.
I have no reason to believe that the power of attorney is not what it says it is. It looks valid to me. I mean, well, I don't know, you might need, huh?
Did you accept them into evidence? Or are you going to for this case?
They were Exhibit A. They were Exhibit 1.
Actually, let me just look something up real quick.
Did you accept them into evidence before?
No, because they were part of the Fox Run case.
Okay, so they should be.
Yeah, let me look something
No,
up.
when you said they should be.
Hmm?
They already were.
No, they would be number 4 because 1 through 3 was already brought in.
They weren't witnessed. I don't know. No. But I don't know.
I'm just gonna grab my water while you do that, sir.
Yes, I'm looking something up very quickly. Let me just connect to the Wi-Fi here. Having trouble getting a signal. Okay. So, Florida Statute 709.2105, subsection 2. A power of attorney must be signed by the principal and by 2 subscribing witnesses and be acknowledged by the principal before a notary. So we've got the notary. There are no witnesses. I mean, it's just not a valid power of attorney. what is the county's position on their ability to present on behalf of these people?
Well, if it's not a valid power of attorney.
It's not.
Then I don't know how they could.
Let me ask you, I mean, I assume, what kind of presentation do you want to make on their behalf for these lots?
Exact copy of what my defense will be.
Okay. Okay.
Exact, because I combined them, as
Okay.
I told you.
Okay. Then before we get to that, and take up their standing to make those arguments, I've already incorporated the evidence. What is the county's case? Present.
Would you like me to read them off both at the same
I just
time?
want you to go through your presentation of the case as you normally do.
Okay. This is for case number 218-5828, development applications and applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code for address 4632 East Rejoice Street in Inverness, Florida. Property owners are listed as Garcia Ferreth and Orwela Andrea. I have good service via confirmation email between Citrus County Code Compliance and the respondent's attorney's office. And I would like to authenticate the following documents for this property to be admitted into evidence. Exhibit A will be photos taken during the initial inspection on March 23rd, 2023, the corrective action inspection on May 12th, 2023, and the final inspection on October 17th, 2023, as well as aerial images from the Citrus County Property Appraiser website for March 2004, January 2012, October 2002, and July of 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code Compliance and the respondent's attorney's office. For case number 218-5830, it's for accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. It's for the address of 4654 East Rejoice Street. The property owner is listed as Garcia Ferreth and Orwela Andrea. I have good service via confirmation email between Citrus County Code Compliance and the respondent's attorney's office, and I would like to authenticate the following documents for this case and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on March 23rd, 2023, the corrective action inspection on May 12th, 2023, and the final inspection done yesterday, October 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code Compliance and the respondent's attorney's office.
Okay. What I'm going to do is, based on the standing issue, I'm going to give you the ability to speak as members of the public on these cases, but you will not be able to stand in their shoes. All right.
Nope.
Show them to the county attorney.
This one is this one, right?
Welke aardig nou? 28? Nee, dat denk ik niet. Want dat is site modification. Daar hebben we het over debris. I'm a bit lost. What case numbers are we talking about?
These are case numbers 218, 5830,
Okay.
which is page 16 of the agenda, and case number 218, 5828, which is page 15. Thank you.
For one of the photos for the junk and debris, can you do the point where it's actually at, because it's kind of like see it as overgrown?
Okay. Go ahead.
For case number 218-5828, on March 23rd, 2023, an initial inspection was conducted at the property for a complaint of site modification without permits. The property was found to be in violation of the above ordinances due to not having any permits issued before the removal of trees and modification of the property. The aerial photos show that trees were removed between March 2004 and the day of my first inspection. As of my inspection on October 17th, 2023, no permits have been applied for or issued. For the property of 4654 East Rejoice Street, I conducted my initial inspection on March 23rd for the complaint of the site modification as well as tree debris on properties.
Can you confirm, you
Yeah.
said the trees were removed, I heard 2004.
That's correct.
Okay.
That's correct. You start to see change for 2004, that's where the trees were. You start to notice change after that date, up until the point of my inspection. For the complaint of tree debris, the property was found to be in violation of the above ordinance. The property remained in violation of my corrective action inspection on May 12th, 2023. And as of yesterday, October 17th, 2023, the property remains in violation. It's severely overgrown, but you can still make out where the tree debris is. But because of the overgrowth of the property, it's a little difficult to see, but I can show you where it's at.
Do you know
on the
how
photos.
big this lot is? Or how either of the lots?
I do have expert witness, Joanna Coutu.
The first one, the 4632 Rejoice, is 0.31 acres, and the second one is 0.38 acres, very similar.
Okay. From the aerial photos for the site modification, one tree has remained, but from the aerials, you can see that there was more than one tree. And that's the reason why we brought it for the site modification.
I can see it. Are there any members of the public who wish to be heard on these cases? If you want, it's up to you.
For me, it makes it very difficult because I put them all together.
Yeah.
And if I read it now, it's as the public, and I haven't seen any picture and, what's in evidence.
Sir,
so-
if you've ever seen these hearings online, they're all online. This is the routine way that we do it. So
Well,
I'm sorry,
And
but
that's a fact, and I have to accept it, and
Yeah.
I'll go back to them and say, sorry, you have to do it yourself next time, or maybe they have to pay a fine, I don't know.
well, if you planned on presenting them all at once, in all the cases, despite the parties being different, that's something we've never done at these hearings before, and never in all my years. So,
Okay.
and you could have known that by watching all the YouTube videos beforehand. So although I
Yeah.
understand your frustration, it was available for either you or your attorney to know. So I sympathize a little, but not a lot. And you now have an opportunity to speak as a member of the public, but I invite you to make whatever comment you wish.
I have no comment.
Okay. Ma'am, do you have any comment? I just want to make sure.
No, thank you.
What's the county's recommendation?
For the case of 218-5828, development applications and applicability, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. In the case of 218-5830, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find that it's respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
In case number 218-5830, I will adopt the county's proposed findings of fact and legal recommendations. The property is in violation. I'll grant 30 days from today to abate the violation. It's not brought into compliance as ordered, $150 per day. In case number 218-5828, a one-time fine of $2,500.
Thank you, sir.
Thanks.
Next case is on the day's agenda. Garden Estates of Inverness LLC, case number 218-56 76 2023-00130, Code Officer Brandon Norman. Pages 17, 18, and 19 of your agenda. Land Development Director Joanna Coutu, expert witness on the case.
I'm sorry.
Can you
could
please repeat it?
I'm sorry.
Follow it.
It's, do you have the whole agenda with
Do
you?
you?
Okay, it's case numbers, it's all the Garden Estates of Inverness cases. All three,
Okay.
okay. Do you need anything else? Do you need the case
You
numbers?
need the case number?
No, I know what how you think and how this process is.
Okay.
Okay.
Just need a second to locate all of them.
Okay.
Apologize.
Hmm? Yeah. Yes,
Okay.
Go ahead.
You want me to read each one of these?
I mean, however you feel it's appropriate.
Okay, they're just all different addresses. I would just feel more comfortable if I just went through the normal procedures for them.
There's two on J Street and one on Rejoice, right?
That's correct, yes, sir.
Okay.
This is case number 218-567, 218-5676. Development applications and applicability, a violation of Chapter 4, Section 4002 A, B, and C of the Citrus County Land Development Code. The address is 4532 East Rejoice Street in Inverness, Florida. Property owner listed as Garden Estates of Inverness, LLC. I have good service via confirmation. I have good service for all cases that we're about to discuss via confirmation email between Citrus County Code Compliance and the Respondent's Attorney's Office. For this case, I would like to authenticate the following documents and request they be admitted to the evidence. Exhibit A will be photos taken during the initial inspection on March 23rd, 2023. Corrective action inspection on July 12th, 2023. A subsequent inspection on September 12th, 2023. And a final inspection done yesterday, October 17th, 2023. As well as aerial images from the Citrus County Property Appraiser website for October 22 and July 23. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code Compliance and the Respondent's Attorney's Office. Exhibit C will be a copy of the LLC amendments and Florida Limited Liability forms for DT Villages 11 LLC and Garden Estates of Inverness LLC. Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Garden Estates of Inverness LLC.
Now, before we, and obviously I want you to look at these documents, but what do you want reincorporated from any prior hearing, if anything? From Fox Run, presumably exhibits 1, 2, and 3.
All of it.
Okay, all right. Then
All of it.
I'll reincorporate everything from their prior presentation in the Fox Run case,
Okay.
just for starters. And, ma'am and sir, I'd like to ask you to go ahead.
I have two more I have to read through.
You got it.
Sorry, sir. For case number 218-5678. This one's for development applications and applicability, a violation of Chapter 4, Section 4002 A, B, and C of the Citrus County Land Development Code. This one's for address 4669 East J Street in Inverness, Florida. Same property owner for Garden Estates of Inverness, LLC. The same good services mentioned before. The following documents that I would like to request be admitted into evidence are as follows. Exhibit A is photos taken during the initial inspection on March 23rd, 2023. The corrective action inspection on July 12th, 2023. I believe it's also the subsequent inspection for September 12th, 2023, and the final inspection done yesterday, October 17th, 2023, as well as aerial images from the Citrus County Property Appraiser website for January 2017, October 2022, and July 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the email chain between Citrus County Code Compliance and the Respondent's Attorney's Office. And Exhibit C will be a copy of the LLC amendments and Florida Limited Liability forms for DT Villages 11 LLC and Garden Estates of Inverness LLC. Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Garden Estates of Inverness LLC. And I have one more to read. This one's for case number 2023-00130, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is for 4575 East J Street in Inverness, Florida, belonging to Garden Estates of Inverness, LLC. Same good services mentioned before, confirmation email between the Citrus County Code Compliance and Respondent's Attorney's Office. And I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on May 12th, 2023. The corrective action inspection done on May 31st, 2023. And the final inspection done yesterday, October 17th, 2023. And I can explain once we get through this as to why the inspection dates have changed a little bit. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code of Compliance and the respondent's attorney's office. Exhibit C will be a copy of the LLC amendments and Florida limited liability forms for DT Villages 11 LLC and Garden Estates of Inverness LLC. And Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Garden Estates of Inverness LLC. And that's all the ones for Garden Estates.
All right. This is another reason why probably I wouldn't want all the cases to be at once. I'm going to ask him to give you all 12 exhibits and A through D in each of the case numbers, and just let me know if you have any objection to them being evidence in this case.
Can I just give them one case at a time? Once they've confirmed with a case, I can
However
pass
you
it.
want.
Okay, I just want to make sure.
Yeah, whatever's easiest for them.
2023-00130. I just don't want anything to get mixed up or confused, so.
That's fair.
Thank you for being so accommodating.
Can't believe the county attorney didn't want to stick around. I love roosters. I'm sorry.
Do you have more than 2 acres?
You just gotta have a balance. The numbers.
Are you a rooster whisperer? Are you adverse?
I'm an animal whisperer.
Oh, okay.
I'm an animal
okay.
whisperer.
That'll come in handy in a year or two.
Yeah. Puppies are good.
Just
Puppies are
rescued a
good.
kitten. So.
Yeah. You'd have riots on your hands. if-
Well, people have asked. They've asked. It's like they have like 15 dogs. I'm like,
Yeah.
they don't have a code for it.
Yeah.
So.
Yep.
Make sure they got food and water. That'd be proper shit.
There is in the animal code, you have to register the county when you have so many.
Which no one
You
does.
have an evacuation type plan.
No one does that.
That
Yeah.
our animal control goes out.
I only say that because I've seen those in a lot of counties and cities, and it always surprises me that they exist. Not that they're a bad idea.
They just don't enforce it.
Just they're not. Yeah, enforced. Yeah.
That's the evacuation.
Yeah.
Dan laat ik nou mijn spullen voorlezen.
Safety's that.
Nou, weer aan mijn hand.
We haven't seen
Is-
pictures of them.
Because we're too tired to send them.
No, you don't even taste the second one, you don't take pictures.
No, I sympathize. I'm gonna call Nick Ozma later and say I get it, you know.
Any idea what the
Yes.
legal is?
We keep saying.
The legal description?
Yeah.
What's the what is?
We'll do that after.
These are-
This one.
It should be on the deed.
You're almost
Here's
done.
some deed.
It should be listed on the warranty.
Exhibit D.
It's Exhibit D.
No, I'm just saying. Unless there were multiple parcels in the deed.
I pulled the most recent warranty deed that was listed for the most recent sale transaction. They're all March 24th, 2023.
And which one is it?
How many packages? Do they only have one?
They only have one right
Okay,
now.
okay.
That's, yeah,
Okay.
that's, it can get a little bit confusing.
No, I mean, it was
so.
a good idea.
Yeah.
No. So, can you explain to me what is 45 to 75? What is the legal? You say,
Sir. It's, you'll have a chance to cross-examine him
Oh, I'll
or
do
examine him if you want. Because I definitely want to hear wherever you're headed. Do you have an objection to these documents? I mean, is there a reason?
Not to the documents, no.
Okay. Okay.
is 202301.
Here is 5, 6, 7, 8. Same order as before, A, B, C, D.
Thank you.
My arms are long now.
Wil je
I have
nog steeds
short arms.
genomen?
My arms only go to
En
here.
dat die twee tussen. Hier.
This is 5676, 218567.
Dat komt nu wel. Dus vaak naar de foto's. Nou, zo is wel hetzelfde dat we dan mee.
Oh, wow. This Sunbiz was from 2006. You've been working with the Osmas for a long time.
Yeah,
Wow.
a very long time.
Wow.
2001.
Oh.
And the family originally comes from the same country as I come.
Interesting. Sounds like you might have come a little more recently than them, than the Osmas.
Yeah.
But that's pretty cool.
There's more stuff there.
Nou, dat een verhaal nog klopt. Ja, dus die bij mij, die heeft
Oké.
5000.
Oké.
En het moet in orde gebracht worden. Maar ze gaan me allemaal zelf betalen. Ik ga er niks voor betalen. Echt niet. Ik doe het gewoon niet. Dan gaat Gerard dat van zijn winst.
I'm sure you saw from the photos, too, we run into a situation where because of the overgrowth, I mean, the debris is still there. I can testify to that, but it's capturing on an image is extremely difficult. So,
All
and
right.
it's like
so
that for other properties as well.
I'm just going to look through these documents briefly.
Mhm.
Um,
Exhibits C and D will be the same throughout
okay.
this.
Let me just take a look.
Stel eens wat vragen voor die roos op voor de cross-examination. Iemand waar met je. Ik heb ze hier al in.
Do you all know who, there's an email chain in here between your attorney's office and the county. And one of the questions that Mr. Ozma's office asked was, did he have subpoena power? And I don't think he does have subpoena power as an attorney for y'all. I have subpoena power in these hearings. But do you know who he wanted to subpoena?
Oh, yes, Commissioner Davis.
Okay, all right.
And I believe that Ms. Spiros advised him that if you wanted a subpoena issued, it would be issued through you.
No, I read, yeah, it's in the
Oh,
emails.
okay.
No, I mean, I was just curious. No one asked me to do it, but I was curious who it would be, and that makes sense given the email exchange. Okay.
Because as I have said, it's a political witch hunt.
I guess before we get into your case,
Yes, sir.
I want to ask you, for example, about case number 218-5676.
Yes, sir.
So the first photos are from March 23rd.
Mhm.
This is before the property was deeded. It was deeded on March 24th, the next day.
That's correct.
So assuming that a violation occurred before the deed, who's liable? If there is a violation, who would be liable?
The county stance on any violation has been, regardless of when the violation took place, if the violation exists, it's whoever the property owner is at the time. I mean, we've had other
And
cases.
did the violation occur? Or even after
At the time
fact?
of the inspection. So if
Hmm.
there's a tree removal, and we've had cases like this in the past where if a tree removal occurs without a site development plan have being issued, the current property owner is still the overall responsible. It's very similar to an after-the-fact permit cases where
Yeah, you buy a piece of property.
and there's something that
and
hasn't been permitted, it's still
something hasn't been permitted.
The violations-
But that's because the structure, it requires a permit. It
Mhm.
needs a permit.
The removal
You
of
do
these
the
trees
you do the
required-
inspections
Mhm.
and okay.
Yeah, and the removal of these trees in essence required a site development plan, if I'm correct, yeah. And that's technically a permitting process. And even for junk and debris cases, or even every time we have, if a person purchases a property with junk and debris on the thing and someone makes a complaint about it, we go out and inspect. We don't, unless we witness that person placing those junk and debris items on there, we don't issue them we don't issue the person supposedly responsible for it a citation. We hold the property owners accountable to bring that property back into compliance, because our goal is not to get
It's
anyone
just
in
for
trouble.
some reason there's something that's affecting my smell test about this, and I feel like there's and I'm just going to talk out loud to
Yes, sir.
discuss it. When you have an unpermitted structure, that's why an after the fact permit exists.
Mhm.
You don't want to have to force people to necessarily tear everything down,
Not at all.
go through everything from the beginning. On something like this, site modification, a lot gets cleared, and then they sell it to, in this case, it wasn't sold to an unwitting buyer,
sir, it wasn't.
right? It wasn't, it was the same people, the
Yes,
same
sir.
principles.
Yes, sir.
But there is potential issue, and I'm just trying to walk through it. I know our code has a section on who can be liable.
The owner or the violator, the owner of the property.
The owner or the violator? Do you remember what section that is?
That's in our, I think that's in our,
It's like
it's in
19.
the definition section, but.
Okay, violator.
And initially, the notice was sent out to the prior owner.
Okay.
The prior owner contacted the county and said the property's been transferred.
Okay, all right. So the definition of violator. Violator shall mean the person creating or permitting the violation of any provision of the county codes, or a person who owns, controls, or is otherwise responsible for the real property upon which the violation occurred. Huh. Okay. Satisfies my questions. All right. Please proceed.
Thank you. So for the two site development cases, my narrative pretty much remains the same. I guess at this point, the circumstance in which I discovered the violations, I'd like to refer back to the previous case that was heard. Unless you'd like me to go back and I can reread
What exactly do you want
my
to
interaction with Mr. Van Oosen.
Okay, so you want to incorporate that
I would
part?
like to incorporate that portion of it
Okay.
just to save time.
Yeah,
Time's
that's fine.
sake.
I'll do that.
I conducted the inspection on March 23rd, 2023, of the area for the complaint of site modification. The property was found to be in violation due to the removal of the trees and modification of the property without the site development plan having been issued to the property owner. Once I was notified that the property ownership had changed, I then verified the new ownership and reissued the notice of violation. As of my corrective action date for, and again, I apologize because all my narratives read the same, so I just need to look at my dates again. For my corrective action date, that was on July 12th, 2023. The property remained in violation with no permits being applied for. And then as of yesterday, October 17th, 2023, the property remained in violation. That's same for the property at 4669 East J Street, as well as 4532 East Rejoice Street.
On 4669
Yes, sir.
East J Street, what is the development that happened?
Could I approach so I can just review the photos and just?
I'm sorry?
Can I approach this so I can review the photos and show?
Sure.
Thanks.
If you don't mind, speak up so they can hear you.
It's just when we do these, we'll take an initial inspection of the property, take a look. I go back and like I did for the other cases, I do my research and I look at the aerial photos. I see that there was trees present at one time. I look at the history of it, I see there's no more trees
So
present.
you're saying that there was site clearing?
Affirmative, yes.
Okay.
Trees were removed without a site development plan
Okay.
having being issued. And that's the same for both cases. I guess just to kind of shorten it a little bit, the cases that are being heard today for site modification without the permit all have to do with the removal of trees from the property. I only had one property that was for the grading. We've already heard it. It's been heard by you and it's been adjudicated on.
So you're not alleging a grading?
I personally haven't observed anything. The fill dirt that he mentioned earlier for the one property, that's the first time that I've heard of it. I mean, I've observed large amounts of dirts in the area. But when it comes to me presenting my cases today, everything is based on the fact that there were trees on the property before.
Okay.
There was no site modification plan issued to remove those trees. Therefore, that's where the violation exists. That's how the property was modified.
All right, before I turn to them, I want to hear, did you already present your case on junkyard conditions?
I have not on junk.
Okay.
For the property dealing with the junk and debris, again, similar circumstances as to how I came about it. Same interaction with Mr. Van Oosen on it. We discussed the properties at the time that had violations. Once we were notified that the properties were sold, I had to go back out, and this is why my photo inspection dates vary a little bit from this one. When the properties were sold, they were one large address before, and as the lots were sold to the individual LLCs, I needed to go back out and verify that the violations existed on the exact addresses that I was going to issue a notice of violation on. So on May 12th, 2023, I went out to do an inspection of the property at 4575 East J Street. I found it to be in violation for junk and debris, specifically tree debris that was on the property. I gave a corrective action date of May 31st, 2023. Went out and re-inspected on that date, found it to still be in violation. And as of yesterday, October 17th, although it is overgrown, I can still tell that the debris that's there has not been removed. So it remains in violation as of yesterday.
All right, I'm going to look through some of these documents very quickly.
Yes, sir.
may have other questions, but I'm gonna wait till I hear from y'all. What is your position on these cases?
Well, let me start by saying that contrary to the Fakron case this morning, we're talking now about block 13.
Okay.
So whatever lot we discuss now, it's all block 13. On the north side, it's Rejoice Street. On the south side, it's J Street.
Okay.
It's that simple. That was that had an agricultural classification through the 1st of this year, as of January 1st, 2023. So it's in contrary the Foxrun case this morning. Okay, so it's good to know that. I start with the site modification. Code compliance has presented in total 72 pictures that are supposed to show site development activities on these lots in support of the notice of violation. Well, Mr. Charlton, the Citrus County Code Enforcement Director, claims that we have physically changed the land. Just to tell you that I watched the video of code compliance in June when there was a similar case, and I saw him making that argument. To the contrary, no development activities have occurred on these lots. The lots have not changed since January the 1st, 2023, when the agricultural classification was lifted. Again, farmland, I call it farmland, but the correct name is agricultural exempted land, is exempted from the requirements in Chapter 4, Section 4002 ABC of the Citrus County Land Development Code. There is no evidence to the contrary. If Mr. Norman noticed any development activities in 2023, I'm sure he would have taken pictures, because he was directed by his superiors and County Commissioner Holly Davis to take pictures of any violation he witnessed. It's up to Mr. Norman and Citrus County to provide details and evidence of those violations. For example, from what lot was the debris moved and to where? When was the debris moved? When did Mr. Norman determine it was moved? Why didn't Mr. Norman provide any evidence of the move? What reason would there be for me to move the debris? The least we may conclude is that there is no evidence corroborating the argument that the vegetative debris was moved. The evidence presented by Mr. Norman, namely pictures taken on 3 different dates, now I hear here 4, does not show any movement of debris. In the Code Compliance Special Master hearing dated June 21, 2023, Mr. Charlton, the Code Compliance Director, stated the following about site modification. They did site grading. Whenever you grade the site, now you are altering the path of runoff. Now you're altering the natural flow, and you're altering the topography of the land. This, in my expert opinion, is a bigger violation than just stripping of the vegetative material. Now you're physically changing the land. Mr. Charlton is right. There's a definition of development found in the Florida Statutes 380.04. The key phrase are any material change in the land. The primary issue is whether or not there has been a development on the lots. Today I can only speak to my company's properties in the subdivision. I have reviewed the photographs as evidence, and I do not see a material change in the land since January 1st this year, when the agricultural classification of land was lifted. This materiality requirement is related to an improvement of the land. Simply having a brush pile or dirt pile is not an improvement and certainly not material. There is no evidence of mobilization, use of heavy equipment, or other indicia of development activities. One additional remark about case number 21 85676, the 4532 Rejoice Street. This case only pertains to lot 8 in block 13. However, the county, in support of its position, has attached photographs of 4 or 5 additional lots. Thus, the evidence of the county is conflicting and does not support the position of the county. To conclude, the violation against these lots set forth in these 2 cases, fail because there have been no development activities, there have been no material changes in the lots, there is no evidence to support the claim that I caused development activities. Now the other cases, that's accumulation of junk and debris. For the past 20 years, through January 1st, 2023, vegetative waste has always been allowed on all these lots because they were qualified as agricultural. See Chapter 20, Article 3, Section 2231, violations number 5 of the Citrus County Code of Ordinances. I've owned these lots for 40 years and the debris at issue has been in place for at least several years, some debris even more than 7 years. Once the agricultural classification was lifted on January 1st this year, code compliance could have required that any structure on the lots be taken down. However, vegetative debris does not qualify as a structure. On top of that, there is no occupied home within 500 feet from the lots in question, nor are there neighboring properties. Thus, there is no health hazard resulting from the alleged accumulated junk and debris. My conclusion is obvious, there is no violation. In case your magistrate orders to the contrary and takes the position that one or more of my companies violated Section 2231, and that I have to clean up the land with a certain period of time, please consider the following. In the beginning of June 2023, when Florida Forestry lifted its burn ban, I asked my landscaper to burn some of the vegetative debris in Block 13 to comply with the suggested violations. Once my landscaper started burning, he was stopped by bystanders, including an environmental engineer, and had to extinguish the fire because, according to the bystanders, there were covert tortoises and burrows in and around the piles of vegetative debris. The people asked my landscaper to leave the govers alone and not touch the vegetative debris. So we left the vegetative debris in place and it will naturally decay in the years to come. So in case your magistrate asks me to remove the vegetative debris, I'm in a quandary, even though I dispute the violation. If I burn or remove the debris, I will have to enter onto the land with heavy equipment and I will disturb the covert tortoises since they are in and around the debris. Florida Fish and Wildlife Conservation Committee will then sue me for interfering with the covert tortoises and their burrows. That could end up in jail time. The illegal removal of covert tortoises is a violation of Florida statutes. I truly believe that the best solution is let nature have its course. The vegetative debris will decay over time, and this will favor the covert tortoises and other wildlife. Let nature have its course. One more additional remark about case number, that's the 130, may I say so, CE 2023-00130, the 4575 J Street. That's the one I mean. These two lots are not adjacent to each other. However, the county is using the same photos to support its claims in both of these cases. Oh, sorry, I forgot number 2023-00129. So, may I rephrase it, this one?
Oh, there's another case where they're using the same photos, you're saying?
Yes.
Okay.
But it's not adjacent to each other, these lots.
Okay.
The county is using the same photos to support its claims. It's claims in both of these cases. Thus, the evidence of the county is conflicting, does not support the position of the county. And one more additional remark, and now I have to be careful because that could be. No, that was the other one, Mr. Garcia. Excuse me, I have to leave that out. That aside, the alleged violation in these cases against these lots fails because there is no junk or debris that has accumulated, only vegetation has accumulated. There are no health hazards as a result of the accumulated vegetation. Most of the vegetation has been in its current position for over 5 years, and thus the current claim is prohibited by the statute of limitations, and the amount of vegetation is the minimus. Thank you, and we request that the violation be dismissed. And I swear to the accuracy of all of the information that is in this written testimony. Testimony.
Okay. Let's see. Just give me 1 second. Okay, I have a question about the agricultural exemption. So you mentioned that to the extent that the agricultural exemption existed until the first of the year, that this exempted from compliance with Chapter 4 of the LDCs.
Yes.
Okay. Is there a code section, or does the county dispute that? Does the county
Yes.
dispute that? Okay. And why does the county dispute that?
First of all, if there was an agricultural classification for 2022, it would have ended on December 31st of 2022.
Okay.
So we're looking at 23. That exemption would not have carried over to January.
Okay.
Second of all, it sounds like he's arguing the Right to Farm Act.
He mentioned that earlier.
And the provision that we're enforcing existed prior to the provision or the amendment to the Right to Farm Act that limited passing and enforcing legislation with regard to farm activities.
All right, let's look up that statute, because I know he gave it's 823.14, I believe.
Yes, I have a copy if you'd like it.
I would love a copy, instead of looking at my phone. Thank you. Okay. Let me just take a moment to look at this. I've read it in for other cases we've had before, but let's see. So how does this, I see that no farm operation which has been in operation for 1 year or more since its established date of operation and which was not a nuisance at the time of its established date of operation shall be a public or private nuisance if the farm operation conforms to generally accepted practices, et cetera, et cetera. Is that the section that you're relying on that protects you? Or is there another section?
It depends what site development is. I hear now that the site development is that apparently while it had agricultural classification, that taking trees out is site development. Is that correct? Oh, I may not ask that yet. That is what I understand.
You can later. It's just I'm asking, I'm trying to understand where the exemption is in the Florida Right to Farm Act. if you're alleging there is an exemption, maybe you're not.
And an exemption for what exactly?
From enforcing Chapter 4 of the LDCs. What I'm trying to do is I'm trying to find the exact statute, whether it's a Florida statute or something else, that allows you to say your property does not have to conform to Chapter 4. Does that make sense? I'm looking for the exact law.
Okay, but if Chapter 4 is translated by, let's say, killing trees, that's what I understand now, then I'm sure that on agricultural exempted land, you're allowed to do that.
And in order for me to be sure, I have to see it in the law. And so that's why I'm asking, do you know where it exists in the law? Because I'm looking at what I think the law is. And if this is the applicable law, which you quoted earlier, you said 823.14 in the Fox Run case, I'm having a hard time finding it. It does exempts farm operations, which is defined as conditions or activities by the owner which occur on a farm in connection with the production of farm honeybee or apiculture products, or in connection with complementary agritourism activities. So, for example, we had a case here a while ago where someone was saying that their farm operation was like people coming to pet pigs, right?
Mhm.
And so that was agritourism, theoretically.
We have a hayfield operation.
You have a hayfield operation. These conditions and activities include, but are not limited to, the marketing of farm products at roadside stands or farm markets, the operation of machinery and irrigation pumps, the generation of particle emissions, ground or aerial seeding and spraying, the application of chemical fertilizers, let's look up what agritourism activity is. Agritourism activity means any agricultural related activity consistent with a bona fide farm, livestock operation, or ranch, which allows members of the general public for recreational, entertainment, or educational purposes to view or enjoy activities including ranching, historical, cultural, civic, ceremonial, training, and exhibition. So, but I guess so I'm trying to give you a chance to make your case. I'm looking through what you've quoted, and I'm not seeing it. You're saying it's there, but it isn't. So I
don't know the what kind of law is applicable. What I do know is that if that was the case, then there was no farmer anymore in Florida. It's that simple. I mean, if you plow the land, disc the land, you change the land. I mean, how could you say you are not allowed to plow your land?
I see what you're saying.
Yeah?
I see what you're saying.
So, and it's that fact that's happening. That happened on the land. And if there's one tree in the way, you may kill the tree,
right? Because
you want to go and make a nice hayfield. That's the characteristic of a farmland.
I see what you're saying. So in order for you to prevail on that defense, you have to prove that this property is a bona fide farm operation under the Right to Farm Act. It's not good enough that the property is ag exempt. That's not good enough under this law. What it says is you have to have a bona fide farm.
Yeah. I can present you that evidence, no problem at all.
On this parcel? It's a farm?
Yeah.
How big is it?
That's not the only one. It's part of this madam's commons. It was 50, 60 acres. And it was once upon a time 100 acres.
Right.
So it's not one lot. That one lot is part of a bigger deal.
Right.
That's why I gave the map. And I made the with the marker, I said, this is the whole of the farmland or agricultural classified
When,
land.
when was the last time y'all grew stuff out of the property and sold it?
I wrote in this morning, I
Yeah.
told you in 2020, we planted new grass, brand new grass on 40 acres. So the plan was to do each year a new part of that agricultural land. What happened was unforeseen that the lot sales started and it went in a really high pace. So then that's also the reason why we stopped it. I could have asked the property appraiser, I said, hey, listen, we can still make, enough room for that. I thought it's unfair. Once I start selling in below a certain line, you're not serious if you want to ask agricultural classification. And the reason for that is it should be a bona fide agricultural venture. That's what I'm saying. So I worked together with farmer John Thomas, well known over here. I had an agreement with him. He provided his tractors, all his equipment, all the rest of it. I did my work, he did his work, and all the bales that we got in the end, well, were sold, or he has 300 cows himself, so we exchanged that. He paid me every year for it, a certain amount, and
Which is common with people who own a lot of ag exempt property. They often will grow hay and sell it.
Yeah.
But I mean, I'm looking at these.
And I can show you my tax.
Well, I'm looking at the lots and I'm looking at the property appraiser photos, and it does not look like there's any farm activity on them.
Well, I can't
In fact,
help,
it looks
but
like
I
it'd
can
be
tell you.
impossible because of the trees that were there.
I can tell you, I've been to the VAB, and they said the same, and I won all the cases.
Okay.
Because the farmer had a good story about it.
Okay.
He said, I don't do it this year. I skipped this year because of that reason. He gave that. And so that will support my position. They had a look at it. They wanted to skip it. They wanted to lift
They tried to
the
get rid of your
classification.
ag exemption, and you prevailed at the VAB.
Yes. And the very same reason they said, the county said, the property appraiser said.
Okay.
We went to the VAB and won all cases.
What year was that?
I think that was 2018. Could be 17.
Interesting.
But I can present
That's
you that.
interesting. That's interesting.
Well, it's interesting because then I can put a property record card into evidence that shows that in a year well prior to that, it was noted that it had gone to the VAB and a petition had been filed, but there were no notes for 2018.
Was it 2017? I said, my guess. I mean, we're talking about 5 years
It doesn't matter
ago.
to me. I mean, to be honest, I think it's interesting. I think it's relevant. I don't know if it's dispositive. It's already been conceded that the. Let me ask Ms. Antrim this. So, if you look at the Right to Farm Act, it says. Here's what a nuisance is defined as. Any interference with reasonable use and enjoyment of land, including but not limited to noise, smoke, odors, dust, fumes, particle emissions, or vibration. The term also includes all claims that meet the requirements of this definition, regardless of whether the plaintiff designates those claims as brought in nuisance, negligence, trespass, personal injury, strict liability, or other tort. That doesn't seem to include a code enforcement case, but is it your understanding that this would apply to, let's say he's right for a second, just arguendo. Does this stop a code enforcement case or just a nuisance, negligence?
It might under certain circumstances, but I do have a case, let's see, involving Hillsborough County's enforcement of a nuisance.
You're not claiming a nuisance.
Well, actually, the junk and debris portion of our code is nuisance code.
It's in the nuisance chapter,
Yes.
that's right.
But what this case states is if basically whatever wasn't a nuisance when the farm operations started,
Mhm.
those operations can't be considered a nuisance later. What we
Correct.
have them doing here is, this has nothing to do with a hay operation. And I'm not conceding that there actually was a hay operation on this property for any of the last several years. But anything to do with the hay operation could not be considered a nuisance. But if there was other activity outside of the hay operation, that could be nuisance.
That
And if
is
it
what
was
the
a
right-
nuisance,
that is what
you
this
can you
says.
can enforce it. You
Right.
can enforce your county code provisions. The nuisance we're saying here is they're knocking down trees and they're stacking them up on different parcels. They're hauling some dirt, it looks like in some of the cases, to different parcels, which would have absolutely nothing to do with any type of hay operation as it existed when the agricultural classification was first established.
I disagree with that completely.
And also, we are allowed to enforce provisions that existed prior to, or before July of 2000. And our land development code with regard to the site development restrictions did exist prior to that time. And I can provide the various sections that have existed over the year in the land development code.
It's about the same discussion as you have cows on your farmland and you have the agricultural classification. Well, you know what happened? Sometimes they rotate. So sometimes there are no cows on that land. Wow, that's a problem. So if you say it's a hay field, you need to have some place where you stack your vegetative debris or whatever. Every farmer has a corner on his field where he stacks things like that. You can't say if it is a hay field, you should be really from every corner, it should be a hay field. That's not the definition.
It's what the Protection from the Right to Farm Act allows. So to the extent that whatever your agricultural activities, to the extent they existed, those are the ones that are protected from enforcement of nuisance laws, unless there's certain types of nuisance which are outlined in the law.
Would you like the case I was referring to, or
Sure. I mean,
Pasco County versus Tampa Farm Service?
Mhm.
And then I also have Wilson versus Palm Beach, which has to do with land development code provisions that existed prior to.
Do you have an extra copy,
I
or
do.
I can just provide the site? Thank you.
Extra copy for.
If you wouldn't
Ms. Manning?
mind, I mean. All right, so I'm now reviewing Pasco County v. Tampa Farm Service, Inc., 573 Southern 2nd 909, second DCA case from 1990. Wilson et al. V. Palm Beach County, 62 Southern 3rd 1247, fourth DCA case from 2011. I'm just going to review them very briefly. So Wilson is provided for the proposition that to the extent the law existed prior to the Right to Farm Act, you can still enforce it.
Prior to the time, there was an amendment to the Right to Farm Act that said you can't enforce provisions.
I see.
Yeah,
Okay. So that amendment doesn't apply retroactively.
right, correct.
Okay.
Nou, stel je ook niet aan. Je bent ook niet hoor. Ja.
Where's Ms. Katu? Where is you usually know this, so I'm asking. Do you know where the definitions are in the
Chapter 1, very first chapter.
Okay. That kind of makes sense. All right. How many of you expected to spend the whole day with me today?
I was looking forward to it.
Yeah, everyone. Okay. All right. So the definition of development in the LDC actually incorporates the definition that they referenced, which is 380.04. Okay. Okay, I've read Wilson. I understand its holding. What's the purpose of Pasco County?
It's to show that the change in the operation can trigger enforcement of nuisance laws.
Okay. I see. If there's something more than a minor change, and governments are free to regulate changes. We admit this line is difficult to define. Okay, great.
Doesn't give
And-
much.
and-
A lot of help. Go
And
ahead.
the nuisance to whom? 500 feet away.
Yeah, I mean,
That's very arbitrary. Nobody.
I'm struggling to find these lots as a bona fide farm operation based on the photos. I hear what you're saying, and I understand how it might have been in the past, but there's no evidence of these activities in 2023, the time period where the county has shown material, in my opinion, and you can appeal, material changes to the lot. I mean, so I'm struggling to apply the Right to Farm Act in your favor. Let me look at some of your other arguments.
Well, then, but why was then the classification granted for 2022?
Yeah.
The classifications are granted all the time. I don't
Oh, no.
know.
Oh, no.
Oh, yeah.
no.
I have,
Very difficult.
believe me, wink, wink. So I don't know the answer to that, but I mean, it's a fair question. I'm not saying it's a crazy question, but the exemption itself is not relevant. It's the right to farm.
We went to the property appraiser. We is Mr. John Thomas and me.
Yeah.
Every year to explain what we did on the field.
Yeah.
So explained a bona fide agricultural venture.
The evidence is not here.
What's that?
The evidence is not in front of me. I don't see the evidence.
I didn't
of
expect that you would have any doubt about it.
But that's your
I mean,
defense. You've quoted a law. You said this law protects me, and there's no evidence to
Okay.
back it up.
Well, okay.
This is an evidentiary hearing.
Okay.
What's the county's recommendation on those two cases?
For the site development?
Correct.
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate these violations for both cases. This amount was selected based on the actions of the property owners once they revised the violation as well as the irreversible and irreparable damage caused by this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation.
I'm going to reject the county's recommendation. Due to the number of cases that we have with this matter, I don't find it bad faith. I don't have evidence of that. I think they've made a good faith Right to Farm Act argument. I think the property is in violation because I don't have the evidence to sustain the defense. I'm going to assess a fine of $2,000 in each of those cases, 218-5676 and 218-5678. In the junkyard conditions case, I don't know if I fully understand. I've been focused on the site modification cases, so I want to kind of start over on the junkyard conditions case. What is the defense on the junkyard conditions case?
At first was agriculture accepted, so until January the 1st this year, it was exempted. Then, if Citrus County finds it a problem, and I disagree with it, but I'm not Citrus County, they have always the power to say it's a nuisance, even if it is 3 miles away and nobody notices it. So I was more than happy. I offered this gentleman, shall we burn it? Completely resolve the issue.
Oh, this is the gopher tortoise. Now I'm remembering.
That's
okay,
it.
The gopher tortoise.
And I can't do it.
My understanding is there are gopher tortoise removal services. I
No.
don't understand.
No. Then you better fine me, because they first, I know it, because the city of Inverness just informed me about a water line. First, they do a survey, $3,000. Then every turtle they find should be relocated, $3,000 each.
My clients have never paid that much, but
So they think about 20 to 30 are in the way. So I don't do it. And if I even touch them, and
if there are gopher tortoises, there's certainly a problem.
Yeah, and as long as you may ask me everything, as long as you ask Citrus County to hold me harmless, then it's fine. If they pay the fine with FWC, the Florida Wildlife, then it's fine with me.
I see what you're saying.
But they have fined the builder over there already. He can go to court.
Does Code have experience with these gopher tortoises getting in the way of compliance? I mean,
no, we haven't. And FWC has been out there, but
I've had clients get in trouble with them on this. I mean,
it
I've never had them cost remotely that much money, but
it hasn't gotten in the way of compliance. No.
Okay.
So I'm more than happy to do so, but I'm not taking the risk. So I'll do it because Citrus County orders me, and they may pay the fine or may go to jail.
Well, I certainly don't have that kind of authority.
Can I ask Mr. Norman if there are other methods of disposing of tree debris
Okay.
than burning?
Well, no, there are. I mean, I know there's other methods.
So I just didn't know if you wanted.
No, I understand that there's other methods.
We had discussed those options when I initially went out to the property and I went over every on that section that he's referring to on block 13, that section in between Rejoice and Jay. While I was out there, I verified which properties had violations and which ones belonged to DT villages at the time of my inspection. And we discussed in great detail what kind of options he had to remove that tree debris. And throughout this entire process and inspection process, not only myself can attest to it, but other code officers as well. The tree debris has constantly changed. And there's tree debris that has been out there and placed out there that isn't even relative
I
to
had a client who had a
to-
case here recently, and they ended up getting a truck and they moved the tree debris. But
It's feasible. It's
Um,
going to take some delicacy, but it's feasible.
Do the pictures prove that?
prove what?
Moving of debris?
I'm not making any findings about the moving of debris.
Yeah. Go ahead.
Go ahead.
I would suggest that these lots are not being developed or whatsoever. Can't you just
Leave
let
it.
sit there?
Let wildlife sit there. Who cares? Well,
In the public, whoever
No, but
complains,
it's-
Okay, good question. Whoever, who?
it doesn't
Who?
matter. Honestly, it doesn't matter. I mean, unless you can prove that it is an arbitrary and unequal protection issue. Now, you've admitted something that would be relevant to prove that, but you have not proved that this is corruption.
Politically motivated.
I mean, everyone who's a citizen has a right to point out a code violation. And you've heard me at other hearings today,
Yeah, neighbors about chickens and that sort of, and
but there's no
dogs.
difference.
but
Any
not a
citizen-
commissioner
any
who's living
citizen
10
can
miles
complain.
away.
Any citizen can complain.
Yeah, true. But sometimes it's not possible. You know, I'm in a quandary. I don't know what to do because if I had the chance, I would have burned it once Florida Forestry had lifted the burn ban in June. No problem at all. I would do that.
How much time do you think you might need to? I mean, this is
to clear it.
Yeah, to clear it.
5 years, hopefully, hopefully, and then it's decayed because I don't want to go in with heavy machines. I don't do it.
This
simply.
This would take a lawn company.
A lawn company to mow the grass, you mean?
No, a lawn company to chainsaw the tree debris and put it on a truck. It would take a couple days.
True, but I have to go. I can't lift it. Maybe there are people that.
This is done with hurricane debris all the time. So I'm not.
No.
How
I'm not
much
gonna
time
do
do you
that.
think you need to get rid of the tree debris?
I'm not going to do it because unless I will be held harmless against Florida wildlife. I don't do it. I know what they do. They pick the guy, the builder. He's risking jail time. It's really tough what they do now. Thanks to the politically motivated Miss whatever her name is, Davis. Yeah, she.
I just don't understand how gopher tortoises can keep you from chainsawing the debris and loading it onto a truck.
I'm not allowed to go over there. You're not allowed to touch anything. The water line had maybe from here till that wall of the 8,000 feet had to be done. There was a gopher, more or less where that lady is.
Okay.
Yeah. And they stopped the whole project. You had to survey the whole project again, and you have to relocate that.
Then what I'm going to do is I'm going to attempt in good faith. I know you're not going to like it, but I'm going to attempt in good faith to give you an amount of time to do something about it. Whether it's starting with the gopher tortoises and then getting rid of the tree debris, or just getting rid of the tree debris.
Okay, gopher tortoises, I heard it yesterday, is a time of 6 months before they can even start relocating.
Okay.
I can show you the paper. I didn't bring it with me because I know it. I know it how it works. So you can ask me to do it, but it's a silly thing. And cities counties should really be ashamed to say, of course, leave it decay. We shouldn't have asked you. Leave it. Let nature do the course. Done. They only make a case out of it. And they use the people to do it. I'm not saying you, but... And that
I've
makes
heard
me
worse,
sick.
believe me.
It's a case made up. There is no case. There is nobody living there. Nobody. It hurts no one. It's in the middle of the woods. So
It's like Ms. Davis said in the paper, all agencies will continue to ratchet up the pressure. And that's because she has made it her quest to help the homeowners in that subdivision do something about the roads. She thinks that either we or the builder are responsible for the roads, which we
for
are
Citrus
not.
County's roads.
Citrus County owns those roads, and they don't want to buy it. And so she's trying to, I don't know, she's trying to blame everything on everybody else instead of looking at herself. And this is part of this. This is just show the public that look how tough we are against the builder and the homeowner and the lot owner.
Yes, and the lots
See
are
what
not
they're
for
doing.
sale.
All for you.
If there wasn't a violation, you'd win the case. I mean, it's just, I think there is a violation. And I'm going to, what is the county's recommendation?
For the case for 202300130, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find it its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
And this is why I don't like people like you. You don't listen to my arguments. That was on your paper before you came in. So why do I make an argument over here? You don't listen to me. Nothing at all. That's always the case.
Well,
you could have changed your mind and you could have said, oh, that's an argument I didn't think about.
And sometimes they do.
Oh, well, not this guy.
Yes, I sit here every month and they do.
Oh, well, that's new to me.
You haven't watched the hearings. I am going to find that the property is in violation. I can't dismiss the gopher tortoise issue. I think it can be rectified, but I have dealt with it myself.
I think our goal is just compliance, sir. That's all. I mean, with the reasonable amount of time that you deem sufficient, our goal is just compliance.
Well, I'm going to grant 7 months to get it done, and if it's not brought into compliance in 7 months, $150 a day.
Thank you, sir.
All right, so that's that case.
150.
Next case is on the agenda, Mimosa Hills LLC. Case numbers 2023-00128 and 2023-00131. Code Officer Brandon Norman. Pages 30 and 31 of your agenda.
This one's in similar as far as for the junk and debris case. This is one of the ones that was also, once we were notified that the property ownership had changed, I went back out, verified, so the dates will be different from that of the other inspection for the other case.
Okay.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 2023-00131.
Oh, okay.
Can you just confirm the cases one more time? I apologize.
Yes, sir.
Just want to make sure I have the right one.
128 and 131.
Still
Tracking. I got the right one.
You got
just
them?
want to make sure. Yep. This is for accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances for both cases. The address for case number 1 ending in 131 is for address 4554 East Rejoice Street in Inverness, Florida. For the case ending in 128, the address is 4495 East J Street, Inverness, Florida. The property owners for both addresses are Mimosa Hills LLC. For both cases, I have good service via confirmation email between the Citrus County Code Compliance Office and the Respondent's Attorney's Office. For both cases, I would like to authenticate the following documents and request they be admitted into evidence. For case ending in 131, Exhibit A will be photos taken during the initial inspection on May 12th, 2023, the corrective action inspection on May 31st, 2023, and the final inspection conducted yesterday, October 17th, 2023. For Exhibit B, it will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code Compliance and the Respondent's Attorney's Office. Exhibit C for both cases will be a copy of The LLC amendments and Florida limited liability forms for DT Villages 11 LLC and Garden Estates of Inverness LLC. Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Garden Estates of Inverness LLC for each respective address. Oh, I apologize to Mimosa Hills LLC.
And it's exhibits A through D in each case?
So it's A through D for each case, yes, sir.
Okay. I'd like to ask you to, if they want to review them, please take a
I
look.
think they're all similar. Well,
They are?
okay, you may give it.
So you're accepting? We're good? Okay.
I'm accepting it.
Just want to make sure.
Hoeveel heb ik er? 4 keer dus. Plus 1500. 10.500.
Thank you.
Gaat wel zo.
Thank you.
Nee, ik vraag aan die meneer ga ik vragen hoe het goedkoper kan. Hij zegt dat het erg duur is.
Please proceed.
I'd just like to reincorporate what I've mentioned before about how these addresses were identified as far as once the ownership changed from the previous that I mentioned, if that's okay.
And what exactly are you referring to?
In
How,
regards,
you said how the addresses were identified.
So in my initial inspection, right, there were one large address with different lots.
Right.
Once I was made aware that
They
the
were
ownership had
assigned
changed.
addresses.
Yep. They had one large address for
Okay.
a lot of lots that were out there.
Okay.
Once I was notified of the ownership change, I went back out and verified, and that's when I started my inspection
I
process.
care more about the legal descriptions than I do the addresses, just FYI.
Exactly. Me too.
Yeah. All right. So I'll reincorporate it.
Thank you.
Yeah.
On May 12th, 2023, I conducted an inspection of the property. Once I was notified of the new ownership changed, I found that it was in violation of the aforementioned ordinance. At my corrective action inspection on May 31st, 2023, I found the property remained in violation for both addresses. And then as of yesterday, October 17th, 2023, I find that while it is overgrown, I still find that the violation still exists, and they are in violation of the ordinance mentioned above.
Ik wil even die dat overzicht van mij.
It can be a little disorienting out there too, so some of the angles may in fact look similar, but I can confirm that I went out there and measured properly for the addresses where the violations are present.
Testimony is evidence.
Yes, sir.
All right, y'all are gluttons for punishment. What do you want to say on these cases?
I think they're all similar, but I want to check and it went too fast for me. What are the numbers now we're talking about?
Mimosa Hills.
Are you
Mimosa
asking
Hills?
For the
That's-
case, are you asking for the case number or for the address?
Yeah, the case numbers.
The case numbers that we're talking about right now are CE 2023-00131 and CE 2023-00128.
Oh, D2. Okay. Okay. Now I got it. I've got the legal here. So that's lot 28. That is for the 28 is lot 28, lot 13, and the 31 is 3 lots, 9, 10, and number 25, block 13. That's correct. I just want to check it because
Which lots?
the
Case number ending in 128 ceased to lot 28 in block 13.
Mm-hmm.
And case number ending in 131 ceased to 3 lots, lot number 9, number 10, and number 25 in block 13.
Okay, thank you. Mr. Norman, I am looking through the exhibits.
Yes, sir.
And I think I have I think I'm missing some. So I have A through D on the case number ending 131.
Can I approach real quick? Just
Yeah, maybe I'm not missing, but I think I only have A. I don't know. Can you help me?
Yes, sir. Yeah. Sorry, I jumped up together.
I was looking for the deed. Oh, gosh, I don't know where it's.
Yes, it's on 2 pages. So
Warranty deed.
Okay, all right.
There's C and D.
Okay, thanks. Well, you need to make whatever record you need to make if you are going to appeal it. So you have an opportunity to make your case here. I haven't made a ruling yet, but go ahead, please.
Well, I say it again. The pictures, I can't see on these pictures what lot numbers there are, the legals. I don't see that. He came up with one address with a lot of lots that doesn't exist anymore. They were disappeared.
What do you mean they disappeared?
Well, they don't come back. So if I may, I give you an example of what I'm saying. Now I need my page again.
There's one that you said is lots 9, 10, and 25.
Yes, and that was before we transferred it to our other companies in March. And that was the big chunk, was lot 8, 9, 10, 11, 13, 14, 20, 21, 22, 23, 24, 25, 26. Some of them are, luckily, I call disappeared or whatever, not part of this case anymore.
Okay.
That's a good thing.
I see. So you're asking, well, and so Mr. Norman, I think what he's bringing up is something I've asked you in prior cases in this neighborhood. I don't understand how you can tell which lot is which.
I can comment on that. There's survey marks that are out there. I've used geographical, I don't want to say landmarks so much, but I've used images from the PA. I've used a measuring wheel. The lots are 90 by 150. I've measured out the lots when it comes to the re-verification purpose of.
So let's talk about these
Yes, sir.
in particular. You used a measuring wheel?
I did use a measuring wheel.
Okay. In other words, to measure the 90.
To measure the 90 portion, yes, sir. That way I can determine.
How do you know where to start with
the survey stakes that are out there?
Okay. You're matching up survey stakes.
But I'm also using my position right in the aerial image to confirm that I am exactly in the right spot as well. So
okay.
It's a very Lewis and Clark kind of situation out there, I'll be honest with you, sir. But I assure you I've done my due diligence in verifying that these are the correct addresses for where these violations are existing.
Did you say Lois and Clark or Lewis and Clark?
I think I said I could have misspoke, but I think I said Lewis.
I am pretty sure you said Lois.
Hey,
and last I checked,
who knows?
They were city dwellers. But at any rate,
but I'd like to know the same pictures, the same second taken of different lots. That can be true.
Help me out. Give me the example.
Well, it was in my was one of my remarks I made.
I do. I remember that. I'm just trying to.
Some of the images he's referring to could be from my initial inspection when I was out there at
Well,
March 23rd.
if you don't mind, let me just hear what they have
Yeah.
to say.
Oh, God. Oh, there's 1, 2, 3. We have to go back. I even don't know where my paperwork is.
I thought that had to do with the J Street lots.
Yeah.
But I could be wrong.
The rejoice. I said one additional remark about case number the 4532 rejoice.
Okay.
this only pertains to lot 8 and lot 13. However, the county, in support of its position, has attached photographs of 4 or 5 additional lots and concludes something out of it. So the evidence is conflicting and it doesn't support. And then I had another one. That was, this one, that was 4549 J Street and 4575 J Street. I said they're not adjacent to each other.
Mm-hmm. This is the one I remember, yeah.
And the county's using the same photos.
And the same
for
photo.
in both of the cases.
So how can you do that? What kind of evidence is that?
Let's go back and look real quick. So 40, which one? Can you give me the numbers on those real quick?
Case number ending in 129.
129
And 130.
and 130.
All right, I'm only reopening just to look at the photos really quickly. 130 and 129.
And these lots are not adjacent to each
Yeah,
other.
I don't think
Have we-
we've
we
gotten
haven't
to
had 139
129.
Oh, we haven't gotten there? Is it on the agenda?
Yeah, that's Miranda Springs is 129.
We
That's
still
the
have
next.
more of these?
We have
Yes.
one.
Okay.
We have one more, sir.
We have one more.
All right. Okay, then I will wait to take that issue up when that case comes up. We'll compare. Let's talk about 4495 East J and 4554 East Rejoice. Do you want to reincorporate your defenses that you've made in the other cases regarding the junkyard conditions?
Mm-hmm.
Okay. Do you have any other defenses you want to make on the record?
No, didn't we present our, that I read?
No.
Oh. Can we bring that into evidence, what I all,
Oh, your
the
written.
Yeah.
So the thing about that is that everything you said is evidence. It's already in the record.
Oh.
I will admit it for the sole purpose of it being your intended testimony. But I am not going to admit it as a secondary evidence. In other words, you've put your evidence on the record. You said everything. I don't want there to be a conflicting, like you said this, but you also said this, if there's any deviation between.
Okay.
So I don't mind admitting it for the purpose of showing what you had intended to say, but I'm not going to admit it as evidence per se, because you've already put it all under the record.
Does it make a difference if we hand it over, yes or no?
It doesn't make a difference to me, but it's up to you. I mean, you want to lay the record you want to lay, so I'm willing to include it, but you're going to need a transcript anyways for if you want to do anything. So
No, she was only.
No.
Oh, she was only there.
no court reporter.
What is it?
Yeah, you
What is
can-
that?
No, we only need one. Yeah, just let Miss Antrim.
Look at it before
Let
it
Miss
goes
Antrim
there,
look at
that's
it.
all. Thanks. Oh, this is the testimony you've already
Yeah.
provided. All right.
Yeah.
And you've already stated that you're going to take,
I'm not admitting it as evidence because they've already put it all into the record.
But
It's
you're-
already evidence.
you're incorporating what they read
I
into the
want
record.
them to have a chance to lay the record that they want. So I'm going to incorporate it just as an example of what they had intended to testify to, but not as independent evidence. What they put on the record is the evidence.
Oh, sure. Go ahead. Wat komt nog? Nee. Oh. Oh, I thought we were done.
I had hoped, got excited for a second, but
Do you want it back?
No.
No,
Okay.
no, not at all. No, but I mean, I think it's similar case.
well, while Ms. Antrim's looking at that, are there any other defenses you want to make on these junkyard cases?
No.
Okay. We've already incorporated all your other arguments and defenses. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate both violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally define that it's the respondent's responsibility to contact the Code Compliance Division once the violation has been abated to allow for reinspection.
Are these also properties that you have been notified you have gopher tortoises on?
It's all around. So I don't know if it is exact on that property, but if there are 30, I can assure you with all the burrows and things like that, and the hunting they do at this moment.
Okay. Grant on each case, 7 months to bring it in compliance. If it's not brought into compliance, $150 a day.
Thank you.
Are you making the same findings as to the no evidence of a farming activity?
Oh, I mean, I have to. If I didn't, then they'd prevail.
And
I'll issue written orders on all these, obviously.
I have a question of order. What can I say to the Garcias? Does it come back, or did you order on it, or?
I'm going to issue written orders on those cases, just
Oh.
like yours, and they'll also have an opportunity to appeal.
Oh, okay. Wow.
So
I'm not admitting it as evidence. I'm admitting it as a document
all
that
right.
they wanted introduced as evidence, but that I don't believe is evidence. I just want it as part of the record. They had this document. This is what they wanted to testify to.
Are you giving it an exhibit number, or you're just
No,
having it a
it's not an
document in the
exhibit.
record? Thank you. Just wanted to clarify.
I just want to make sure there's nothing that I missed.
Well, then I missed it too.
Yes.
Okay. All right, what's the next case?
Next case, Miranda Springs LLC, case number 2023-00129, Code Officer Brandon Norman, page 32 of your agenda.
This is case number 2023-00129, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for 4549 East J Street in Inverness, Florida. Property owner listed as Miranda Springs LLC. I have good service via confirmation email between the Citrus County Code Compliance Office and the respondent's attorney's office. I would like to authenticate the following documents requested to be admitted into evidence. Exhibit A will be photos taken during the initial inspection on May 12th, 2023. The corrective action inspection on May 31st, 2023, and the final inspection done yesterday, October 17th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the email chain between Citrus County Code Compliance and the respondent's attorney's office. Exhibit C will be a copy of the LLC amendments and Florida limited liability forms for DT Villages 11 LLC and Miranda Springs LLC. And Exhibit D will be a copy of the warranty deed from DT Villages 11 LLC to Miranda Springs LLC.
All right, this is just one case.
Just one case with Miranda Springs, yes, sir.
Could you please show those documents to respondents?
Yes, sir.
And if they would
You can
like
go ahead.
to.
I
Nope.
believe it.
All right. Is there anyone from the public who wants to be heard on this case? I'm glad you still have a sense of humor.
But I like to say something about it. This, oh,
There you go.
All right, without objection, exhibits A through D are evidence. So I usually let them present their case first. Go ahead.
On May 12th, 2023, when I was notified the new ownership, I conducted an inspection of the property and found it to be in violation. My corrective action inspection on May 31st, 2023, the property remained in violation, and as of yesterday, October 17th, 2023, although overgrown, you can still, the junk and debris still remains.
Aha, now, so I think this is the one where they had said
Yes.
photos were
Correct.
similar or identical. And I'm now looking. So exhibit A, page 1 on case number ending in 129, and page 1, exhibit A on case number ending in 130 are indeed identical. Why is that?
Can I take a look at it?
Sure.
It's quite possible it's a technical error on my part.
Do you know which one is accurate? But, don't mind, I'll keep taking a look through these photos. Let's see. This is a little bit of a quandary. I'm not going to admit page 1 of Exhibit A. Even though it was without objection, I can't admit it. So, all right.
Is that for each case or just this?
I already
case?
admitted it in the other case.
So you're not admitting it in this case?
You know, the thing is, there's no contrary evidence that I've been given regarding these properties. I can't admit page 1 for sure because the county doesn't know if it's this lot or another lot. The other pages are different, and there is testimony that it's this address. I do think there's a slight credibility issue established by this.
Can I ask Mr. Norman some questions?
Yeah, please.
Mr. Norman, are these two properties adjacent to each other?
I would need to review an aerial map with the addresses to verify and make sure.
Do you have one you can review?
I don't have one in front of me, no.
No, they're not.
Oh, okay.
I can pull it up on my phone.
We've
though,
had
and verify.
repeated testimony that it's not
Okay,
adjacent.
that's fine then. I was just thinking maybe he was on
I
the
know.
property
What-
line, that's all. But no, if they're not adjacent, then that's not the case.
It could definitely be a technical error on my part.
Well, it wouldn't matter. It's not getting admitted.
I understand.
The issue with evidence, of course, is that photos are not the only evidence. You have testimonial evidence, and there are the other photos. So, have you completed the presentation of your case?
I have completed the presentation.
All right. Miranda Springs LLC. Would you like to reincorporate your defenses from other cases?
Yes, but I'd like to tell you that it's not only one picture that is the same. There
Okay.
are more in there if you compare it. It's not only one.
Okay, help me out.
Can I get them both?
Yeah, I mean, show me. So the only photos I have are in Exhibit A,
And the other one?
and the other one is right here. Now, we have to be careful. We don't want to get them all mixed up. But obviously, page 1 is the same. Oh. Yeah, one has 3 pages, one has 4 pages.
About the same, but not the same.
Well, I know.
But, I mean,
I know what you mean. I
guarantee
mean, you go into the desert in Arizona and all the shots look the same no matter where you are. I get it.
I don't want to mix it up.
Yep, thank you. All right, so do you want to incorporate the defenses you have already made on the other junkyard conditions cases?
All same, yes.
All right, as well as testimony you've offered regarding all your other defenses, including the arbitrary and capricious enforcement.
Yeah.
Okay.
Yes, please.
I will incorporate your prior evidentiary exhibits as well. I'm not happy about the fact that it's the same photo, but I actually think you've established a prima facie case. It does show, and you've testified And you're sure of your testimony despite the photos?
Despite my photos, yes, sir.
Okay.
There was a lot of photos, and
And to me, I don't care. I have to clear it anyway, and I can find it on each lot and say, oh, this is this lot or whatever. If I have to clear the trees over there, I clear them all.
No, I get
whatever
it.
lot.
I get it. All right.
You know? So makes no
So what's the county's recommendation?
The Citrus County Code Compliance Division requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to additionally find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
7 months, $150.
Thank you, sir.
Yeah. Any more?
You're free. I wasn't, you could have leave at any time, but you're done with the hearing. Okay. Good luck. Give my regards to Mr. Ozma if you talk to him before I do.
And may I ask you, if you have a cheaper solution for the government, I'm more than happy to hear.
I always recommend landmines to people, but they're unfortunately really traceable. They're really traceable these days. So
No, but your experience, is it?
no, I mean, in my, the last time I did a gopher tortoise removal was 2 years ago. Maybe the prices have gone up a lot in the last 2 years. I don't know. So
I wish I knew
Yeah.
someone, But anyway, let's see.
you used to get competitive rates in the Villages area. That's all I can say. So
Thank you very much for today, and everybody have a very nice
good luck.
Yes, sir. Take care.
So say we're not done.
Yeah, we'll hang out a little
Do you
bit
want to proceed?
have more
Do you want to? Okay.
All right.
till the doors close.
No problem.
Yep.
Next case on the day's agenda, Saul Johnson, Brenda Pierce, and Daryl Charles Ballard. Case number 2023-00321. Code Officer Cody McGuire, page 21 of your agenda. Joanna Katu, expert witness on the case.
It's been a long day. Still got me going.
Solve a lot of problems that way.
Good way to fish too.
Yeah.
Unless you're behind Beth's house.
You ready?
Yeah.
All right. Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-00321. Special requirements for all accessory structures. A violation of Citrus County Land Development Code 3102A. Address 8336 West Candleglow Street, Crystal River, Florida. Property owner is Johnson Sal, Pierce Brenda, and Ballard Daryl Charles. Good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on June 29th, 2023, a follow-up inspection on July 20th, and photos taken during a corrective action inspection on August 23rd, 2023, and photos of my final inspection on October 17th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property, and a pre-hearing order.
Okay. Anyone from the public on this case? Nope. Any other
This is a
testimony from the
underground
county?
septic tank?
Do you want to
They
give
don't
it?
have it.
We don't need to
Yes.
wait.
I'm still shaking on the landmine.
You're traumatized? All right.
Yes, I really am.
Well, I can do worse.
No, please don't. Please don't. It's been a long day. Coastal Lakes Residential, 2.6 acres. They do have a permit application in. It has not been issued yet. They did also ask to live in the RV, which could be allowed once the permit's issued. However, the permit has not been issued. They're waiting for approval from the state for help for septic.
Oh, okay. I mean,
They didn't apply until last month,
and
so.
we don't know how long that'll
Right,
take.
right. They didn't apply until long after they turned in the building permit.
Okay. Mr. McGuire, any other testimony? Exhibits A and B are admitted.
Sir?
Go ahead with your case.
On June 29th, I conducted an initial inspection and observed 4 RVs on a vacant property. On July 20th, a follow-up inspection was conducted with another attempt to get in contact with the property owners by leaving a pink door hanger on the RV to the right. On August 23rd, 2023, a corrective action inspection was conducted with no change. I've had contact with the property owners Sal Johnson and Daryl Boward on October 4th and 5th as we spoke about having RVs on our property as a home was being built. As of my final inspection on October 17th, 2023, the property remains in violation and no permit has been issued for the RVs to remain on vacant property.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that a special master assesses a fine of $100 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We also would ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for a reinspection.
I mean, so getting something from the county is not enough, right? Or to abate the violation? Because we need health.
They can't get it from the county without the health. So
Can't get
it's
it from the
before.
county without
It's
the-
before the issuance. It's an issuance requirement for the permit that they have a septic permit.
Okay, I understand. How long does this normally take? I mean,
They're dragging it out. Their permit was not issued, but
Applied
for on November 3rd of 2022.
That's the house permit.
Okay.
The septic permit came in about 3 weeks ago or
Okay.
so it may be a few more weeks if that's
Okay.
approved. I don't
do you
know if
think
it will be.
2 months is reasonable? Yes. All right.
And just to clarify, Cody, when you say they're dragging it out, do you mean the applicant or the county?
The applicant.
Okay, thank you.
Okay, that's how I construed it.
sorry. The applicant is dragging it out.
Okay. The property's in violation. 2 months, $50.
2 months, $50?
Yep. We're going on a streamlined order diet here.
Next case, AmirHouses.com LLC, 2023-00447. Code Officer Alan Johnson, page 5 of your agenda.
Y'all need to sit closer.
I'd just like to
Let's walk
state for the
in.
record, I love the landmine idea. I think it's fantastic.
I'm writing an article for the Bar Journal about
I like
them. I really think they're underused. I think we have got to start using these.
I think it can be something that can be implemented countywide. I do.
It'll solve a lot of problems, Mr.
Bright
Johnson.
minds.
Yeah.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202300447. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 3490 East Fisherman's Lane, Hernando, Florida. Property owner is AmirHouses.com LLC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 19 July 2023. Photos from my
Are all the dates on the photos when you took them?
Yes, sir.
Did you take all the photos?
Yes, sir.
Is there anyone from the public who wishes to be heard on this? Are there any objections to exhibits A and B being evidence in this case? Nope. Does the county have any objection? Does the county have any objection? Exhibits A and B are evidence?
We don't object to our own exhibits, no.
All right. Well, I mean, you look at them, so I'm like, go ahead.
On 19 July 2023, I conducted an initial inspection and observed the property to be in violation. On 19 July 2023, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the ordinance mentioned earlier. On 21 August 2023, I conducted a compliance inspection and observed that the property remained in violation. I have had brief contact with the property owner, and as of my final inspection on 17 October 2023, the property remains in violation.
Looks like some improvement.
Cut the grass.
Yeah, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, 1 month to comply, $100 a day if not.
Thank you.
Next case, Banzery Corp., case number 2023-00765. Code Officer Amy Becker, page 6 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 2023-765, excessive growth and accumulation of vegetation.
I know this company.
Pardon?
We've had this company.
I thought you said you owned it.
Oh, no, no, no.
So did I. Was gonna.
I don't, I mean, but this is a frequent flyer. Yeah.
The address is 34 South Adams Street, Beverly Hills, Florida. The property owner is Banner C Corp. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 25th, 2023. Photo taken on September 12th of my corrective action inspection, and photos taken on my final inspection, October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on September 18th, 2023.
Are there any objections to exhibits A and B? No, they're evidence. Is there anyone from the public who wants to be heard on this case? No.
On August 25th, I conducted my initial inspection. The grass was overgrown over 18 inches. As of my final inspection on October 17th, the lawn remains in violation.
I agree. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, 14 days to comply, $50 a day if they don't.
Next case, Jose R. and Janelle Correa, case number 2023-00752, Code Officer Amy Becker, page 11 of your agenda.
Amy Becker, Co-Compliance Officer, case number 2023-752, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 8285 North Rhonda Drive, Citrus Springs, Florida. The property owner is Jose R. Correa and Janelle Correa. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on August 24th, 2023. Photos taken on September 12th, 2023 of my corrective action inspection. Photos taken on my final inspection, October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on September 18th, 2023.
Is there anyone from the public who wants to be heard on this case? No? Without objection, exhibits A and B are evidence. I agree that there is a violation based on the dates and photos, although on your I mean, that looks pretty good. Oh, okay. For anyone who thinks I don't look at the photos,
It's the left, it's the right side of the house that's still in
Okay.
violation. I talked to the owner, so I've spoken with Jose, and he's mowing it, he's getting it done, so it's just the right side.
what is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection. And he has had health issues.
Okay.
I'm going to ask
Okay.
for the 30 days.
Okay, so ordered, 30 days and $50 a day if it's not. I assume the next case will be Daly, case number
Yes.
2023-00689.
I'm sorry.
Code Officer Amy Becker on the case.
Amy Becker, case number 2023-689, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Address is 771 West Margarita Drive, Citrus Springs, Florida. Property owner is Johanna Mosea Daly. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on August 18th, 2023. Photos taken on September 6th at my corrective action inspection. Photos taken on October 5th showing the posting of the property. And photos taken on my final inspection, October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? I don't see any. Exhibits A and B are admitted as evidence. Do we have to stop right at 5 or just before?
We can finish.
Okay.
We're not the courthouse.
You don't? Do you have any like overtime issues or anything like that?
For salary, we're here.
Okay.
And I don't want to.
Well, we're still gonna hustle. I mean, I don't think it'll take us much past 5. According to my projections, it'll be about 5:06-ish. So, please proceed.
Thank you. Thank you.
I know.
I'm trying. October 18th, 2023, I conducted my initial inspection for excessive growth and accumulation of vegetation.
August 18th.
August 18th, thank you. And observed grass in excess of 18 inches. As of my final inspection on October 17th, 2023, there's been no change. The home appears vacant. I've left my card again, so I have not had contact with the owner.
All right. I mean, it's pretty self-evident from the photos there's a violation. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered. I'll grant 14 days, and if not brought into compliance as ordered, $50 fine per day.
Okay. Next case is going to be George David Ignatin. Case number 2023-00709, Code Officer Amy Becker. You should do one of those car commercials, you know, where they have the disclaimer at the end, they talk really, really fast.
Her and Brandon, I think, could maybe
Yeah.
tie for that.
Yeah. No, Amy beats him.
I think they can do better.
Say that again?
I said you should do one of the car commercials where they have the disclaimer at the end, where they talk really, really fast.
And Christian says you can do faster. So let's see what happens if you kick it up a notch.
It's gonna sound like a chipmunk.
Amy Becker, Citrus County Code Compliance Officer, case number 2023-709, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 1685 North Prospect Avenue, Lecanto, Florida. The property owner is George David Ignitant. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Photos taken during my initial inspection on August 22nd, 2023. Photo taken on September 13th at my corrective action inspection. Photos taken on August 5th showing the posting of the property, and photos taken on my final inspection on October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the posting affidavit.
Is there anyone from the public who wants to be heard? No?
For
Without
the record,
objection?
I just wanted to state that she posted it on October 5th, not August 5th.
Okay. Without objection, what's been proposed as exhibits A and B are evidence? One of these.
On August 22nd, 2023, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in excess of 18 inches. As of my final inspection on October 17th, 2023, the majority of the backyard is mowed. However, there's still areas that remain in excess of 18 inches. On October 11th, I called and left a voice message advising the owner of the violation. I called again on October 17th. He's had a prior complaint. He doesn't reach out to me. But anyway, I did leave him a voice message at 9 o'clock on 10/18 as well.
What's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, 21 days to comply, $50 if not, per day.
Next case, Ricky Wayne Landrum. Case number 2023-00761, Code Officer Amy Becker, page 25.
Amy Becker, Code Compliance Officer, case number 2023-761, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Address is 9 South Fillmore Street, Beverly Hills, Florida. The property owner is Ricky Wayne Landrum. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on August 25th, 2023. Photos taken on September 13th at my corrective action inspection, and photos taken on my final inspection October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on September 18th, 2023.
Is there anyone from the public who wants to be heard on this case? No. Without objection, what's been proposed as Exhibits A and B are evidence.
On August 25th, I conducted my initial inspection and found the grass to be in excess of 18 inches. As of my final inspection, October 17th, part of the front has been mowed. However, to the backyard to the right has not. I have not had contact with the owner recently. We have an unsafe slum blight case on this address as well.
Really? Okay.
9 South. So the last
Seems
time
redundant, doesn't it? I mean, isn't this case redundant?
I was told to
Okay.
do
No, I'm just
it.
curious.
Yeah,
Okay.
I was told to do it, to see if we could get some type of response. Sometimes when we go this direction, we'll get a response, and then that'll gear it up to the
Okay.
rest of it. That's all I have.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, I'll grant 21 days to bring into compliance and $100 per day if they don't. We have 3 more cases.
Actually, two were abated.
One abate, which one? Which one abated?
Bingham, page
Bingham,
8.
okay.
Yeah, Bingham.
All right. Music to my ears.
All right.
So now
You
we're
ready?
on Pancrat's,
Pancreas.
case number 2023-00744, page 33 of our agenda.
That works.
Yep.
Yes, sir.
Listen, we're
Amy Becker, Citrus County Code Compliance Officer. This is case number 2023-744, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. Address is 2061 West Howard Place, Citrus Springs, Florida. The property owner is Brennan Paratz and Camellia Black. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on August 24th, 2023. Photos taken on September 12th at my corrective action inspection, and photos taken on my final inspection October 17th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the posting affidavit.
Is there anyone from the public who wants to be heard on this case? No? Without objection, what's proposed as Exhibits A and B are evidence.
On August 24th, I conducted my initial inspection for excessive growth and accumulation of vegetation, observed grass in excess of 18 inches at the property. As of my final inspection on October 17th, the lawn's been mowed.
Yeah, looks
However,
pretty good.
there's accumulation of vegetation matter at the property. I've not had contact with the owner, the home appears vacant. However, on October 17th, a woman called. She identified herself as a friend of the owner's and advised the lawn had been mowed. I advised her I was unable to abate with vegetative matter, had to be removed before I can abate it.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, 14 days, $50.
Next case, last case.
Last one, fast
Michael
one.
Silcott, Michael and Tara Silcott. Case number 2023-0060, Amy Becker, page 37 of your agenda.
Amy Becker, Code Compliance Officer, case number 2023-606, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 93 South Tyler Street, Beverly Hills, Florida. The property owners Michael Silcott and Tara Silcott. I have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on August 3rd, 2023. Photos taken on August 17th, 2023 at my corrective action inspection. Photos taken on September 8th. Photos taken on October 5th, showing the posting of the property, and photos taken on my final inspection, October 17th, 2023.
Bless.
Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a pre-hearing order, and a copy of the posting affidavit.
Is there anyone from the public who wants to be heard on this case? Oh, man, I swear. Without objection, what's proposed as Exhibits A and B are evidence.
Sandra, you are not a part of the
Okay.
Yeah, go home.
On August 3rd, 2023, I conducted my initial inspection for accumulation of junk and debris. So in the first couple pages, you're going to see a dresser that's behind a shed. You're going to see a mattress, box spring, and an appliance in the backyard. I'm getting access from the neighbor's property behind. Okay. I did contact on August 17th. I spoke with the owner, Tara, and advised her I was unable to abate. They removed the dresser. That's gone. So the only thing left is that pile of vegetative matter in the backyard. That's it.
Oh, man. Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs, begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
So ordered, 14 days to comply, $50 a day if they fail to. Is there anything else?
No, sir.
No, sir.
Time is about 5:06. This hearing is adjourned.
So I did 8 cases in 15